Good morning, good morning, good morning, and hear ye, hear ye, hear ye. It's time to go to court for day 19 on May 20th, 2025 of the Karen Read retrial. Yesterday's cross-examination was one of just the wildest things. It was just one of the wildest things I've ever seen because the expert not only admitted to errors in the way that they approached their task, they admitted to errors in their May 8th report, which I thought was an update report. It seems like it was a pretty thorough extra report, said that they'd never ever done that before, and also purported on their company website, on LinkedIn, and on their company's CV to have a degree that is not on the CV they provided to the Commonwealth and the defense. Does it matter if they have the degree that they say they have online and not to the defense? The degree is not the point. It's the holding yourself out as if you have it elsewhere. That's the point. And then once you get there, everything is viewed with less generosity, because then you get to the issue with them asking the Commonwealth to do a bunch more work, to download a bunch more chips, or to re-download the chips, or to try to re-download the chips, to try to put the boards back into Karen Read's Lexus, because his fundamental error was he thought that they had not downloaded fully because he misinterpreted the amount of storage that they had and how big those downloads should be. So when you're relying on a tech expert who is telling you that they don't understand the storage on the chips, I think it's hard to get beyond that for many. But he's back on cross today. We'll see if this will be the only witness today, because when you're a lessee, trying to finish this cross is hard because you never know what else you might unearth. Because some of the answers, I think a lessee is just sitting there going, wait, you really just said that? And who knows what else it's going to be. So we're going to roll the intro. We're going to go to court. Hear ye, hear ye. We're going to go to court. Is court queued up? It normally is. Is it this morning? No. Why? Because my alarm decided, that I needed more sleep. And that's a whole adventure this morning. So away we go. Away we go to court, law nerds. Let's go to court. Let's roll the intro first, though.
Hey there, I'm lawyer and legal analyst Emily D. Baker, and this is your go-to destination for live court coverage. I break down the law, the strategy, and the evidence in real time, so you know what's happening. No law degree required. So join the law nerds in the chat. They're here for the facts, not and let's get to court.
All right, we're just pulling up that trial feed right now, and we're going to go to court. It looks like as I went to pull it up, court was at a sidebar. Are we shocked? Are we shocked? Are we shocked? No. Immediately to sidebar. Do we have a little Zoom room? Yeah, we do. Do we have breakfast? Yeah, we do, because Dr. B was on his way home, and he was like, do you by any chance want some Starbucks? I'm like, I was asleep. Shit. So I have coffee. Let me know where you're coming in from, what you're drinking. I have egg bites. It's all gonna be fine. It's all gonna be fine. It's gonna be fine. We're gonna stand here and go, what is happening? What is happening? We're gonna do that together. And then if I disappear suddenly, well, it's because my generator hasn't kicked in and I've lost power and or internet. Don't worry. We'll let you know in the app. Today is a spicy day as well. It's just, it happens. So don't worry. I've got a generator, but if we glitch, we'll be back. If we glitch, we'll be back. Let's go to court, shall we? Oh my God, today. Good to see all of you coming in and where you're coming in from all over the world. Good morning, good evening, good afternoon. It's all the things. Breakfast with scrambled egg. That sounds amazing. I always forget when I go to Atlanta that it's a time difference. It screws me up every time. Emily, you should get used to it now. I know. I'm from California. You can drive for like 12 hours and still be in the same state.
Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable Beverly Canoni, the Justice of the Superior Court holding in Dedham, within and for the County of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is in session. Please be seated.
Wasn't it yesterday that I mentioned that we never, ever get to see the bailiff who does did I not just say that yesterday? I don't know who's watching the channel, But whoever's watching the channel, thank you. Just thank you. Just thank you. Thank you. I wanted to see our clerk during the hearings. I feel like we've been heard. I'm here for it. Can we zoom in less on the defendant? That's it. If we're getting wishes granted, that's my only other wish. That's it. I feel like we got our wish. We had to do that again. That was magical.
Beverly Canoni, the Justice of the Superior Court holding in Dedham within and for the County of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is in session. Please be seated.
Thank you so much. That was fun.
Good morning, counsel. Good morning, Ms. Reed.
That was delightful. They're going to ask the jury same three questions. Same three questions.
Those same three questions. Were you all able to follow my instructions and refrain from discussing
I'm gonna
this case
speed
with
you
anyone
up.
Since we left yesterday? Yes.
Same questions.
Yes, nodded affirmatively.
Great.
Were you also able to follow my instructions and refrain from doing any independent research or investigation into this case? Everyone said yes and nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left yesterday? Everyone said no or shook their head.
I mean, I did, but
We have Mr. Burgess, please.
they didn't. May we have Mr. Burgess? Mr. Burgess is like, may we not? May we not? However, when I talk about the reason I do not dive into the internet on cases like this, because I want to be surprised, and I didn't realize that there had been rumblings about this before yesterday, which is why I don't go noodling around the internet. One, you never know what's going to be proven or not proven, and two, I appreciate being surprised. Hi, Dr. B.
All right, Mr. Alessi, whenever you're ready.
Thank you, Your Honor. Morning, Mr. Burgess.
Morning.
On your direct examination yesterday, your experience was brought up in questions, correct?
Yes.
On your direct examination, your
We need to figure out what that is.
certifications were brought up in questions,
Hi,
correct?
George.
Incorrect.
Can you?
There was no discussion in your direct examination about having certifications
There
in
was.
Celebrite and
You said you were
Magnet
Celebrite certified and Magnet
Forensic
certified.
Axiom. Did I mishear
No, if I misheard your question, it was
I asked about certifications. I'll repeat it, sir, in case I misspoke.
I don't
On
think
your
it's you,
direct
Alessi.
examination, your certifications were brought up in questions, correct?
yes, correct.
However, on your direct examination, no questions were asked of you at all about your supposed education, correct?
Correct.
Well, it did say in progress on the
And
CV.
you did not bring up your educational background at all
Because what does in progress
on
even
direct
mean?
examination, correct?
Correct.
A forensic examiner must prioritize accuracy, correct?
Correct.
A forensic examiner must prioritize reliability,
Accuracy is a
correct?
big part of it.
Correct.
Both are important.
Correct.
Incredibly important.
It's criminal proceeding we're in, correct?
Correct.
I was wondering
And
where he was going with that. It's
therefore,
criminal.
accuracy and reliability are especially important in a criminal case
And they're
as
important in
opposed
all
to a civil
cases.
case, correct?
I think they would be equally important in both, but yes.
But they're certainly important in a criminal case.
Correct.
And
Case you called a homicide, sir.
accuracy and reliability are especially important when seconds and minutes matter
We knew that was coming.
as they matter and as you testify to in this case, correct?
Correct.
You
We knew that was
testified
coming.
yesterday that the events on the timeline contained in your PowerPoint presentation that was displayed yesterday and presented to the jury were accurate, your words several times, down to the second, correct?
Correct. For the Lexus, yes.
For the
said that.
Lexus. You said they were accurate down to the second, correct?
Correct.
Let's take a look at your PowerPoint presentation that you discussed extensively
Am I knocking things over? Yes.
before the jury yesterday. Mr. Woe, could we please bring up
Oh boy.
slide 32 of the presentation.
Sir,
Mr.
we're going to go
Burgess
through all the things you
discussed
said.
with the jury yesterday.
All the things you said. Last night, were they running through your head,
Your
running
Honor,
through your
with
head?
your
Or did you just
permission to
sleep like a
publish?
baby? Like,
Okay?
Thank you.
I don't know how you're feeling about
Mr.
this.
Burgess,
but,
pick your screen.
like, how?
Sure.
Is this a true and accurate representation of your analysis of Miss Reed's Lexus vehicle traveling to 34 Fairview Road and the O'Keefe residence?
Yes.
According to your timeline, Miss Reed's vehicle powered on at 12:36 a.m. on January 30th, correct?
Correct.
Now, is your timeline on this slide accurate down to the second, as
To
you
the
stated
Lexus
in your
clock,
direct
that's what he's gonna
examination
say.
yesterday?
For the power on and off events, yes.
Yes. Could we go to slide 33, please, Mr. Wolk? And we're going to go through a handful of slides,
Sure.
Mr. Burgess, to just give you a heads up. Is this a true and accurate representation of your analysis of Ms. Reed leaving the O'Keefe's residence at 5:07 a.m.?
Yes, it is.
And according to your timeline, Ms. Reed powered on her vehicle at 5:07:46 a.m. on January 30th, 2022, correct?
Correct.
I see
Is
it
the
too,
time
Chat. I see
on
it too,
this
Chat.
slide
Date.
accurate
Chat, I see the
down
date too.
to the second, as you stated in your direct
Where at the end it says
examination
January
yesterday?
30th.
Yes, according to the Lexus, yes.
Down at the bottom there.
If
Way
we
down
could
in the
go,
valley.
Mr. Woke, to slide 34, please. And these are all your slides, correct, sir?
Correct.
I will say the chat clocked this quite a lot yesterday, but here's the problem. It does start with January 29th, midnight, and then into the 30th. So he has the front date and the back date wrong. Yeah, no, that makes it worse. Because he's showing these things from the 29th overnight. The actual date was the 28th overnight into the 29th, not the 29th overnight into the 30th. No, chat, all of you clocked this yesterday. It should read the 28th to the 29th. And instead, he has it scaled the 29th to the 30th. Who just said it's calendar drift? That's Sasquatch the Quatch. 10, 10. 10 out of 10. 10 out of 10. 10 out of 10. So, no, Alessi is covering this because he noticed that. Half of you guys clocked it yesterday. I was wondering if we were going to get into this. Does it say up here any dates? No. Are the dates on the video correct? Yes. But is it so many different things that are an issue? Yes. Because it was the bits versus the bytes, which is not insignificant. It's the degree, which is not insignificant. No matter how much people want to say, it's just a LinkedIn typo. It's not. I mean, people can feel that way, but that's objectively incorrect because it was multiple places and it's not a typo. And then it's the copy and pasting about whether Brennan asked for something or not. And then the answer to the copy pasting being like, it didn't seem important. Sir, it's a trial. So what's important? Maybe the date of when you say things happen. I'm just going to leave myself up here for a minute. Let's continue.
They
You
are.
prepared them?
Yes.
Is slide 34 a true and accurate representation of your analysis of Miss Reed traveling to the Dighton residence
If
at
all of you are
12:25
hearing in your head, why isn't
a.m.?
anybody ready today? Alessi is.
I'm sorry, 12:25:01 p.m.
Alessi's ready today.
12:35:01. Correct.
I'm sorry. Thank
Yes.
you. 12:35.
Everyone else.
And according to your analysis,
We'll see.
Ms. Reed powered on her vehicle to travel to Dighton at 12:35:01 p.m. on January 30th, correct?
Yes, that's correct.
And is the time on this slide accurate down to the second, as you stated in your direct examination yesterday?
Yes.
Slide 35, please, Mr. Wold.
And yes, Nightbot gets spicy with the all caps because I'm dyslexic and they're hard for me to read. Thanks, y'all. I know. It's hard to exclaim.
Is this a true and accurate representation of
restrained
your
exclaiming.
analysis of Miss Reed's vehicle being towed by the Massachusetts police vendor from her parents' residence in Dighton?
Yes, it is.
And pursuant to your timeline that you created here, Miss Reed's vehicle was powered on at 4:11 p.m. on January 30th, 2022, and
Also,
towed to
if
the
this was
Canton
the only
Police Department,
issue
correct?
with this
Correct.
expert, it might not be a huge
Is your
deal to some
timeline
jurors.
on this slide accurate down to the second, as you stated in your direct examination
But
yesterday?
it's too
Yes, this
many
timestamp
things.
is.
Slide 36, please, Mr. Wood. Is slide 36 a true and accurate representation of your analysis of Miss Reed's vehicle arriving at the Canton Police Department?
Yes, it is.
And pursuant
boy,
to
oh
the
boy, oh
timeline
boy.
you created, Miss Reed's vehicle powered off at 5:36:42 p.m. on January 30th, 2022, correct?
Objection. Objection.
I'll let him have this.
Okay.
I do not love the way the judge answers because it's so weird instead of just saying sustained and overruled, but I went on and on last trial, so I'm going to leave it. The I'll let him have this is so strange. Unless he just asked the date. And the objection was because it's the wrong date from Brennan. So I backed this up. We're going to do this again.
42 p.m. on January 30th, 2022, correct?
Objection. Objection.
The court sees it.
This.
Okay.
Is your analysis down to, is your analysis on slide 36 accurate down to the second as you stated in your direct
Just not the right
examination
date.
yesterday,
Yes, according to the Lexus, yes.
according to the Lexus?
Did the Lexus have the date wrong?
In point of fact, Mr. Burgess, none
Of those are
of the
correct.
5 timelines that we just reviewed from your presentation are accurate at all, and certainly not down to the second. Am I right
question.
or am I wrong?
You are wrong.
Are you aware?
Sir,
could go-
how did you not see the trap? It's almost worse that you didn't see the trap. The chat feels trapped.
Back to the first,
All of the chat feels like they're being cross-examined now. Who said
which
great
is
googly
slide
moogly?
32,
Yes,
and we'll look at each of them quickly.
I co-signed that great googly moogly.
Are you aware that all of the relevant events in the timeline you described in your presentation in these slides actually occurred on January 29th, 2022, not January 30th, 2022? Do you know that?
This is January 30th 2022.
That's what
January 29th, correct.
It's January 29th, 2022. And in terms of January 30th, I want to go back. I want to go
my
back and make sure it's very, very clear. In your
It's clear to all of
presentation,
us.
they actually occurred on January 29th, 2022, correct?
The night of the incident, yes.
Can I have a moment, Your Honor, please?
Yeah.
He thinks it was before midnight on the 29th. It seems to me. It seems to me he thinks it was the night of the... He thinks it was... It seems he thinks it was overnight, the 29th to the 30th, not overnight, the 28th to the 29th. Chat, no, you're right. Don't gaslight yourselves, you guys. They went to the bar the 28th, midnight over to the 29th, and then everything happened after midnight, on the 29th.
Thank you.
we're now just getting to the lack of attention to detail in the extreme, because precision matters when they're tech experts.
Mr. Burgess, once that timeline crosses into midnight, it's January 30th.
On your timeline.
Not January 29th, correct?
Correct. Yes, it is January 30th. Yes.
On your timeline.
So in actuality, these 5 timelines, as you testified to them yesterday,
incorrect.
Are not accurate down to the second, correct? Because you got the wrong date.
Well, parlance, yes, but yes, they are still accurate to the second.
Parlance.
But the date,
The date.
these 5 timelines, let's pursue this.
If you pulled the reports from the wrong day, it's not parlance. It's the date. The car probably wasn't doing shit on the 30th because it should have been parked at Canton PD. But that's not for the jury to figure out. That's for him
These
to figure out.
5 timelines are exactly 24 hours off from the time where the event actually occurred, correct?
No. So these events occurred on January 30th.
What?
If I misspoke and said the 29th. Yes.
Okay.
No. What?
You understand my point?
Yes.
He. It's too early.
Yes, I do.
Unless he's like, how do I even cross him when he doesn't realize how bad it is? How do you cross him when you don't realize how bad it is? He said, if I said the 29th, I misspoke. I backed
24
it up.
hours off from the time where the event actually occurred, correct?
No. So these events occurred on January 30th. If I misspoke and said the 29th. Yes.
Okay. You understand my point?
Yes, I do.
No, he doesn't. No, he doesn't. No, he doesn't.
The core basis of your job, your role in this case, is to reconcile time discrepancies, as you say, down to the second, correct?
Correct?
But your discussion of the timeline on each of these slides, on each of these key events, is incorrect, correct?
No, it's not incorrect.
So your discussion
The jury's got to be sitting there
of
going,
the applicable date, you're
the
saying,
29th.
as you described it yesterday and interpreted this timeline, was correct? Is that what you're saying now?
This timeline is correct.
But
yes.
my question is your discussion of it yesterday.
If I misspoke and said the 29th, then yes, I misspoke on that. Yes.
And that was your testimony yesterday, what you spoke about.
Yes.
Let's turn to a different topic. Lights up, if we could, and thank you for
my
taking that down, Mr. Wolf.
God.
Your actually to
I've never seen
mitigate
a cross go like
the
this.
inconsistencies that you analyzed yesterday between independent clocks,
It's
am I
just
correct
worse.
that your position is that forensic methodology recommends cross-referencing timestamps from multiple sources
And the
to
thing is,
identify?
all of you in the chat who are like, what? John O'Keefe and Karen Reed went out on the 28th. And then overnight to midnight, the 29th. And then the day of the 29th. The Lexus SUV was parked in Canton January 30th. The raw data would indicate or should indicate the 29th. It doesn't matter. because he's so fried on the stand that even if it is a typo on the bottom of the timeline, his testimony is overnight the 29th to the 30th, not overnight the 28th to the 29th. So it doesn't matter that the Lexus would be parked at Canton PD if his testimony is this is the 30th. Because the point is, can the jury trust what he's saying? And there have been so many errors. And the fact that the data, did it not have a date?
Identify discrepancies, and when possible.
Oh, Tanya and a number of you in the chat asked, why is he changing topics? Why give him any more room to try to fix it? The answer's in. It just becomes asked and answered at this point.
Leveraging time anchors, events that contain both system, timestamp, and an external physical event to identify and correct.
I think he's going to get into the
timing
system
discrepancies.
timestamps.
Do I have that right?
Yes, you did.
There's a big
Yesterday,
timing discrepancy.
we talked about the scientific method. You recall that, sir?
I do.
And how it's designed to prevent bias from infecting the analysis. You recall that as well?
Yes, I do.
And yesterday you agreed that experts should never selectively gather and interpret evidence to confirm a pre-existing belief while neglecting evidence that contradicts those beliefs, correct?
Correct.
And doing that is called confirmation bias, which you said you understood yesterday, right?
That is correct.
That would be improper to do that, correct?
Yes.
It would raise the specter, if not the reality, of unreliability if that occurred, correct?
It could, yes.
And it could also lead into errors in forensic analyses, correct?
Correct.
Let's take a look at your January.
I mean, I've never seen somebody
30th
confidently
report,
give
sir.
such wrong
Okay.
answers, but okay, those are
This
all
is,
right ones.
Your first
But he's very
report,
confident
your
about the
second
date.
report being the May 8th report. In your January 30th report, you did not issue any opinion or conclusion with regard to the timing of what you call the text stream event 1162-2.
I mean, I can't imagine a jury that has to pay attention to detail for their work in a way that matters sitting there being like, how is this acceptable? Like, how is this acceptable? The answer is it's not.
In your January 30th report, did you?
No, I did not.
You didn't even mention either the phrase text stream event or the phrase 1162-2 in your January 30, 2025 report, did you?
No, I did not.
But in that January 30, 2025 report, you did evaluate the variance between the Lexus infotainment system on the one hand and Mr. O'Keefe's iPhone data on the other, correct?
Correct.
In fact, in that report, the January 30th report, you compared the call logs on Miss Reed's Lexus infotainment system with the call logs on Mr. O'Keefe's iPhone
For what day?
in order to evaluate whether there was a variance,
Yeah,
correct?
What day were you
Correct.
evaluating them from Mr. O'Keefe's phone?
And do I have it correct in your report that it's the position that the timestamp call log data, specifically the recorded calls between Miss Reed and Mr. O'Keefe, along with the infotainment power event logs, were analyzed for what you called clock skew by cross-referencing them against other independent data sources, right?
No, so that would have been comparing the timestamps from Mr. O'Keefe's iPhone with the timestamps from the defendant's Lexus.
Right.
Correct. Yes.
Yes. Right. To Miss Reed's Lexus.
Correct.
And a forensic comparison of these data sets was aimed to identify timestamp discrepancies
And all those calls are from
Correct.
the 29th.
Correct.
to identify potential clock skew, correct?
Correct.
And
What about
potential
date skew?
clock drift
And date drift.
that could impact event reconstruction, correct?
Correct.
All this stated in your January 30th report, right?
Correct.
I've seen a lot of people talking about whether or not Brennan knew about the degree. I think the fact that he listed his degree on the CV that Brennan had as in progress is why Brennan wouldn't ask him about it. I'm not going to ask somebody about a degree that's in progress either. I don't know if Brennan knew the rest of it. I don't know if we'll know, but the in progress, I wouldn't ask somebody
Your Honor,
about.
may I have this marked as the next exhibit? in
And I
order?
wouldn't ask him just about an AA degree. I'd ask him about his certifications. Because tech experts can have certifications without university degrees. But I don't think that indicates to me 100% that Brennan knew. The in progress is weird language. It should have made someone look closer.
Exhibit BBB ID.
Carolyn said, I bet he has the correct dates on the January 30th report.
May I present to the witness, Your Honor?
Yes.
One would hope.
Mr. Burgess, I am presenting to you what has been marked as Exhibit BBB for identification. I'd ask you to take a look at it, sir, and then pick your head up when you've had a fair opportunity to take a look at it.
Brittany, it didn't have an in progress date on the CV. The 2008 of it all didn't come out till later. I mean,
Do you recognize
my oldest has also been in progress since 2008. So I appreciate the amount of time that since 2008 is. As I was retelling this to Travis yesterday, I'm like, and it's been in progress since 2008. My kid who was born in 2008 is like, I'm like, right. Look at you. Grown a whole human at that time. It's wild. Basically an adult at this point.
that document, sir?
I do.
May I reapproach, Your Honor?
Ashley said, what if Brennan gave him the wrong dates to review? Then
What
the
do you
text stream
recognize
data.
that document to be, sir?
If Brennan gave him the wrong dates to review, then the 3-point turn and the backup incident happened while the car was at Canton PD. That's not what I think the data shows, because we saw this data in the last trial. The thing is, what I saw in the last trial doesn't matter. What this jury is saying matters. And this jury has to be sitting there going, wasn't the car at Canton PD? Like, what? Like, how is the car backing up and making 3-point turns? And why does it matter if it's happening on the 30th?
Sure. So this is a graph that I put together that is comparing timestamps, call timestamps from the infotainment module with Mr. O'Keefe's iPhone.
And is that Exhibit BBB for identification in your January 30, 2025 report?
Yes, it is.
And did you create that chart that is depicted in Exhibit BBB for identification?
Yes, I did.
And is that a fair and accurate representation of the information that you discussed in page 33 of your January 30, 2025 report?
Yes, it is.
I offer Exhibit BBB for identification into evidence. Your Honor.
Can just put it up on the screen. We all want to
If
see.
we can introduce the whole report to put it in
Why don't I
context.
see you at sidebar instead of before?
They're going to go to sidebar about whether part of the report or the whole report goes in. Numbers said, did Brennan not realize the dates were wrong? If Brennan had realized the dates were wrong in a typo and could say that that is a Scrivener's error, then there is generally room for the expert to correct their report and say, on this, I realized this and I am correcting it. No one noticed. Well, not no one. Y'all noticed yesterday and Alessi noticed. But how was this not noticed by anyone on the prosecution team? I don't know. Because we saw it yesterday, and there were times yesterday when Brennan was saying December. I'm like, Brennan's misspeaking. Brennan also came into this case and was working at zoom speed. So should he have caught it? Yeah. Somebody on the prosecution team should have. And you should have more than one pair of eyes to review something.
Yes.
I can't believe they don't have a law clerk that would have caught this.
Your Honor, at this time, I offer Exhibit BBB into evidence.
Okay.
And it seems like the objection was denied.
189.
And just that page of the report is coming in. But again, one error that is a genuine
Represented to the witness, Your
typo
Honor.
or
Thank
whatever can
Mr.
generally be
Burgess, I
overcome.
have represented to you what is now Exhibit 189 in
There's a lot.
evidence.
There's a lot here.
Ask you to, once again, take a look at it, and if you need further time, please take it, sir, and then pick up your head when you've had a fair opportunity to look at that document.
Okay.
Despite claiming the purpose in your January 30 report of, quote, identifying timestamp discrepancies, potential clock skew, and clock drift, you did not compare the time of the three-point turn between the infotainment system in the Lexus
Oh, that doesn't surprise me.
SUV and Mr. O'Keefe's phone, did you?
Not at
doesn't
that time,
surprise
no.
me. Yeah.
Instead,
That I think he actually explained.
Instead, you identified the potential variance by analyzing various calls on the infotainment system of the Lexus versus Mr. O'Keefe's phone, correct?
Correct.
This data in that exhibit.
Why is that a problem? Because the way that he was dealing with the time variance in his first report contradicts what he said in testimony about his second report. He said you need two of the exact same events to correlate the variance. And that's not what he was doing in the first event.
Captures a precise moment in time that is easily compared between the two devices, correct?
Correct, it does.
Mr. Wolk, Your Honor, may Mr. Wolk please publish this exhibit?
Okay.
So this data, just to reestablish, captures a precise moment in time that's easily compared between the two devices, correct?
Correct.
Now, according to your
Well, look at that. Just about 2 seconds off on some of those, less on some, and then a lot more on one. So those are the infotainment timestamps from Karen Reed's vehicle and the timestamps from John O'Keefe's calls. That's exactly opposite of how he said that those would happen.
your own table, there are potential offsets of reading in the far right-hand column. 2 seconds.
A real good exhibit for the defense.
1 second, 2 seconds, 1 second, 8 seconds, 16 seconds, and 21 seconds, correct?
Correct.
And yet, you failed to apply this variance to the infotainment time on the Lexus associated with the text stream event 1162.2, correct?
Correct. May I explain?
No.
I will proceed along. I'm sure if Mr. Brennan has questions and wants you to explain,
He'll ask.
he may choose to do that. This is simple arithmetic, is it not? It's
I mean,
either
simple
an
for you,
addition
Alessi.
or a subtraction, the offset, correct?
Correct.
And yet, in your initial
I mean,
report
I think Alessi
on
invented
January
calculus.
30th, 2025, you did not take that final analytical step, did you?
No, because these clock variances do not apply to that time frame.
But you didn't take,
What?
you know what analytical step I'm talking about, correct?
No, I don't. I don't
All right.
believe so.
Are you trying to tell me? No, one crazy cat. I'm not calling Alessi old. I'm calling Alessi brilliant. Alessi speaks and new words are born into existence. Alessi is the international man of mystery. Yesterday, a lot of you sent me a variety of Alessi memes, including one that said Alessi is the reason that Waldo is hiding. They were very funny. That kind of Chuck Norris Alessi yesterday. But what I find so confounding about this answer is he says that the time variance doesn't apply. This time variance doesn't apply. So are we picky, guessy, choosing which time variance? What do you mean that that time variance doesn't apply?
We'll come back to it. I want to go focus on your opinion. What you did do, as I understand it, in your January 30th report. So, in your opinion, we can leave that up for a moment, please, because I want to see if we need to show the contrast. With your Honor's permission, can we leave it up just a little bit longer?
Yes.
Thank you. In opinion number
Ladies and gentlemen, just look at it a bit more.
5, and please feel free to look at your January 30th report.
Sure.
You indicated only this. The difference between the Lexus Infotainment and Mr. O'Keefe's cell phone ranged between 8 seconds and 16 to 21 seconds during the period between 5:21:36 a.m. and 5:30:31 a.m. on January 29, 2022. Do I have that correct?
Yes, between 5:21 and 5:30 a.m.
Yes. Now what I'd like to do is, and we can take that down. Thank you, Mr. Wope.
So
Let's
he
talk about what
reported-
information.
He reported the time variance between 8 seconds and 16 to 21 seconds. Because after 5 a.m., apparently everything just changes. That's what his first report said. George, are you stuck? All right, hold on. My cat is catting.
learned after you issued your January 30,
Are you better now?
2025
All right.
report. Or at the time of that report, you received and reviewed a copy of a portion of your
Unbelievable.
colleague's slide presentation and
unbelievable.
report at Aperture, Dr. Judson Welcher, correct?
Isn't Welcher one of
From
your
a
bosses?
presentation by Mr. DiSogra. Yes.
Well,
Correct.
I understand you want to add Mr. DiSogra. My question is,
Sustained.
okay, yes, Your Honor, thank you. I'm focusing on what would you like to call it? Do you call it a slide presentation you prefer, Dr. Welcher?
Sure, we can.
I want
we
to
can
use
call it-
whatever parlance you're comfortable with.
Yeah, slide's fine, yeah.
Slide. So the slide presentation of Dr. Welcher that he submitted the same day you submitted your report on January 30, 2025. And in that,
Looks like it.
he analyzed the timing of the 11:62:2.
The judge sustained the objection to the comment. I understand you want to put Mr. DiSogra in this. Alessi makes very, very few of those comments. It's not a question. The lawyers are not supposed to be commenting. That's what she was sustaining. If an objection is made, she's going to sustain them. So. It is a
what he
proper
calls an
objection and is
infotainment
proper
event,
to be
you call a
sustained.
text stream event, correct?
Alessi is the least.
Well, could I see the slide we're talking about to clarify?
Alessi has it the least.
Absolutely, absolutely. Could we publish what is in evidence? It was 188.
I generally don't do
And I'm
meme
also
reaction videos because so many of them can be mean-spirited.
At your request, I want to give you
Sure.
that, if we have
And it is a murder
188,
case.
we'll just give them the actual marked exhibit.
Marveling at Alessi's intelligence, I'm all here for, because
You know what we'll do?
This is
We'll
not the
use
typical
slide.
work
If you
Alessi does.
need an exhibit, we'll pull the exhibit and move it along. Please publish, Mr. Wolf.
and I appreciate it. I also did post on LinkedIn yesterday for the first time in like 4 years. I had to update things on LinkedIn. Did everyone go
Now,
update their
if we could
LinkedIn
enlarge
yesterday?
the text.
I don't know when the last time I looked at my LinkedIn is. Again, if the error was just LinkedIn, I don't think this would be as big of a deal. The company website, you guys let me know what you think. The company website and the company CV is a bigger deal to me than LinkedIn. If it was just LinkedIn, it would be like, oh yeah, I totally forgot. But the company website and the company CV, in addition to LinkedIn, that becomes a big thing. So yeah, I went and I was like, oh crap, I need to update a bunch of stuff on the LinkedIn. I had to do a password reset, the whole 9 yards. That one thing for an expert would come up, but I don't think it would be the end. Though experts take this shit seriously and they know that they get paid a ton of money and people are looking at these things. The company website I find and the company CV combined with the LinkedIn that he wrote, it's the combination together that looks intentional to me.
We don't need the map, so make that as large as you can, please, Mr. Wolf, in the relevant portions.
So those are the things that to me
All right.
stand out.
You're aware that according to Dr. Welcher's analysis, as depicted in this slide in evidence, the 1162-2, what he calls an infotainment trigger that you call a text stream event, right?
Correct.
The 1162-2 text stream event occurred at 12:31:38 a.m. on January 29, 2022, correct?
Correct.
And that's when it began, right?
That's when the trigger threshold was met. Yes.
That's when the trigger threshold was met.
correct.
You
This matters
we can take that
because
down now, Mr. Woke.
of what was going on John O'Keefe's phone. And I think that there probably
You
is a time
also
variance there.
testified yesterday that
I understand the time variance between the clocks. It's the Commonwealth's job to prove it beyond a reasonable doubt. It's the Commonwealth's job to prove it beyond a reasonable doubt. So even if the information is right, the jury has to believe it and believe the person who delivers that information. So even assuming it's correct, the jury has to believe this expert, because if the trigger event, which the Commonwealth's going to argue is a collision with John O'Keefe, is at 12:31:38, back to the Post-its, how is John O'Keefe locking his device at 12:32:09? And if there is some variance in those two times, then the Commonwealth has to explain it.
you reviewed
That's their job.
Mr. Whiffin, Mr. Ian Whiffin's January report, which established a timeline of the last interactive events on Mr. O'Keefe's phone, correct?
Correct.
Your Honor, could we please publish Exhibit 39, which is in evidence?
Oh, we don't need my Post-its. They're just going to pull it up for the jury.
And we could go to slide 82 and have 83 available.
And yes,
if we can enlarge.
someone would have had to go through and gotten a list of what those exhibit numbers are in evidence and pull them up for Alessi last night so that he could do this smoothly. And he's doing it very
applicable
smoothly.
sections. And what I'm going to ask you, Mr. Burgess, is to see whether these events are consistent with your memory of what the applicable
I mean, I like
events
my Post-it,
are.
but this works well for the jury.
Do you see the column biometric device unlock with Face ID event at 12:32:04 a.m.
Yes.
Now that's after the 12:31:38 a.m. 11:62:2 text stream event that's in Mr. Welcher's slide, correct, that we just saw?
Correct. The unadjusted Lexus clock. Yes. Timestamp. Yes.
So, but I'm going to repeat the question. The 12:32:04 a.m. device unlock with Face ID event is after the 12:31:38 and 12:31:43 11:62:2 text stream event that is stated in Dr. Welcher's report, correct?
Correct.
Now, do you see the lock event which occurred at 12:32:09?
Yes, I do.
That is also after the 12:31:38 to 12:31:43 text stream event, correct?
Yes, the unadjusted time.
That 12:32:09 a.m. lock event is after the 12:31:38 to 12:31:43 range that is stated in Dr. Welcher's report, correct?
Correct. From the Lexus clock.
So, if we could go back, and we're going to toggle back with Your Honor's permission between these two slides for the next couple questions. If we can go back to and enlarge Dr. Welcher's slide.
Jill, this is fair. Jill in the chat said, I don't even know what LinkedIn is. Is it an employment agency? LinkedIn is like Facebook, but for jobs. So it connects you to people that you might know. It has generally your resume or past jobs and educational experience on it. You can publish articles. I think you can post videos, but it connects you by connections, and companies can post jobs that they have. So it's like Facebook, but more specifically for work and employment. So it's kind of a social network, but also it's very employment focused and very focused on where people work and what they do. So job seekers are frequently using LinkedIn because companies will post jobs there. By the way, Aperture has openings available for forensic analysts, but I think that was before this trial started. So it is a whole jobs tool. But again, I started working in my career job pre-LinkedIn. So I have never used it in that way, but it is an indispensable part of a lot of employment these days. So it's like Facebook, but professional. So.
That 12:31,
So it's a fair question.
38 to 12:31:43 time period is what your colleague, the licensed
Your boss.
engineer, Dr. Welcher, chose and his slide analysis as the last user interaction, according to him, on John O'Keefe's phone, correct? That's what he chose.
Yes, the 12:32:09. Yes.
Now, if we could go back to and zero in, please.
12:32:09 is the final
Now,
lock event.
but even Mr. Whiffin's report establishes additional activity on Mr. O'Keefe's phone after
the jury can see that
event chosen
as
by
plain as
Dr.
day.
Welcher,
Yep.
correct?
The point is being
Correct.
made well.
And, in fact, Mr. Whiffin identifies a, quote, lock event that occurred 26 seconds after the 1162-2 text stream event identified by Dr. Welcher at 12:31:38 to 12:31:43, correct?
Look, y'all, I understand yesterday how he explained the variance. I think he explained it well prior to cross. But when you math at me that his variance went from 21 seconds to 21 to 26, which just by the hair of its chinny chin chin encompasses this, it starts to look more sus. It starts to look more sus. So it was 8 seconds up to 21 seconds. And then all of a sudden it was 21 seconds to 26. 26, the exact amount of time between Welcher's report and Whiffin's report. Exactly the same amount. Exactly the same amount. Not 25, not 27, not 28. That 26 window there.
Correct, using the unadjusted clock.
18 to 19 to 29. Fair enough.
I
It
would
didn't go
like-
exactly to 26.
Does Dr. Welcher at all use the words
Thank you,
unadjusted
Madeline.
clock in his slide, sir?
No, he does
Okay, what I'd like to
3
do
seconds
is
over.
ask you a question about whether, in fact,
No, fair.
Mr.
Up to
Whiffin
29.
identified...
No fair. Up to 29 seconds. 21 to 29. 3 seconds over. That 26-second difference. Fair. That was me.
a lock
Emily, it's
event
like you're
that
tired.
occurred 26 seconds after the 1162-2 text stream event at 12:31:38 to 12:43, as stated in your colleague's report, Dr. Welcher, the slide presentation. Is that correct?
Yes, that's correct.
Do you know whether a lock event on an iPhone requires human interaction?
Typically, yes, it would.
Is it just typically?
It says lock event with the phone. Lock event with the phone. I'm going to let him roll for a minute. But JP in the chat and a number of you have asked, why does any of this matter? I'm going to just give you a real quick overview. The prosecution is going to argue that the 1162-2 vehicle trigger is the backing up vehicle event from Karen Reed's car. They're gonna argue that backing up event is when John O'Keefe was injured. I suspect that their medical testimony, either the prosecution's or the defense's, will indicate that the injury to John O'Keefe's head is the type of injury where after that injury, volitional movement would not be possible. You would be unconscious, you would be unable to manipulate your phone, and the lock button event requires the lock button on your phone to be pushed. So if John O'Keefe is struck by the Lexus when their timeline says at 12:31:38, then how is John O'Keefe on his phone? And these are the things that are in Whiffin's report after 12:31:38. The phone comes out of a pocket. And this is all assuming John O'Keefe has John O'Keefe's phone in his hand because it's found under him. The phone comes out of the pocket at 12:31:52. That is after 12:31:38. If he is struck by a vehicle and incapacitated in the way the government says, he couldn't pull his phone out of his pocket. Maybe it fell out. However, then the phone registers a Face ID unlock at 12:32:04. Then the phone registers that a text message is read because the app is initiated and a text is read that says pull behind me at 12:32:06. And then at 12:32:09, the phone is locked. So if there's a time variance between John O'Keefe's phone and the Lexus SUV that encompasses that time period, the government's argument is the clock in the Lexus and the clock on John O'Keefe's iPhone aren't exactly synced. So the things happening on John O'Keefe's iPhone happened before he's struck by the SUV. But the time on the SUV indicates that the times are off. Now, there's still an argument that the entire fucking date is off. We'll see if that gets cleared. But that's why it gets down to, if John O'Keefe was struck by the car and the injury to the back of his head happened how the government says, he wouldn't have been able to use his phone. So the defense is going to argue, right, he wasn't struck by the car and incapacitated then, because he wasn't struck by a car. That's their argument. So that's why the timing of this matters much. Some of it's not going to become readily apparent to the jury until we get to that next medical testimony. And until some of this, the jury might not go, oh, wow, when it gets connected in closing. But you can't argue something in closing that's not in evidence. And so this all has to be in evidence for them to tie it together.
Or does it?
Well, it does. And in this case specifically, I believe it was via the lock button.
Correct. But this specific instance, the lock, it requires somebody, a human being, to actually press a button on the side, correct?
Unless it's auto locking, yes, it requires a button press.
says
Yes.
Do you
lock
have
button.
any reason to believe
Whiffin's
that the
report,
iPhone of Mr. O'Keefe had an auto-locking?
Whiffin's report specifically says lock button. Whiffin's report expressly and specifically says lock button.
Function on it, sir?
No, as I said, he used the lock button.
Right.
It specifically says
If we
lock
can
button.
enlarge that, do you see the end of health event 36 steps that we talked yesterday that was covering a distance of over 84 feet? Do you see that occurring at 12:32:16 a.m.?
I don't believe we talked about that yesterday, but yes, I do see
Do
that.
you see it?
I do, yes.
And that's also after the 12:31:38 to 12:31:43 text stream event identified by.
The experts' reports say that everything happened on January 30th, not the 29th. The Lauren, when asking, what did I miss? There's a lot more, but that's the best summary of the
Your
shocking-
colleague, the licensed engineer, Dr. Welcher, in his slide, correct?
Correct.
Now, finally, do you see the entry pocket state detected at 12:33:14 a.m.? You see that, sir?
Objection.
Sustained.
Do you know what a pocket state is, sir?
I do know what a pocket state is.
Do you know when the
Oh boy.
pocket states occurred on the iPhone of John O'Keefe pursuant to your analysis of his phone?
I do not.
Oh boy.
You didn't analyze pocket state detections on Mr. O'Keefe's phone?
No, I did not personally.
Do you believe pocket state detected data? Well, let me just go back and confirm. So you didn't analyze with any source pocket state detection information with regard to Mr. O'Keefe's phone. Is that correct?
That's correct.
So let's go back and summarize for each of the ones you did look at and analyze that you just testified. Every single one of those that we just discussed, those user interaction events, occurred after Dr. Welcher claims a collision occurred as represented in a text stream event of 11:62:2 at 12:31:38 to 12:31:43, correct?
Objection.
Do you understand?
The issue was the word
Let's, if we
collision.
can go back, please, to Dr. Welcher's slide. Highlight the text again, please, Mr. Wolf.
The thing that Brennan seems to fail to take into account with some of those objections is that when
Do
he
you
makes a
understand that
when he makes a lessee break down his thought process, it tends to get worse for the witness. So if you're going to object to the word collision, which is in fact what you're going to argue later, it's what you're going to argue later. Why are we objecting to it? So lessee's like, fine, we'll just go step by step. Ooh, baby.
Dr. Welcher is correlating the Infotainment Trigger 1162-2 with an alleged collision? Do you understand that?
Objection.
Let's come to sidebar, please.
Is the Commonwealth not going to argue that that's what happened? Has the collision been rehomed? We're going to zoom past this sidebar because I'm ready to hear the rest of this. And that's a longer sidebar than I anticipated. That's a pretty decently long sidebar.
Thanks for your...
All right.
If we could go now, Mr. Woke, back to the slide from Dr. Welcher's
This witness did
slide
not use
presentation.
collision in his initial report, and I think he used incident in his second report.
And if you could re-enlarge the applicable section that we've had up before.
And then trigger event.
Thanks for your patience,
Sure.
Mr. Burgess.
Mr. Burgess is like, I got nothing to do but sit
You
here.
had
At least my company still gets paid for me being on the stand this day. I still get paid for being here. So, who knows what's going to happen after I leave court, but for now we're here.
have reviewed this slide and this specific data in this slide previously, correct?
Correct.
And I just want to, Mr. Woke, just go back to the slide so we're clear on what this is. So this slide here is what you're speaking about, right?
Correct.
And you've reviewed this slide prior to your testimony in this court, correct?
Correct.
And did you...
That's key, because
and
if he hadn't, he can't be questioned about it.
this slide as part of your analyses that you have performed and testified about, correct?
Yes, I have.
So, now, Mr. Burgess, I'd like to ask you a question. Every single one of the user interaction events that we talked about, steps, lock, etc., occurred after Dr. Welcher's, what he calls an infotainment event, which you call a tech stream event, in the range of 12:31:38 to 12:31:43, correct?
I would agree that yes.
So
with-
the answer is yes?
With the caveat.
I'm sorry, I didn't know
Sorry.
you hadn't finished.
Sure.
Please finish your answer.
Yes, with the caveat that user interaction only applies to the device lock, steps, and the pocket state are not duplicative of user interaction per se.
Duplicative?
Let's just assume.
Do you mean indicative? I don't think duplicative is what you mean there. And I normally don't play word games with witnesses and give them the benefit of the doubt, but I think you mean indicative, because steps can happen on your phone without you interacting with it. Ask anyone who plays Pokemon Go and has tried to hatch eggs while they are doing other things. Phones can register steps and other things, but yes, the phone lock and the Face ID is indicative of user interaction with the phone. For all of you that said duplicitous, it was in my brain as well.
Assume that is the case. Let's then just focus on what you consider to be a user interaction, which is device lock, correct?
Correct.
And
I know that's just his
the
parlance.
device lock event that you agree is a user interaction. We could go back to that just so we have clarity.
And why is the defense doing all of this?
The
Doubt.
lock event that you agree
If the jury doubts when this happened, then where does that leave you?
is a user interaction occurred at 12:32:09 according to Mr. O'Keefe's phone, correct?
Correct.
In that 12:32:09 time period, we could go back to Dr. Welcher, it is after the end of the text stream event dubbed as 11:62:2, correct?
Correct. According to.
And that's
Sorry.
26 seconds. I didn't finish my question. I'm sorry, Your Honor.
So go ahead, finish your question. Don't answer, Mr. Burgess, until the complete question.
But I thought he was done.
In
Your Honor.
that-
Oh, he's not even close to done,
That
sir.
event lock,
You maybe, him no.
even according to Dr. Welcher's own words in his own slide, occurs 20 seconds after the end of the text stream event 11:62:2, correct?
Of the unadjusted clock, yes.
May I have a moment, Your Honor?
Sir,
Yes, do you want the lights on, Mr. Leslie?
unadjusted is not a cure-all. Much like what, if anything, unadjusted is not a cure-all.
And so to
And if
to
I'm the
repeat
defense-
my
If I'm the defense, I love that word, adjusted. I love that they're using it. I think an expert like this should be saying correlated, because what he's trying to do is correlate the clocks. I don't even know if he knows that at this point. But if I'm the defense, why do I love the word unadjusted and adjusted? Because when you're arguing to the jury, the Commonwealth just wants to adjust the times. They just want to adjust the times so it all fits. But they don't get to just adjust the time. It either is or it isn't, and the jury gets to decide the fact. When it's correlated, it's easier, I think, for the Commonwealth to argue and harder for the defense to point out that they're just making shit up. Adjusted is like, oh, well, it didn't fit, so they went back and adjusted it. They're the adjusted clocks. It leaves a different impression at argument, and it's a better word to argue. Correlated is different.
to alter it, hopefully make it a little clearer. Sure. So according to Dr. Welcher, the licensed engineers, your colleague at Aperture, his slide that he has here, the
That was me sighing, by the way. That
last
wasn't the court this
O'Keefe
time.
cell phone event, the lock, occurred within approximately 26 seconds after the end of the text stream event dubbed 11:62:2. That's what's stated there, correct?
Correct, according to the unadjusted clock.
You keep adding according to the unadjusted clock, but do the words according to the unadjusted clock appear anywhere in that slide?
It's not a cure-all.
No, they do not.
Not a cure-all.
We can take that down. And
All of
with
you in the
court's
chat that said
permission,
his
turn the
employment
lights back
status
on,
might be
please.
adjusted. It might be. And I saw a lot of questions
Yesterday,
about...
you stated that you reviewed a presentation.
I saw a lot of questions about whether this will affect other cases. I'm going to talk about that when we get a break. It's a bit of a longer conversation. So I see those questions. We'll get to them.
By another expert, Mr. DiSogra, who
Oh, boy. Into the defense
reviewed the
expert.
findings of your January 30th report. Do you recall that, sir?
Fred left
Yes, I do.
glitter on my
In fact,
microphone.
in your May 8, 2025 report, your second report, your first being the January 30th report, you only cite 2 new sources of data that you reviewed before making your conclusions, correct?
Correct.
And those are? And those are?
We have a moment, Your Honor.
Yes.
For all of you in the chat that said, oh my God, I have such a crush on Alessi. Yes, the Lawnards stand competence above all else.
Yes.
Like competence first, and then entertainment second, and then vibes. But yeah, competence. Competence is helpful. Unless he's showing something to the Commonwealth, we can hear him talking to the prosecutor.
I think it needs to be heard about on this as well.
All right.
You can object all you want. You can object all you want, Brennan. But even the three-piece suit isn't going to make today any better. I don't know if he's actually wearing the three-piece suit today. I didn't notice. But there's not much Brennan can do with this. Is he going to try? Sure, he's going to try. But the court, Brennan has objected, and the court has given pretty wide latitude in not allowing Brennan to say, well, if this one page comes in, the whole report comes in. She keeps saying no. And has given Alessi the latitude that was promised. And Alessi has been allowed to bring in pages of different reports that this witness has relied on.
May I proceed, Your Honor, and
into
approach the
evidence
witness?
that
Yes.
wouldn't
Thank you.
necessarily come into evidence otherwise. Reports are generally not evidence.
Sure.
The testimony
I'm going
is.
to present to you 2 documents, each of which is marked for identification.
I just imagine the court going, this is purely my fiction. I wonder how this is going to go. Because she knows what just happened at sidebar. Laura, why does Karen Reed go to the sidebars? Because she has a right to hear what's said at sidebar, and this courtroom is not set up so she can hear it from counsel table. The courtroom is so small that if her lawyers come back to counsel table and try to tell her what happened at sidebar, there's an entire gallery of people sitting right there with her. So the defense asked to allow her to have headphones so she could hear the sidebar. And the court said, no, she can come to sidebar. So she has the right to hear and participate in what's going on. And the only way she can do that in this court is to go up to sidebar. So she does.
The first is Exhibit CCC for identification.
We see
That
CC what you're doing here, Mr.
one
Alessi.
Slide.
We love that
out
you're just
of
taking your time.
What is marked as Exhibit DDD for identification. And Exhibit CCC is 1 page out of Exhibit DDD for identification. And I'd ask you, sir, to take a look at
If you're going to ask why are
those
there
documents and reference either one.
why are they on DDD? Because they already went through the
And
entire alphabet.
Please
They're on their third round through the alphabet for the marked exhibits.
let me know.
When exhibits are marked for identification, they are given a specific number. Not all exhibits come in to evidence. But if a case goes up on appeal, the appellate court needs to know what the person's looking at on the stand, so they need some way to identify it. So they start at A and go through the alphabet and then start again. So the exhibits marked for identification are going through alphabet. The exhibits marked for evidence are numerical. So if the next exhibit, CCC, gets marked as an exhibit, it'll be, I think we're on 190. So it'll be 190. But that's why. It's for the appellate record, because not everything marked for identification, for the record, comes into evidence. So for all of you starting to sing do, da, 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 yeah, yes.
Sir, when you've had a fair opportunity to review those documents, so I can proceed with questions about them.
Sure. Okay.
Sir, can you please
I mean, his
read
affect
the
has remained
exhibit
unbothered.
designation on the entire slide presentation?
On DDD.
Pardon me?
On exhibit DDD.
And that's triple D as in David?
Correct.
It's
So
when you need the D, but like you really need it. I couldn't help myself.
In exhibit D,
Either that or it's for
D,
danger, 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 danger.
Is that the March 5, 2005 PowerPoint presentation
Yeah,
of
today it's
Mr.
me.
DiSogra that you spoke about extensively yesterday?
Yes, it is.
And sir, before you came to court yesterday, did you review and consider the exhibit DDD for identification?
Yes, I did.
And as a matter of fact, you spent considerable time with regard to exhibit DDD before you came to court yesterday.
Correct.
And in addition,
I'm starting to just hear the
isn't
funeral
it the
march. It's
case
like,
that
dun, dun. No, wait, Emily, that's the
your
Imperial
testimony
March that you're
yesterday
hearing.
is that Exhibit DDD, the March 5, 2025 slide presentation of Mr. DiSogra, was part of the reason why you created your May 8th, 2025 report, correct?
Correct.
May I approach, Your Honor?
Yes.
This May 8th report is so much.
Your Honor, I offer Exhibit Exhibit CCC into evidence, and do not
Yeah,
offer Exhibit DDD.
We missed
at this
CNC
time.
Music Factory at some
The
point.
witness just spoke of DDD, so why don't you have him just say what CCC is before we put it in?
Yes,
will do so,
please,
Your
please,
Honor. Thank you.
please.
Mr. Burgess,
I will
is
say,
Exhibit CCC a slide page out of Exhibit DDD?
Yes, it is.
this witness has not gotten defensive.
Thank you for that, Your Honor. I now
In the
offer
way so many
Exhibit
witnesses do when they're being
CCC
challenged.
for identification into evidence.
Yes.
Thank you.
We see so many
I also hand
witnesses
back to Madam Court Reporter Exhibit
get offended and get
DDD for
challenged
identification.
when they are being challenged. And normally they're being challenged over sometimes kind of nitpicky little things because that's what you do. These are very, very, very big things. And and he is just like, yep.
And sir, do you have before you read the three letters, please, just so we're on the same page in that exhibit?
Jim, we need this.
That the one that's in
In evidence.
the one page?
Yes. Exhibit 190.
And that's the entitled All Possible Combinations?
Yes, it is.
So we'll refer to that as Exhibit 190, okay?
Okay.
Have you had a fair opportunity to refresh yourself on that one-page chart?
Yes, I have.
Your Honor, may I please publish Exhibit 190?
Yes.
And if we could enlarge it without, I think, Mr. Wolk, we can obscure for the moment the all positive on the right and come back to that as needed. Thank you. Now, Mr. DiSogra.
This is a slide from the defense expert's report, and I still am unclear on the defense expert's exact name because, well, we kept hearing Mr. Disorder. And so in my brain, that's how I still hear DiSogra. I'm not sure. Defense expert. Mr. Disorder, the defense expert.
Who is an expert for the defense, took the data points you evaluated in your January 30, 2025 report and simply performed the last step in your analysis that I was referring to in previous, correct?
Correct. For a lot of data points that do not apply for the time of the accident.
I understand you may have a view as to whether they apply or not. I'm just trying to.
For a lot of data points that do not apply to the incident, if there is, in fact, a clock variance, shouldn't the variances fall within the same window? And I don't know if something cannot apply more than you saying everything happened the day after it fucking happened. Like a whole 24-hour window wrong. The confidence of, it's a bunch of shit that doesn't even apply to the report. Okay. Sure, buddy.
Understand
Objection.
what you understood he did.
Again,
I'll repeat. Yeah, yes,
so
Your
we'll
Honor.
strike the comment part and just
I'll
question,
repeat
please.
and just go to the question.
I mean, normally attorneys getting overly dramatic in
So
court
you understand
is something
that
that's going
Mr.
to bring my
DiSorga-
ire, and I will tell the attorneys they're being too much. unless he's not doing too much. His comments are so narrow. And he's communicating with the witness. He's not just snarking. He's like, I understand you're saying that, but my question is.
Took the data points that you evaluated in your January 30, 2025 report and simply performed the last step in your analysis, correct?
In my report, in addition to Dr. Welcher's.
Right, in addition to Dr.
Correct.
Now, what I want to do is just elucidate the columns and their meaning. So, the column on the right equals the number of seconds, and it's the far right, the number of seconds between the end of the 1162.2 text stream event that in the slide of Dr. Welcher is ending at 12:31:43 and the lock event on Mr. O'Keefe's phone that's occurred at 12:32:09, correct?
Correct.
And that's your understanding of that column as well.
Correct.
Now, even taking your colleague Dr. Welcher's assumption that the last user interaction on Mr. O'Keefe's phone occurred at 12:32:09 a.m. on January 29, 2022, is Mr. DiSogra demonstrating in this chart that by using the clock variance that you calculated in your January 30 report, there are no circumstances where the trigger event of 1162.2 occurs before the lock event on Mr. O'Keefe's phone?
Objection.
After.
Sustained. There's one part of your question that needs to
Okay.
be omitted.
In terms of
He's got to ask it more carefully.
this chart, do you agree that the methodology and application of it of Mr. DiSogra is that Mr. DiSogra took the last user interaction data point of Dr. Welcher in his slide of 12:32:09 and applied the clock variance that you calculated in your January 30th report? Do you agree that that's what Mr. DiSogra did?
No, I do not.
What do you believe
was me,
Mr.
sorry.
DiSogra did here?
Well, so the math is correct. So when he's trying to adjust clock variances between the two devices, that math is correct, but he's applying incorrect adjustments.
I understand, but what I'm trying to get at is just what you understood Mr. DiSogra did in this chart.
Correct. I did understand, yes, what he
Okay.
was trying to do.
And so do you agree, based upon what Mr. DiSogra did as represented in this chart, there are no circumstances where the 1162.2 text stream event occurs? Well, let me have you describe what you believe Mr. DiSogra is doing with regard to comparing, based upon this chart, the 1162.2 text stream event of Dr. Welcher with the lock event on Mr. O'Keefe's phone.
Sure. So he's trying to adjust the clock from the Lexus to the Mr. O'Keefe's iPhone clock, but he does that inaccurately.
Well, I understand you have
Okay, sir.
I understand your comment. But my question, sir, is this. What do you understand Mr. DiSogra is doing with regard to this chart? Do you understand what he is doing in this chart?
Correct.
I'd just like you to state what it is you understand he is doing.
Sure. So he's trying to adjust timestamps.
He's trying to adjust timestamps.
Like you.
In adjusting timestamps, do you agree that Mr. DiSogra makes the point with this chart that there are no circumstances where the 1162 trigger occurs before the lock event on John O'Keefe's phone.
Objection.
Sustained.
Can I have a moment, Your Honor?
Sure.
He's going to need to answer that in a different way. But Emily, what have you guys been working on today? Well, the soundboard. We're working on the soundboard because we added.
Believe.
I thought a Mr. Alessi was going to take a minute.
Mention it all. Mention it all.
We needed it today. Also, if you notice that my lighting is changing, it's not me, it's the sky.
Do you understand
It's
that
the
what
sky.
Mr. DiSogra
It's the
is
sky.
doing in this chart is he is showing numerically and arithmetically that there are no circumstances where the text stream event
Turn my lights up.
1162-2 occurs after the lock event on Mr. O'Keefe's phone.
Objection.
I'm going to allow it in that.
Yeah, it's a proper question.
Yes, I understand he's trying to show that.
Right. Well,
and you're trying to show shit
he
that
did
happened
more
on the
than
30th.
try. Isn't that what he, by his
There is no
math,
try,
that he
only
is
do at this
demonstrating?
point.
Objection.
I'm going to allow that.
Yes, but it is inaccurate.
I understand, but that's, again, the question.
Sir, you have sat on this stand since yesterday. You commissioned a bunch of work, which I wonder if whoever is paying you for from the government is going to look at. You commissioned a bunch of work based on a misunderstanding. You have a misunderstanding with whether or not putting a year after a degree title indicates that you received that degree. You have been shifting the timeline for the Commonwealth because you say that their expert doesn't understand. When we are talking about inaccuracies, I don't even think that you've realized that on your timeline, you have the entire date wrong. Sir. And I have to just this here's where I'm at. Okay, Runes. No, this was not the comment I was trying to pull up. Yes, I agree. Somebody was like, call him Dylan Efron because he is misunderstanding. And I tried to grab it and then the chat jumped. Both Bob the drag queen and Dylan Efron deserve better than this witness. That's what I was trying to pull up. Because this is not a misunderstanding. These are not misunderstandings. Some of them are. Some of them, I think, are a skill issue.
Is that what he demonstrates using this chart?
Yes.
And what he demonstrates is that Mr. DiSorga demonstrates that there are no circumstances where the 1162-2 trigger event occurs after the lock event on Mr. O'Keefe's phone, correct?
Yes, inaccurately.
So I'm asking what Mr. DiSogra demonstrates in this report, and isn't it correct that Mr. DiSogra, using this math, Mr. DiSogra demonstrates and concludes that there are no circumstances where the 1162-2 text stream event occurs after the lock event on Mr. O'Keefe's phone?
Objection.
I'm going to allow that. Does that demonstrate that?
Yes, inaccurately.
Okay.
Saying inaccurately doesn't mean it's inaccurate, though.
So let's.
I'm going to move on, Your Honor. I'm going to move on.
The point's been made. The feed is choppy. And I also saw a notes from the mod team. I'm trying to focus on court and weather. I have seen that the website has a note on his CV. I don't know how long that's been there. We don't have that information in trial. If that information comes into trial, we'll talk about it. But it might not be related to this trial because CVs for designation are the ones that go to court. So again, I try not to get into stuff going on outside of court because I still like to be surprised about what's happening in court. So I don't go looking for the tea about witnesses before court because I want to see it as it unfolds. I'm not telling you not to. I'm just asking you not to tell me. We'll see how it happens in court, but I like not knowing what's going to happen in trial and seeing it as it unfolds in real time. And I appreciate that. So thank you, chat. I know. I'm sure everyone went deep diving into this, but we have to wait and see how this unfolds in court and know that if the defense thinks it's a big deal, they'll bring it up. Do we think that the attorneys are missing anything? They have like 17,000 law clerks. That's a bit of hyperbole, but I don't think the defense team's missing anything. If they bring it up, it's because they want to. If they don't, it's because they don't. But I would not be surprised if it is on all the CVs on the company's website because they don't want somebody downloading those CVs and giving it to the court because that's not what those CVs are for. Those are advertising. So I appreciate all of you. It is so hard to trust and wait that the stuff we want to see brought up in court gets brought up. It's hard. It's hard. It's hard. James said, I like EDB not knowing too. More fun to see her surprise, especially if you know what's coming. During Dep, we heard all of you guys knew what was coming. Well, a substantial amount of you knew what was coming in that clip of Amber Heard talking in the deposition. I had no idea. I had no idea what was coming. And I was stunned. Absolutely stunned. And I don't want to know what's coming in court. I want to see. So thank you. I appreciate you. So let us continue.
And this methodology and approach of Mr. DiSogra is simply math that he's using, correct?
No, it's not simply math.
Well, let's go to the clock variance values in the middle column.
That's the first time I've seen him get snippy.
Chart. You see that, sir?
Yes, I do.
Those are, as of March 5 of the date of this column was created, nothing in that middle column is new, is it? That data?
Yes, some of that data is new.
Well, the source data upon which it is created is not new, is it?
No, it is not.
All right. So the source data of that column, it's not new.
Correct.
And the middle column uses your data points from your January 30th report, correct?
No, not all of those are.
But it does use some of the data from your January 30 report, correct?
Yes, it does.
Is the reason that you did not take that final analytical step that we've been talking about in your January 30th report, and this is a question, is the reason you failed to take that final analytical final analytic step we've been talking about in your January 30 report was because you knew if you did that if you calculated the actual time of the 1162-2 text stream event based upon your own methodological analysis of the clock skew, there would always be continued interaction on Mr. O'Keefe's phone after the text stream.
It's a good question.
No.
Then why?
So you deny that?
Yes.
Yes.
Did you keep your January 30?
I'm going to let him keep going, but chat, we're going to just, apparently the new math is mathing. Emily, are you making a joke because you don't understand your kid's math homework? Yeah, I'm real bad at math. Anyway, Emily, this is not unearthing your academic insecurities. I want to know in the chat real quick while we're taking a pause here. what are your key takeaways? Like if you had one key takeaway, where we're at in cross now with this witness, what is your takeaway? Like where are you at with this witness right now? Because I feel like I am sitting here going, I don't even need more from cross. I just can't, like, I don't even want to know. Like, okay, you disagree with the defense expert. Fine. I just don't find you a reliable expert at this point. And it keeps getting worse. And when we went through direct, I was like, the way he's explaining this makes sense. He explained it much better than the first trial. He wasn't in the first trial. It was explained much better than the first trial. I think there are things he correlated properly. But I can't put reliance on that based on everything else that we've seen. Even though I think that there are parts of his testimony that's accurate. I do think there's room for variance between the Lexus and John O'Keefe's phone. But I don't feel like I can trust what he says that variance is, especially after seeing that phone call data, where it seems that he took the 1 and 2 second variances and threw them out the window. So I can't trust what your variance says. That's where a lot of you are too. All right. Yeah, it's just as they get deeper into the nuance of where there's disagreement with him and the defense attorney, every time he says, right, but that's unadjusted, right, but that's based on this. I'm like, okay.
2025
sure,
report.
Bro.
Purposefully
just like, go off then.
vague by merely noting a clock skew without engaging in any further analysis, such as tethering that clock skew or otherwise connecting it to the text stream event in Dr. Welcher's slide presentation.
No, I did not.
Switch to another topic.
Great. You know what it feels
Take
like?
that down.
I don't want to liken it. It's like being at a conference or a professional work event and you can't get away from the person you don't want to talk to. And you're just sitting there going, I don't want to hear another word that you say. And then you're just stuck. I feel stuck with this witness at this point. And this weather. Damn.
Thank you, Mr. Quote.
If you hear everything go boom and crash, it's me.
After reviewing, and I'm going to identify 3 timelines. After reviewing the timelines, reviewing the timelines presented by Dr. Welcher,
Bucketing down rain.
1, Mr. DiSogra, 2, and Mr. Ian Whiffin, 3, all of which established that the 1162.2 text stream event occurred before that last user activity, the lock on Mr. O'Keefe's phone. You then decided to issue a new report that would become dated May 8, 2025.
I want to hear
correct?
all about this,
Objection.
though.
I'm going to allow that.
No, so I issued the supplemental report based on that presentation that you just had up.
But you
Well,
decided.
Before you issued that report, isn't it correct that you had reviewed the time data of Dr. Welcher in the slide that we were reviewing?
Not before that time, no.
You had not looked at Dr. Welcher's slide with a text stream event 1162.2 and a time for that before issuing your May 8th report?
No, yes, before sorry, misheard you, yes.
That's my question.
Yes.
So let me just ask it through a question.
Sure.
So it
So it's another misunderstanding?
is correct that before you issued your May 8th, 2025 report, that you had reviewed that slide of your colleague Dr. Welcher on 1162.2 that establishes the text stream event as 12:31:38 to 12:31:43, correct?
Correct.
You reviewed it before your May 8th report.
Yes.
You
yes.
also reviewed before your May 8th report the slide presentation of Mr. DiSogra, correct?
Yes, I did.
And Before you issued your May 8th, 2025 report, you also had reviewed the January 2025 report of Mr. Whiffin, correct?
Correct.
He just wants to know what you
One
reviewed.
of and all of
Like, that's it.
those three established that the 1162.2 text stream event
This is
occurred
a good point.
before the last user activity on Mr. O'Keefe's phone, correct?
They do.
I'm going to allow it if that's what.
That's
Let's
accurate.
see what the answer is.
Using
accurate.
either unadjusted timestamps or inaccurately adjusted timestamps. Yes.
Let me ask my question again, and if it's not clear, please let me know.
Sure.
The point's
After
made to me,
reviewing
but we've gone through this a lot.
What we've discussed,
This
prepared by
morning.
Dr. Welcher, Mr. DiSogra, and Ian Whiffin, each and all of which established
Yes,
that the
bud.
1162.2 text stream event occurred before the last user activity on Mr. O'Keefe's phone. You then decided to issue a new report that would become dated May 8th, 2025. Is that statement I just made correct?
Yes, that is correct.
Now let's take a
Right.
look at your May 8th, 2025 report.
I want to know more about this report.
You departed in your May 8th, 2000. Do you have that report in
I
front
do.
of you?
Yes.
Do you need a moment to look at it, or are you ready to take
No,
questions?
go ahead.
Thank you. You departed
Sure.
from your
Let's
analysis.
continue.
Let's start it this way. In this May 8th,
Let's start at the
2025
very
report,
beginning.
you departed from your analysis
good place
in
to
your
start.
January 2025 report to reach a conclusion that would attempt to put the 1162.2 text stream event after human interaction with Mr. O'Keefe's phone, correct?
No, I did not depart from my original report. I clarified.
Okay. So
Parlance.
you didn't depart
Parlay,
from it, but
parsnip,
you, in your May 8th report, but your
or chance.
position is you clarified it.
Correct.
But isn't it correct that in your January 30, 2025 report, you did not address at all whether the 1162.2 text stream event occurred before or after the last user event on Mr. O'Keefe's phone, correct?
Correct.
But you did that in your May 8th report, correct?
Correct.
You don't call that a change, sir?
No, sir, I do not.
You call that a clarification.
I do.
He uses them synonymously.
In your January 2025 report, you compared call log entries between the infotainment system on the Lexus and Mr. O'Keefe's iPhone to determine a potential variance, correct?
Correct.
And call logs are discrete points in time that are fairly easy to compare.
Correct.
Now, in your May 8th, 2025 report, you abandoned the call log analysis from your January 30th, 2025 report, correct?
No, I did not abandon it.
Did you rehome it?
You did depart from it, at least in some respects, correct?
I did not depart from it. I used another method.
Okay.
So the method you originally used, you no longer used. Is that not a departure? Why are we, is it getting uncomfortable? Because now you're starting to kick back at Alessi. No, I didn't depart from my method. I just didn't use it anymore. Sir, what? You changed methodologies, which is making me even more mad when the court said, this is not new information. It seems to be a complete fucking change in methodology. Because he went from, and this is why I say that, he went from looking at when calls were received on Karen Reed's Lexus, Infotainment, and calls received by John O'Keefe's phone, or calls made from Karen Reed to John O'Keefe's phone. And he looked at the timestamp on those two things and said, okay, this is how we're seeing how in sync these times are. And then instead of syncing it between infotainment calls and calls on the other phone, he started syncing it between Waze data on the phone and text stream data. How is that not a completely different way to sync events? It's a new methodology. Unless you're going to say the methodology is more broad and you're linking the phone to the Lexus still, it's different. Linking app activity and the car driving is different than linking the two different call data. Am I? What?
So you used another method.
Correct.
So you departed from it.
In your May
We're not
8,
fighting over the-
2025 report, you
We're not fighting over the
opined,
dictionary
as I
today,
understand
apparently.
it, that the call log variance has been ignored because, in your words, this offset is measured approximately 5 hours after the time of the alleged collision and cannot be assumed to apply to other timeframes as stated in the initial report. Do I have that right?
Yes.
Now, please show the jury, in your January 30 report, where you ever made that statement.
Oh, we're just going to flip. We're just going to flip pages. Great. Great. Let's just flip. Daisy and Rue's mom said, thrilled to be here for Tudacity. I mean, the thing is, I've been using Murdacity, or we've been using Murdacity since it was said in the chat during the Murdoch case, and we had gotten to all the audacity that it became Murdacity. Now we've got to Mendacity. I need to put a fucking thesaurus on my desk. I am behind in life compared to Alessi. Now we've gotten to the Mendacity, and we got to Mendacity Monday.
Sure.
But-
So that would, it's not worded exactly like that, but that would be in conclusion 5.
So you said it without saying it?
And conclusion number 5 is on page 37 of your January 30, 2025
We've gotten to, like,
report,
trust me,
correct?
bro.
Correct.
And you concede at least as much that at least different words are used in paragraph 5 in your January 30th, 2025 report, correct? Correct. And your position is
Was that an answer?
that it's the same statement as in your May 8th, 2025 report? Because that's my question.
That is correct.
In your May 8, 2025
Alessi, the
report,
microphone.
instead of applying the offsets
For the love of my ears.
from the call logs, which discrete points in time that are fairly easy to compare, as you stated just moments ago, you decided to use, in your words, quote, approximate time of the 3-point turn as your anchor between the two devices. Do I have that right?
Yes, you do.
Isn't what you did and we just discussed a classic example of confirmation bias, which is to be avoided in science?
No, it is not.
So you believe that that is not confirmation bias?
No.
Choosing
I believe
the
that he believes
3-point
that.
turn as the independent data source
The jury might disagree, but I
is
believe he
the
believes that.
only way you could ever get the text stream event to even possibly occur after the lock event on Mr. O'Keefe's phone, correct?
That adjustment is the only adjustment that can be applied due to the data. Yes.
And that adjustment is
What happened to those 1 to 2 seconds on those pesky little calls? Because it seems like the adjustment could be as little as 1 to 2 seconds and as much as 26 seconds. So why not say it could be as little as 1 to 2 seconds and as much as 29 seconds? So it could be anywhere up to 30 seconds. It still narrows it down from the 60-second window. But when you throw out the data that doesn't work with you, I don't know what else to call it. Like, science and law are very different. Law is going to argue every single way around a fact and hope that the jury takes their interpretation. Science doesn't work that way. Shouldn't. It is what it is. The other methodology showed mostly a 1 to 2 second variance. So if you throw out all that data to go with the larger variance, what else is it?
is the only thing that can be done to get the text stream event 1162.2 to occur after the lock on Mr. O'Keefe's phone, correct?
Correct.
And that only one is the one that you chose, correct?
Correct.
And that's only because it's not a pinpoint in time. It's an amorphous range that can only, in your words, be approximated, correct?
No, that is because it is the only time adjustment in that time range that can be applied.
So it's your view that that's the only one that can be applied, but it is even what you're using is, in your words, an approximate time, correct?
Correct.
Isn't the shortcoming, sir, in your analysis that you ignored the additional user activity on Mr. O'Keefe's device that occurred after the lock event?
Can you repeat that question?
Yes, I can.
That was the clerk, or the court reporter asking us to report
shortcoming
that.
in your analysis, sir, that your analysis ignores the additional user activity on John O'Keefe's device, his cell phone, that occurred after the lock event?
No.
Well, let's take a look at events that you tell me if
When we get past the lock event, what I understood from Whiffin's report and Jessica Hyde is that some of the things on John O'Keefe's phone after the lock event are not user initiated. I don't know if it's going to matter. I'm pointing it out because I disagree with that interpretation of the data, but it's not going to matter to this expert. I think for anyone. I don't know if there's anyone on the jury going, none of this is a big deal. If it was just one thing, maybe they'd be like, oh, the defense is just defensing. But it's too many issues.
correct or not occur after the text
Because I don't think there's
stream
anything
event
user
1162.2.
initiated after that lock.
So do you recall our discussion yesterday about the Apple Health data event of 36
What, not
steps
healthcare
covering
data?
a distance of over 84 feet? Do you recall that?
Yes, I do.
And do you recall that that occurred at 12:32:16?
Yes, I do.
And that's after the text stream event of Dr. Welcher that he put in his slide, correct?
Correct.
Do you also recall a Doppler pocket state detection at 12:33:14? Do you recall that?
Yes, I do.
And that is almost an entire minute
That's not-
after the 1162.2 text stream event.
That's not user
that
initiated,
is
though.
identified by your colleague, the
Oh.
licensed engineer, Dr. Welcher, in his slide presentation.
Maybe. Because at some point you would have to put it back in a pocket. So maybe?
Correct?
Correct. And neither one of those are user interaction.
I understand your, well,
At some point it's got to get
but
covered back up again.
let's just take one of them.
Sure.
And that is the
I see the
Apple
argument.
Health data event of 36 steps covering a distance of 84 feet at 12:32:16. Would you agree
That's when that event ends.
those steps covering that distance is human activity at least? Would you agree that's human activity?
Yes.
Thank you.
Though I do agree with the other experts that that gets written when the steps end. So it doesn't show that those steps are happening at that time. Will it matter? We'll see.
Let's take a look at opinion number 7 in your initial
I don't
January
think
30th, 2025
that
report.
matters that much.
And sir, tell me when you had a fair opportunity to locate that.
Okay.
Oh my God. Alessi with the mic. You're just smashing it with paper, my guy.
You concluded to a reasonable degree of scientific certainty that, quote, the infotainment module power on events were on average recorded 3 seconds after the ignition release or finger off, correct?
Correct.
That means that your own testing requires an offset
Added a
of
3
-3 to account for a delay in the power on of an infotainment system, correct?
Correct.
That increases the time between the text stream event 1162.2 and the iPhone lock event by 3 seconds, correct?
Correct.
You
Oh, now we're gonna map
testified
together.
about this same 3
We're gonna map in
second
real time.
discrepancy yesterday during your direct examination in connection with your January 30, 2025 report, correct?
Correct.
However, you did not mention this offset of 3 seconds
On both ends.
in
So
your May
6, it could be up to 6 seconds.
2025 report, did you?
No, I did not. Can I explain?
No.
Mr. Brennan may have questions for you with regard to that. So nowhere
It's
in your
cross.
May 8, 2025 report did you include the 3-second offset that you discussed in your January 30, 2025 report, did you?
Correct.
And in fact, sir,
Look.
nowhere.
The explanation might be, right, this was an amended report. Does it matter? No, because there should still be 3 to 6 seconds accounted for from when you push start to when you push stop. So we still need that window. That offset also needs to be accounted for if you're correlating.
In your May 8th report,
And Alessi is saying it's nowhere
you
mentioned.
discussed why you're not addressing that 3-second, do you?
I do not discuss it, but it is that offset is adjusted within the adjustment that we do with the 3-point turn.
How?
I understand. My question is simply, there's no discussion in your May 8th, 2025
Show your work.
report how or why you're not discussing that 3-second.
We've gotten to full trust me,
Correct.
bro. It's accounted for in the work. Trust me, bro. It's show your work.
I've got a next section, Your Honor, if you would like me to move into it.
So why don't we keep going?
Okay.
Oh my God.
Sir, a text
Oh my
stream
God.
data event
I appreciate that he asked the court if it
like
was time for a break.
1162.2
I'm ready for a
does
break.
not, well, let me back up this way. You testified on direct that you're involved in accident reconstruction. That's part of the work that you do, sir?
No, that is not part of the work
Thank
that I
God.
do.
Well, let me clarify then.
The thing is, no matter what the next witness Welcher has to say, Welcher, the accident reconstructionist from this same firm for the Commonwealth, relies on this individual's timing of when things happened. And I saw a lot of questions. Is this what the Commonwealth is using to rebut ARCA? I don't think ARCA even went into when things happened, and I don't know if they're going to. ARCA goes into very much how things happened. I don't think ARCA needs to go into when they happened. So this expert, is that me being like overly lawyerly? Maybe. This expert's not going to really rebut ARCA because ARCA's like, we can't tell. I'm not looking at when this happened. I'm telling you what happened, and what happened is not this, or that. But when we get to Welcher, who is truly supposed to rebut ARCA, the Commonwealth needs to come up with a timeline, not the defense. The defense is saying never happened. The Commonwealth needs to say this is when and how it happened. But Welcher's testimony is founded on this testimony. If your foundation is bad, then the jury can pull that bottom card and be like, if I don't trust this witness and your testimony builds on this witness testimony, yoink, because the foundation isn't stable. So no matter what work Welcher does and how qualified he is to do the work, if it's still founded on the timing determined by this witness, it still blows up because so much damage has been done to this witness's credibility. The Commonwealth has to prove the timeline. It's on them to prove it beyond a reasonable doubt. And this is the expert for that. So,
Do you at all understand whether there's an issue as to whether a collision actually occurred in this case? Do you understand if that's an issue?
Objection.
Sustained.
Sir, do you
understand
have
what
any
I'm saying to you, sir?
understanding about
Blink,
what
blink.
Dr. Welcher in his slide presentation was addressing in context with this case? Do you understand it?
Objection.
I'll allow a yes or no on
No, I do not.
So you have no idea
Unless he just
what
buffered.
your colleague, Dr. Welcher, who's working on the same case, was addressing in his slide presentation?
Generally, yes, but I cannot speak to it.
What do you generally understand?
Objection.
that. Sustained.
What understanding do you have
Sir,
after
today,
reading
ignorance is
Dr.
not
Welcher's
bliss.
slide presentation?
Objection.
Sustained. Ask it different.
Today's not the
Do
day.
you have any
Today's
understanding?
not the day.
Can we approach, Your Honor?
Sure.
Alessi is trying to get at, did you understand that the conflict in the timeline was a conflict? Because what Alessi is insinuating is that this witness modified the way that he interpreted the data because John O'Keefe's phone data and the 1162.2 text stream data conflict. So Alessi is trying to get to, you saw that conflict and tried to bridge the gap, right? Like you knew that can't be. So you were attempting to bridge the gap. And I don't know what this witness knows. All right, they go to sidebar. So that's what Alessi's trying to question him about. And he's like, huh? I don't even know.
May I proceed, Your Honor?
Yes.
Thank you. Thanks for your patience, Mr.
Yes, sir.
Burgess. I would like to go back to the
I think
line of
Yannetti's
questioning
trying
I-
not to
I was
smile bigger.
starting, and that is, I would like to discuss with you, and I'll start with your conclusion, and I'm going to reference your May 8th, 2025 report, sir. If you could turn to the conclusion section of your
Chad, it's fair to
report.
say Scotty doesn't know. My only quibble with Scotty doesn't know is Scotty was lied to. Maybe Scotty wasn't as observant as he should have been. But Scotty was lied to. This witness should fucking know. Like,
which is on page
it's his job to know.
7. And I'm going to start with, and I
We're
may
still on cross, Leonard Tay.
just
We're still
end
on.
with,
We're still
we'll
on
see
cross. We're still on cross.
Conclusion number 1. Please take a fair opportunity to read that. Pick your head up when you have concluded.
Pick your head
that fair
up.
reading.
Pick your soul up off the floor. I don't know. Do we need Scotty doesn't know on the soundboard?
Okay.
Now, that paragraph
How
1
quickly
states,
would I have copyright issues if I just put
under
it on the soundboard?
conclusions, you
Probably
say the following
immediately.
can be stated to a reasonable degree of scientific certainty. 1, as noted in my initial report, the only call logs that can be used to compare and synchronize the clocks between Ms. Reed's Lexus and Mr. O'Keefe's iPhone are those occurring between 5:21 a.m. and 5:30 a.m., which occur approximately 5 hours after the collision. You see that, sir?
I'm going
I
to
do,
back
yeah.
that question up because I was contemplating Scotty. Scotty doesn't know. We'll have an in-depth conversation. Scotty became Pope. We'll have an in-depth conversation about Scotty doesn't know later. It's a Euro trip. And in my brain, it's a meme.
Say the following can be stated to a reasonable
I'm going to back this up because I lost my train of thought. I was arguing for Scotty.
You need to read that. Pick your head up when you have concluded that fair reading.
If you guys YouTube Scotty Doesn't Know, you will see Matt Damon singing the Scotty Doesn't Know song from the movie Euro Trip.
Okay.
Now, that paragraph 1 states, under conclusions, you say the following can be stated to a reasonable degree of scientific certainty. 1, as noted in my initial report, the only call logs that can be used to compare and synchronize the clocks between Ms. Reed's Lexus and Mr. O'Keefe's iPhone are those occurring between 5:21 a.m. and 5:30 a.m., which occur approximately 5 hours after the collision. You see that, sir?
I do, yes.
Now, what I'd like you to do is to go back in your report.
Oh, he does say collision.
Same report?
Yes, sir, same report.
Unless
May
he has
8th.
done this a different way. Unless he was trying to get to, so you're synchronizing the timelines, which I also think is the wrong use of word, but you are synchronizing the timelines and you say after the collision. So you are aware when the Commonwealth thinks the collision is, which is what Alessi's trying to get to. Alessi wants to get to, you are aware of when the Commonwealth says the collision occurred. And you are aware of the activity on John O'Keefe's phone that happens after the Commonwealth says the collision occurred. And then you adjusted it. That's what he's trying to get to. And he's trying to get to it cleanly, and it's hard because this witness is like, huh?
And I'd like you to turn to page 3.
Okay.
And if you could go to the 4th full paragraph that begins with 2 events near the time. And let me know, sir, when you're there. And if you could read that paragraph, pick your head up after you've had a fair opportunity to read it.
Okay.
Thank you. Now, you state 2 events near the time of the collision were recorded by the Lexus system as identified by Dr. Welcher and referenced by Mr. DiSogra. The first event, labeled TechStream Event 1162-1, is associated with a 3-point turn on Cedar Crest Road. The second event, labeled TechStream Event 1162-2, is associated with a reverse maneuver on Fairview Road. These events will be referenced below for clock synchronization analysis. The timestamps associated with these 2 events are based on a combination of the Lexus Infotainment Power On event and TechStream time count. Did I read that correctly, sir?
Yes, you did.
So in the same paragraph, am I correct that you're discussing a couple of TechStream events, 1162-1 and 1162-2?
Yes.
And you are talking about that text stream event in the same paragraph as you're talking about an alleged collision, correct?
Correct.
And in your paragraph of your conclusion that we were referencing, conclusion 1, is this paragraph part of the basis for that conclusion 1? Is this sort of like some predicate analysis for conclusion number 1?
No, it is not.
So it has your view, it has no relationship whatsoever to conclusion 1.
No, correct.
So let's go to your discussion of a collision and a text stream event. Let's go back to paragraph 3. You mentioned
Can we
the
just
word
put it on the board for the
collision
class?
in paragraph 3, correct?
I do not.
I'm sorry, I just had paragraph 3. I meant page 3, sir. Page 3.
Yes, page 3. Yes.
Page 3, that paragraph we were just looking at, paragraph 4.
Yes, sorry. Yes, I do see
You
collision.
see the use of the word collision.
Yes.
And again, that term is used in the same paragraph as you're identifying text stream event 1162.1 and 1162.2, correct?
Correct.
Where did you get the basis
The audacity. I'm sorry.
to use the word collision
No, I'm not.
at that
Not
part
sorry. It's
of
true.
your report?
That would have been from crash reports.
And whose crash report?
You said you didn't have the crash
Massachusetts
reports.
State Police.
Oh, the cars
So
report.
you
Emily,
used-
incorrect. He said he didn't have the cars report. Alessia is trying to get to, so you looked at Welcher's report and you tried to modify the timelines and just like make them match. He's saying, no, I didn't. I used the Massachusetts State Police crash report, different than the cars report from Trooper Garino or Trooper Paul or whoever wrote the crash report. Cars report. There's a cars report and a crash report.
Massachusetts State Police reports to discuss allegations of a crash, collision.
Yes.
Do you state
The
anywhere
MSP crash report was done
in
after
your
the fact.
May
the police
8th report
There's no accident report. There's
That
police reports
you
that say there was a collision.
use
That's what he's calling a
those
crash report.
reports at all? Do you list it in your references?
No, not in this report. No.
And as a matter of fact, this is the first.
Aren't you supposed to like cite your sources? To be fair, if he cited everything he referred to in the first report, you wouldn't necessarily list it in the supplemental. Like in the first report, it should say, I reviewed, and then list everything that you reviewed. But the supplemental, if you reviewed supplemental material, the supplemental should list what you reviewed. It should, every expert report, just period, should list, I reviewed.
Time, right this previous moment, that you are mentioning those reports at all, correct?
No, those were mentioned in my initial report.
But I'm talking about your May 8th report.
That's a
Yes, sorry,
that's
yes.
fair
Okay.
to him. That's fair to him.
Your
If it's mentioned in the first report, you don't need to list it in the supplemental specifically.
statements, and I want to clarify this because this is the ultimate topic I want to go to.
Does it matter? No.
It is not your conclusion that every text stream data event means that there is a collision. Do you, sir?
No, that is not my conclusion.
So isn't it correct that you can have text stream events and they're not collisions?
Yes, you can.
And isn't it a fact that a text stream event, sometimes called a trigger event, is not like an airbag type deploying, correct? They're just, and we're going to get to this later, it's just something that
Later.
happens with a Lexus vehicle that can cause the vehicle to register a text stream event, correct?
Correct.
And some people refer to text stream event as a trigger, correct?
Correct.
But there's many things that can happen with a vehicle that can cause a trigger. correct?
Correct.
We will come
Like?
back to that. So you would agree,
Let's get
again,
into
that
some
a
of them.
text stream trigger event does not mean that there was a collision, correct?
Correct.
A text stream data event doesn't mean that airbags were deployed, correct?
Correct.
A trigger data event doesn't mean that there was a vehicle impact, correct?
By itself, no.
By
Correct.
itself, it doesn't mean, correct?
Correct.
A text stream data event merely refers to Lexus's practice of capturing real-time data from applications databases and not devices and transporting that data for immediate processing and storage or for real-time analysis and analytics reporting, correct?
I'm going to let him answer. Not that Christoph asked an important point in the chat. For those of you that haven't watched this trial before, and those of you that are like, I'm sorry, I've glitched. Fair. Did I space out the reversing of the 20 miles plus yesterday? No, they haven't talked about it at all. They haven't talked about what these text stream triggers are. We know, well, more specifically, we know that the 1162-1 trigger is a 3-point turn, and that the 1162-2 trigger is a backing event. That is all the detail that we have about those. They will get into it with the other witnesses, but we don't know more about the details of those events beyond that. I want to know what makes the Lexus register a trigger event. I wonder if the reason we haven't gotten there is because that's proprietary. But we'll see. So he's starting to ask about not all trigger events mean this, this, or that. Oh gosh. I can't believe we're here. I just can't believe that this is what's happening.
I don't think I understand your question.
Fair.
If you could rephrase.
Sure. A text stream event merely refers to Lexus's practice of capturing
I'm glad Alessi
real-time
went there.
data from applications and databases. Is that correct?
I would not call it applications and databases, no.
What would you call it?
So from various sensors or other modules on the vehicle.
Okay, so it's
That's fair.
Lexus's practice of capturing real-time data from various sensors and modules on the vehicle, right?
Correct.
Why don't we stop?
I feel like I understand that better now. The stream froze a little bit. It's not you or your brain. The witness stopped moving.
Here, Mr. Lessie?
Yes.
I think we're going to stop for the morning
We'll take
break.
our morning recess, so it's 20 minutes.
All right, please.
All of you stretch. We're going to just, oh boy. We're going to zoom past the morning break. I mean, it's a long morning break. Y'all, what in the world today? Yes, the video froze a little bit. It's not y'all. All right, let's answer some of these real quickly, because there's been a number of questions that I think will be helpful, because we're still in the middle of cross-examination with the Commonwealth's Aperture tech expert, one of their two key witnesses. Amy in the chat said, EDB, was the Commonwealth allowed to speak to him last night or this morning before he got back on the stand? Only as to like scheduling, but not about their testimony. Nope. You cannot talk to witnesses about their testimony. You can say, hey, you need to be at court by this time. Let me know when you're here. So you can't say, bro, what the fuck? By the way, you need to clean these things up. You cannot talk to them about their testimony. M gifted 5 memberships. Thank you. There are different circumstances that are an asterisk we won't get into. The sequestration order in this case is significant. There are times when you can say to the court, Your Honor, can we speak to the expert and have all the parties there together? But no. Julia Duffy, and many of you asked, can he get in trouble for this? I'm interpreting trouble to mean with the court, not with his own employer. And when it comes to the court, he has not, to what we've seen, lied on the stand or violated a court order. Is he getting roasted on cross? Yes. Can you get in trouble for being a bad witness and getting roasted on cross? I mean, in the sense that the jury is told that they can choose to disregard your testimony, but is the court going to strike all of his testimony? Something extreme would have to happen. You let the jury decide. You let it come in and you let the jury decide. Now, is this going to cause problems, I imagine, for him personally? Yes. I don't know how he testifies in another court after this because of how bad this was. The thing that's critical for experts is they're reliable. And this cross has shown that there are numerous touch points of lack of reliability, even if he was correct in the way he interpreted the data initially. There are too many areas for cross. There are plenty of people that understand how to interpret cars and phones. Why pick the one that's going to open up a can of worms? Now, could his company still choose to allow him to work with, non-trial cases? That's up to them. Like, that's all up to them. A lot of questions about, will they revisit his previous cases? Only if he lied. If he said in previous cases that he had education that he didn't, that is the basis of his expertise, that would be the only reason. But him getting roasted on cross doesn't mean that his assumptions or evaluations in other cases were wrong. Though if he represented on the stand he had education he didn't, that can be an issue. So no, I know a lot of you are like, I would get in way more trouble at work. Yeah. I wonder if other clients, government agencies, insurance companies will look at the billing. That is the thing I keep coming back to. His employer held him out to have education he didn't have. And I wonder if they charged insurance companies at a commensurate rate. I'm not saying that they did or didn't. I don't know. Oftentimes insurance companies, and Emily, did you work with insurance much? No. Oftentimes insurance companies will have a flat rate, so it wouldn't even matter. But I think other clients would want to know. I also think it makes it hard to hire the company for a little bit, because if you're on a jury in 6 months from now in your jurisdiction where you live, and it's a vehicle collision, and somebody comes in and is like, I work for Aperture, and you watch this case, aren't you like, bitch, what? Really? So can this damage the reputation of a firm? I think it can. So repercussions in court, probably not. Professional repercussions, 100%. I don't see how this person can testify as an expert again after this cross. Maybe I'm being too harsh. I'm open to somebody explaining it to me, but if I was looking at a case with this expert, I would immediately be hiring another expert or a different company. If I was dealing in civil right now with a case with Aperture, I would be considering whether or not the jury might be aware of this. I had friends that were picking juries after Depp Heard, and the things that happened in the Depp Heard case, jurors were talking about in jury selection because so many people watched it. So yeah, jurors are aware of things that happen in other cases. So yeah, I think there is a huge problem for this expert, but is he going to get in trouble in court? This is the in trouble in court. And I saw a lot of people saying that they felt badly for him. He wrote his LinkedIn. If he hadn't written his LinkedIn, I might have been a bit more generous with, is your company holding you out wrong? But it's the company and the resume and the LinkedIn and the bits versus bytes and the wrong date and. So my generosity only goes so far on this. Do I blame Brennan for that? Not necessarily. I don't know if Brennan was aware of all of this, and I don't know if we will know, but Brennan is a special prosecutor. I'm trying to grab a question real quick, and it keeps jumping, and it's a good question. I want to grab it because there's a lot of us in chat. I'm going to hold on to this. We're going to get back to this cross. But in the way government hires experts, it's possible that this was a decision not made by Brennan to hire Aperture, and this was a decision made by the Norfolk DA's office, by the higher ups. He's a special prosecutor. I don't know if he had a say in that. Or if they said, these are the experts that we've hired, you wanted new experts, here's their reports, and then he read them. So I don't know if Brennan hired this expert, vetted them, or chose them. However, Brennan had the information he turned over to the defense. Brennan seems to be aware on May 7th that that May 8th report was coming. Brennan had the slide presentation that shows the wrong date. Brennan should have caught all of those things. 100%. But did Brennan get to choose this expert? Not necessarily. Are there things that the prosecution team should have caught? Yes. 100%. 100%. So on the last question on that, Marlene said, can other cases where this witness testified have grounds for appeal? Only if they find that he lied about something. If they find that he lied about something, then depending on what the lie is, probably, but sometimes that can also be for the jury to decide. But it's wild. It's wild. Potentially criminal. Good to see you in the chat. Sean said he volunteered to help put Karen in a metal box for the rest of her life. With this nonsense, knowing he was full of BS. I have no sympathy for him. I don't think this witness, Sean, only to push back, I don't think this witness knows he's full of BS. Just watching him testify, I think he thinks he's 100% correct. But Brennan should have caught the errors. But y'all know that I have issues with how the prosecution chooses to move forward with this case anyway. So, but yeah, they've charged her with second-degree murder based on this. Then again, when I point back to the other cases y'all have watched and you wonder why I talk about the prosecution has to prove it so much in this case, all of you that watched the Boone case with me, were you sitting there during the prosecution's case in chief going, I wonder how this happened? No. Same with Brooks. Same with Shabusiness. I think the Murdaugh case maybe came the closest to like, how did this all go down? What's the prosecution going to prove? But a lot of the cases we've watched, you're in the prosecution's case going, I wonder what the defense is going to say about that. You're not in the prosecution's case going, how the fuck did this happen? There's a reason for that. It's because prosecutors get to choose what cases to bring and not bring. And a lot of cases don't get brought. Well, I don't know about Norfolk. I can't speak to that. A lot of cases don't get brought. Even cases where the prosecutor might be sitting there going, I know that that person did that thing, but I don't know if the evidence is strong enough to go to trial. That's what you do. You have to be able to prove it beyond a reasonable doubt. It's not based on fucking vibes. This is one of the two key witnesses. So sure, the comments can be like, it's not the you in the chat. Chat, it's not you. But people are like, so a mistake on a LinkedIn is a reason to disregard an expert witness? It can be for a jury, but it's not that. And trying to downplay that this expert misrepresented their education, I find to be disingenuous. Because it's not just the LinkedIn. It's the LinkedIn, it's the CV, it's the website. It's the billing for added work that didn't need to be done because you didn't understand the data that was coming off of the chips. That's where it started going wrong. But this is the data that is supposed to show when a collision happened. Is it reliable? Is this expert's data and this expert's testimony reliable? That's the question. And we're not even done with Cross yet. So yeah, I find it offensive, but I worked in this system for a long time. I find it offensive that an expert would blatantly misrepresent their education when there's no need for it. There are tech experts that do not have a 4-year university degree who know their shit. So there's not even a reason unless it goes to billing, which I also find offensive. So yeah, there are things and good points that this expert made. And maybe some on the jury will find him credible and be like, yeah, those are picky. I don't care. Doesn't matter to me. Are his certificates up to date? But I don't think you're going to have 12 people on a jury that are just like, whatevs. Especially if they're still paying fucking student loans. I don't think this is a whatever. I don't think it's a typo on a LinkedIn. It's a lot more than that. So, am I frustrated? Yeah, it's frustrating. The Commonwealth hired new experts to prove their case, and this is what we're at. And the witness doesn't even seem fazed. Not even fazed. Like, aren't you embarrassed? Not even fazed about so many errors, typos, misrepresentations. So if he doesn't give a shit about what he's testifying to, why should the jury? Why should the jury give a shit about what he has to say? It's the fucking craziest thing I've ever seen. Katie, thank you for your comment. Katie said, I'm an attorney in Massachusetts and encountered Aperture experts before, and recently one of those experts told me Aperture is a preferred vendor for the Massachusetts DA. Billing government agencies is real easy, isn't it? I wonder if that's going to change. I wonder if that's going to change. They were at, there's times I go do my CLEs at events with other lawyers. So Aperture was one of the vendors at one of those events. Tracy said, Emily, have you ever declined to prosecute? More cases than I can count, Tracy. Someday we'll talk about a screaming match I got into with a boss. Sometimes Los Angeles district attorneys have a flair for the dramatic. I think I would be hard pressed to find a colleague that hasn't walked into a boss's office and said, I'm not doing this. If you want it done, do it yourself. Or some variation of that with curse words and throwing things. But yeah, I think every colleague I've ever worked with has been like, I'm not doing this. And I think a lot of my colleagues have probably declined to prosecute. Well, if they're not filing, it depends on their unit, but decline to prosecute regularly as many, if not more cases than they prosecute. It is a very normal part of prosecution. It should be a very normal part of prosecution. It's a very normal part of prosecution for the feds. The feds take a fraction of the cases that come to them, a minute fraction of the cases that come to them. So it's frustrating. You don't bring in a witness that the jury can't trust.
You may be seated.
It's so frustrating. It's so frustrating. I keep my license current because I do
All right, Mr.
consulting
Leslie,
work.
whenever you're ready.
Thank you, Your Honor.
So yes, I keep my license current because I do consulting work. Do I want to go to court every day anymore? No. I did that. I like doing this better, but yeah. No. It was hard work, man. I am dyslexic and ADHD. I fucking fought for not only high school graduation, but college graduation, law school graduation, and the bar exam. Like, it was not easy. I fucking worked for it hard. It was not easy. Getting into college wasn't easy. My grades were not great. So, no, it was a fight. So, yes, I keep my license current because it was a fight. Also, I learned a lot from my CLEs. This year, they just happened to talk about LinkedIn a whole bunch, and who knew how relevant it was going to be? I was like, that's interesting. People don't understand how LinkedIn works. I mean, I guess I don't always understand how LinkedIn worked. It was talked about so much, but no, I had to fight for it. I had colleagues who have photographic memories. I'm pretty sure Alessi probably does too. I have complete aphantasia. There was no photo anything happening. I don't begrudge them that. People learn differently and do things differently. It was not easy. And if it doesn't feel easy to you, it doesn't mean that it's not meant for you or that you're not capable of doing it. Some things are worth fighting for. Some things come easier to some people. Some don't. It's the same with school. So yeah, offended on a lot of levels. Offended on a lot of levels. Because bro's just like, yeah, it's fine.
Mr. Burgess?
Awful. Just
I'm going to pick up, sir,
awful.
where we left off. A text stream trigger event does not automatically mean there was a collision, correct?
I like that
Correct.
they are breaking down what the text stream triggers
Text
mean.
stream data event doesn't, without more, mean an airbag deployed, correct?
Correct.
A trigger data event doesn't mean without more that there was a vehicle impact, correct?
Correct.
A text stream data event merely refers to Lexus's
I think this is a
practice
good
of capturing real-time data from
Good.
applications
area of cross.
in databases, correct?
Sensors and other modules.
That's right.
on the vehicle.
You had
Correct.
said that earlier, sir. Sensors and modules.
I think it's a good area for cross
You
because
Reviewed.
Emily, you're pausing. You're chatty today. Yep. Here's why I think it's a good area for cross. There could be some jurors that sit there thinking, yeah, but if the car recorded something, that means it happened. And what they're going through is the car records that their sensors have just picked something up. I think it's a very good thing because the defense has to be mindful that no matter how good they think they're making their case, there might be jurors who are like, yeah, but the car. And they have the benefit, of Alessi, who's a new attorney to the team with fresh eyes, and I don't think is going to pull punches with the defense, and is able to see the blind spots that I think at times Jackson does not see. Because I think there's times Jackson's like, how could anyone not see it the way I see it? I mean, obviously. But if you listened to the jurors that spoke publicly after the last trial, they completely discounted the ARCO witnesses. So the defense also has to be mindful that just because they're reading the room one way and they're reading the internet one way, doesn't mean the jurors feel that way sitting in the courtroom. So they have to close those loops, even though they think that this witness has been rendered not credible. Some people might be like, yeah, this witness is a shit show, but what did the car say? This guy didn't testify in the first trial at all. But the other experts did, who I found very persuasive. The jury didn't. So they have to close all those loops too, even though it might seem obvious to us sitting here.
The raw text stream trigger events on Miss Reed's vehicle, correct?
No, I did not.
Oh, you did not?
No.
I'm going to back that up real quick because I stopped to rant again.
A trigger data event doesn't mean without more that there was a vehicle impact, correct?
Correct.
A text stream data event merely refers to Lexus's practice of capturing real-time data from applications in databases, correct?
Sensors and other modules.
That's right.
on the vehicle.
You had
Correct.
said that earlier, sir. Sensors and modules. You reviewed the raw text stream trigger events on Miss Reed's vehicle, correct?
No, I did not.
Oh, you did not?
No.
You didn't review the raw data.
Do you understand
Where'd it come from?
do you have an understanding whether Mr. DiSogra reviewed those events in his March 5, 2025 report?
I do not.
So you did not.
So what did you review? Did you review someone else's report about a report about a report? Did you review? No. You didn't rely on Trooper Paul's report, did you? That's not what's going to happen. That no. That can't be right.
Not review the raw data for text stream trigger events on Miss Reed's vehicle.
It might not
and
be
you
Paul's.
did not therefore perform any
could have been
analysis
Guarino.
of that data as you sit here today, correct?
Correct. Outside of what Dr. Welcher provided.
So what Welcher provided to you. Yet when you wanted to look at John O'Keefe's information, you ring-a-ding-ding Tully and asked for the raw data. You're the car expert. Why didn't you ask for the raw data? Isn't that literally what you were hired to do? Holy shit. I think Alessi's making notes and buffering in real time because he didn't expect that answer.
That there were approximately 30 text stream trigger events in an 8-month period on Miss Reed's vehicle?
No, I'm not.
Jesus.
Assume
Take the wheel at this point.
the data shows that in the mere 8-month period that Miss Reed owned her vehicle, the Lexus in question, there
She
were
only had the car
30
8 months
text
before this?
stream trigger events. Assume that. You would not conclude that there were 30 collisions in that 8-month period, would you?
No, I would not.
Would you agree, sir, that there were actually 2 triggers on January 29th?
Yes.
Oh, we're back to the
And
29th?
the first trigger that you referred to of 1162-1, that was not a collision, was it, sir?
Without reviewing the data, I don't know.
But you didn't
Well,
review
as
the
you sit here
data.
today, you have no basis to state that the 1162-1 trigger was a collision, do you?
No, I do not.
And in fact, didn't you refer to that as a 3-point turn?
I did, yes.
And you didn't mention in your direct testimony when you talked about the 3-point turn anything about a collision, did you?
No, I did not.
And as you sit here today, there's no fact or data that you have to conclude that there was any supposed collision associated with that 1162-1 3-point turn trigger event, correct?
Correct.
A trigger event can occur on a Lexus vehicle by a whole host of
It's a good
possibilities,
area for
correct?
cross.
Correct.
You could maybe slam on the brakes and cause a trigger event.
That is one possibility.
You
Yep.
could have
What are the
just
other ones?
unusual driving. You could be going at a speed or doing something else that has nothing at all to do with a collision, correct?
That is correct.
And in fact, there are almost countless events that can occur that can cause a trigger event in a Lexus vehicle.
So I don't know the exact count of what type of triggers there are, but yes, there are
There are
a
many.
number. Yes.
Kathy Abbott in the chat said the state needs a refund. Yeah, they're not going to get one. He
So
came in
back
and
to the
testified.
1162-1.
They're definitely not going to get a
3-point turn
refund. They're going to be
trigger event.
mad.
On your direct examination, you just referred to event surrounding that as a 3-point turn, correct?
Correct.
And yet that 3-point turn registered as a trigger event, right?
Correct.
Are Lexus SUVs trigger happy?
I do not know, sir.
As you sit here today,
He was happy with that
none
question.
of the information in that black
I wonder if the trigger information, this is just me speculating because that's a large vehicle. I wonder if the trigger data comes from when the beep beep sensors go on in the front or the back of the car. And if you're doing a 3-point turn on a residential road, I would imagine you could come close enough to the curb that the car beeps at you. And if that is enough to register a trigger event, when you're doing a 3-point turn in a large vehicle, it's going to beep at some point. But he doesn't know because he didn't review the raw data.
Box that you referred to on your direct testimony indicates that there was a collision on January 29th, does it?
Not by itself.
Not by itself.
Correct.
And it doesn't occur that none of the information in that black box indicates that there was a collision on any day without more, correct?
Correct.
I'd like to
Which
now turn to...
I think cuts both ways because the defense is going to argue that Karen Reed collided with John O'Keefe's vehicle and it didn't register that either. What I have to wonder, he didn't review the data. What I have to wonder is, did the vehicle even register an event for when Karen Reed was backing out of the driveway? Because we see it on video. Did the car register an event for that at all? Or not? Because that you can say, okay, this is on video and there wasn't even a trigger event for it. So it is 6 of one, half dozen of the other. I'm curious.
To a different topic, sir. In your direct examination, you referenced a Ms. Maggie Gaffney. Do you recall that?
Yes, I do.
And wasn't part of your reference
That's the feed, not you.
that she did with respect to the Lexus SUV?
Yes, it was.
And, for instance, you criticized her for failing to extract the micro SD card from the circuit board during the initial chip-off, right?
So, sure. So I did criticize for not identifying the micro SD card and subsequently not downloading it, yes.
And on direct, you even tried to lay at her footsteps, if you will, your bits, bytes misinterpretation on her
Your
by claiming that you
misunderstanding.
assumed, quote, a competent expert, close quote, would not have overlooked a relevant chip, so you became confused how there could be data missing. Is that a fair characterization?
No, it is not.
Did
That's
you
what you said.
at all try to use as a justification for your misunderstanding of bits and bytes that it was her work?
Her word? you
Her
said?
work.
Her work.
Yes, her work.
So it was the, overlooking of the SD card, yes.
Right. So you did try to...
He also said on direct, to my memory, that he believed that the cards had incomplete downloads. And that was based on him not understanding how much data those cards held. And so he said, the other person didn't complete the downloads. These are incomplete. It's not incomplete. You just didn't know how much data they held because you misinterpreted the data. Okay.
Lay at her footsteps, part of the reason why you misinterpreted the bits and bytes that we discussed yesterday. Is that correct?
No, that is not correct.
Okay. So you would agree then
I
that
disagree.
the bits and bytes misinterpretation that you and I discussed yesterday had nothing to do with the work of Ms. Gaffney, correct?
So in part, but that was my mistake, yes.
All right. I'm trying to understand which is it. Is it
His.
Ms. Gaffney's work had some part in your misinterpretation of bits and bytes, or her work had no part in your misinterpretation of bits and bytes?
Some part.
So you do attempt to lay some blame on Ms. Gaffney for your misinterpretation of bits and bytes, correct?
No, I'm not trying to blame anyone.
Okay.
Including you,
In
as
your
it turns out.
January 30, 2025 report, Are you consistent with your criticism of Miss Gaffney?
As I recall, yeah, I believe so, yes.
In fact, you yourself provided the explanation for why the micro SD card was not extracted during the original chip-off, didn't you?
Yes, that it was overlooked.
Right.
Yes.
So if you could please turn to page 5 of your January 30, 2025
Oh
report.
boy. LB in the chat asks, can you all remind me who Gaffney is?
And
Gaffney
sir, when you get
did
there,
some of the original downloads
if you could let me know,
and the chip
and
off.
I will then proceed with questions.
Okay.
So you do attribute to Ms. Gaffney in your report some responsibility
thank you
for
that,
this
Chad.
micro SD card not being extracted during the original chip-off. Is that correct?
Yes.
So let's go to page 5 of your report, sir.
Page 5. If I'm a lessee,
And-
I think I never want this cross to end, even though it's exhausting.
Bear with me, I want to get you the exact location.
And the thing that I think works for a lessee with this cross particularly is that he does modulate his tone when he thinks something's important. But he's very linear in working through it.
I don't have it
So
exactly, but I want to.
It doesn't seem that he's trying to trick the expert into a gotcha moment. It is just a this, then this, then this, then this, then this. So this. Right? Versus some more aggressive cross can come across as like trying to find a gotcha that's not a big deal. And I think that would lose how many moments of this cross are like, but you didn't. It's wild. But I think the methodical nature of the cross highlights those versus the jury feeling like they're all just fighting and tuning out. It's a really solid
quote, yeah.
strategy.
Your Honor, may I have a moment to get the exact quote?
Sure.
Thank you.
Yeah, take your time. We're just gonna answer questions. I'm not even gonna zoom. We're just gonna answer questions. Ashley said, EDB, oh wow, I just learned about aphantasia. Yeah, I didn't realize it either. I think you can go watch me learn in real time when we are in the middle of the Gwyneth Paltrow case, which is actually a really interesting case to watch chat kind of change its mind mid-trial and go, wait a second, what? It was a fascinating case to cover. I'm fascinated with the idea you can't picture an apple. If I say picture an apple, can you please talk about your experience? I had no idea. Here's why. I don't know how other people think. I always thought when my water polo coach was like, just visualize this, it was like a metaphor. I didn't understand that other people see pictures in their brains because we don't really talk about it. I now talk about it with my kids and my husband at length. I ask my kids what they see or hear when they're doing things. I ask my husband about it. My husband, this probably goes very well with his work, can see things almost three-dimensionally and kind of puzzle them out in his mind. So when he's sitting and processing, he's processing everything visually. I hear. It's more like not watching a movie. It's more like audible.
Thank you for that, Your Honor.
Like
I now
everything
have it.
is through sound, not pictures.
Mr. Burgess, if you could turn to.
But I remember song lyrics. I remember movie lines. I remember things I've heard. I do not have a memory to things that I see. Emily Alito said, wait, y'all actually see the image? Oh, people see images in varying degrees. Some people see it three-dimensional. Some people see a whole movie. Yeah, no, people can actually picture things in their mind. Some people cannot at all. I process everything through sound. So I can remember what I heard. I can remember what I said. But I can read a page and not remember what I read unless I also read it out loud. I do not have visual processing. But, which is interesting because like when I would go to the movies with my friends, they'd be like, that's not how I pictured that character. I'm like, what the fuck do you mean? That's not how you pictured that character. Like I'm waiting for them to cast it so I understand what this person looks like. And they're like, I mean, the book describes what they look like. I'm like, yeah, and? The book describes what they look like. So my friends and I would read something, go to the movies, and they're like, oh, that's not how I pictured that at all. And it kind of ruins the experience for them. For me, I'm just like, oh, cool. That's what that looks like. So Amanda said, what are your childhood memories like? If I don't have a picture of it, it's just sound.
Also, same with dreams. Sound. Like it's like listening to Audible. But I know that doesn't make sense because for a lot of you, when you listen to Audible, you can picture the things happening in your mind. So you have like a movie going on up there. I just hear the words. So yes, for all of you who are, we don't talk about how our brains work nearly enough. And we don't ask students how they think. We don't ask, do you learn better when you hear something? Do you learn better when you see it? Do you need to see it and hear it? Do you need to read it and hear it? We just don't ask. So we ask our kids all the time for them to explain. Travis can see things more three-dimensionally. It's probably why, though I was a okay water polo player, I could not well anticipate what plays were coming up because I could not see the sports ball happening. It's why I like doing legal commentary, because I recognize the patterns in court. Court's all verbal. Court's all spoken. This is my wheelhouse. But I went to law school with people who are like, oh, it's this case. How the fuck do you remember that? Well, I could see the page I was reading in law school in my brain. What? What do you mean you could see the page that you were reading in law school in your brain? I had to talk things out in study group to remember them. Or to myself. Only verbal processing. So, all of you who are learning more about your brains, welcome. We'll get back to trial. Thanks for the question.
Page 5, as I was referencing, and go to the third full paragraph. If you could look about 2/3 of the way down the far right, you see the word where it starts with at.
Brains are different.
It's the paragraph beginning when examining vehicle systems.
I do. Yes, I see it.
And do you see the at that is at the very far right of that paragraph?
Yes.
I love you guys chatting about this.
At the time of the incident,
Brains are not off topic because I have digressed. Nightbot, it's fine. It's on topic.
Burla, and Burla is what? Can you read?
Burla is a company that offers and develops forensic hardware and software for vehicle modules.
Right. So at the time of the incident, Burla did not offer support for the infotainment and telematics modules removed from the Lexus, but have since released updated software indicating similar modules are supported via in-vehicle acquisition. According to Burla, currently, there are 2 known and documented modules within the vehicle that have the capability to store data. The infotainment module removed from Ms. Reed's Lexus is consistent with the MMU documented by Burla and has been identified.
I know, it's got its own multiverse at this point.
As containing an internal micro SD card not acquired during the initial chip-off acquisition by Ms. Gaffney. Did I read that correctly?
Yes, you did.
So as you stated, Burla is the organization that you described, which for the purpose you did, I'm not going to repeat it on direct examination. If I could sort of put in layman's terms and see, you tell me if this is correct.
That's the feed. It's not even my weather.
To make it
The feed's been
easier
rough.
for non-technical people, as you put it, to extract data from a vehicle, correct?
Correct.
You describe in your January 30, 2025 report that at the time of the initial chip-off, Burla did not provide support for the information contained on the micro SD card, correct?
No, so I think you're misreading that last sentence, and I can clarify.
Any other lawyer, I would say you're probably right. Here's the debate that's happening right now while we're also debating how brains function. The software and hardware that reads the chips says, or Alessia is saying, that during the time they first did the chip off downloading, it didn't support the micro SD card. I think where Alessi's going with that is, well, why? This wasn't overlooked. This was a choice. She chose not to take it off because it couldn't be read. Isn't that true? That's where they're going. This was not overlooked. This was a decision.
Can you read the last sentence, sir?
I can. So the infotainment module removed from Ms. Reed's Lexus is consistent with the MMU documented by Burla and has been identified as containing an internal micro SD card not acquired during the initial chip-off acquisition by Ms. Gaffney.
So my question is, did or did not Burla, at the time of the initial chip-off by Ms. Gaffney, provide the technical support to address the information contained on the micro SD card?
No, Burla did not and does not.
Good. That I wanted to.
That was my identifier of the micro SD card. Correct.
So it was not until after the initial chip-off that Ms. Gaffney participated in that Burla updated their software to be able to identify the types of data, for Burla software to be able to identify the types of data contained within the micro SD card on the Lexus circuit board. Is that correct?
No, that's incorrect.
So Burla didn't do anything new after the initial chip-off with its software?
Sure. So Burla released new software after the initial chip-off that addresses being able to download software via the infotainment module while it's in the vehicle. So that involves plugging a USB in to the vehicle and downloading data. That does not address the micro.
So if the chip off hadn't been done and the software updated, then you wouldn't have had to tear apart the entire car. Okay.
SD card on the circuit board itself.
And Ms. Gaffney did not have, at the time
He says that does not address the micro SD card.
of the initial chip-off, that updated Burla software, correct?
Correct.
Okay, thank you, sir. Appreciate your questioning. Thank you for answering my questions. That's all I have at this
He's
time, Your Honor,
done?
but I have a bit to pack up, so Mr. Brennan can have a clear podium.
Go right ahead.
Thank you.
If you notice that the light keeps changing, yes, I have very dynamic weather today. The light's going to keep changing. Hey, T. We're just switching witnesses, so let me zoom real quick. Well, not switching witnesses. We're going to redirect with Mr.
Follow the
Brennan.
rules, sir.
I'm not sure how he's going to do that. So, hi. You wanted to say hi to everybody? Hi.
Yeah, no, I just got home from exams.
I know. Give me 1 second as the attorneys are changing. So,
Thank you for that opportunity.
I'm glad you got home before this.
Yeah. There are kids who literally showed up to exams.
Soaking wet, I'm sure. It's that kind of a day. All right. Wave bye to the chat.
Goodbye.
All right. Glad you're home. You should probably go put that away. You're not going outside with that right now. Or anywhere.
Need to practice my drop spins exercises so that
Not in here, you're not. Love you.
in the garage and upstairs.
All right. Oh, and the gym would work. All right. If you hear all kinds of banging around, it's because my kid is practicing drop spins upstairs.
Your Honor.
It is what it is. I told you, it's May. It's a very busy week at the Baker House this week. All right, redirect. How is this going to go? Has anyone anticipated a redirect from Attorney Brennan more than this one? Also, should we let the app know that we're on to redirect? I'm shocked that we got here before lunch. I'm very curious. Very curious where we're going with this. Artemis, thank you for the gifted memberships. LB, thank you. Welcome to our new members. We will be doing members only things. Oh, you are in the three-piece suit today. I was joking earlier.
Good afternoon.
Good afternoon.
Sir, what the fuck? I have two questions. First, how dare you?
Do you know what a sequestration order is?
Yes, I do.
And what is it?
So it would be an order to not view any testimony of a trial, is my general understanding.
Does that mean that you can't watch any of it on television?
Correct.
Or in court?
Do you understand whether or not you can speak to attorneys about testimony? Is that precluded as well?
I'm not aware either way.
Has anybody ever spoken to you about any testimony about that occurred in this trial before you testified?
No, they have not.
Have I ever
not the
discussed,
biggest
intimated,
issue.
or suggested any information whatsoever to you about arguments, testimony, or anything about this case as it's ongoing?
No, you have not.
Do you follow the rules, sir?
Yes, I do.
Have you followed them in this case?
Are CV's guidelines?
Yes, I have.
When you gave your opinions and you've testified, do you have any information or knowledge about this trial as it actually occurred until the point when you testified?
No, I do not.
You were asked some questions about your CV. A CV is a resume?
Yes, it is.
Okay. And you were asked about a LinkedIn account.
Yes, I was.
Is your LinkedIn account different than your CV?
Yes, it is.
And in this case, when did you learn that your LinkedIn account was wrong or had not been updated? When was the first time you learned that?
That was yesterday.
I
When
can't.
you
What?
started your LinkedIn account, do you remember when it was you set it up?
I do not. It would have been maybe 10 years ago or more.
Do you routinely update your LinkedIn account?
No, I do not.
When you set up your LinkedIn account, the section where it asks,
But if you made it 10 years ago, you still didn't have a degree.
for education, whether graduated or ongoing, do you remember filling out that section?
I don't particularly remember filling it out, but obviously I did at some point.
When you were asked about Aperture's website, how many experts are associated with Aperture?
I could give you a rough number between 80 and 100,
How many offices?
15 or so.
Are you
15.
involved in the website design or content?
No, I'm not.
Do you know if Aperture gets the information from their website directly from LinkedIn?
I don't know where they get all of their information from.
Did you ever weigh in or develop your information that was on Aperture's website?
No, not on the website.
You do provide CVs before you come to court, don't you?
Yes, I do.
And in this case, you were asked by the defense, when you provide your CV, do you understand that it's going to be reviewed by whoever requests it, the Commonwealth or the defense,
Yes, I do.
and that it will be shared with both sides in the court?
Yes.
And in fact, the first time you provided a CV in this case, was it October 11, 2014?
Objection, Your Honor.
So the leading nature sustained.
Do you remember the first time you provided a CV in this case?
It would have been around October
Of what year?
of 2024, sorry.
And when you provided that, was it as an exhibit to something?
Yes, if I recall, it was as an exhibit to the initial protocol that I sent out.
And when you submitted that CV, did you appreciate whether or not it would be part of a court filing in public?
Yes, I did.
If I could have exhibit 183, please.
So we knew it would be public and it still didn't come up?
183.
It's actually not part of the docket. It's just provided to the defense and the prosecution.
You could enlarge the top section. Right there is good. And sir, when you provided this CV to be filed with the court and made public, did you indicate that you had obtained a bachelor degree?
No, I did.
Let me move myself out of the way because I'm blocking part of this. This says education. This is his name, his face. Don't do the things with the things. But it has his photo and it says education BGS currently pursuing. That's not what the website says. The website says 2022.
Did not.
Why did you put currently pursuing?
Because I am currently pursuing a bachelor's degree.
And did you understand your CV was received by the defense and they knew this?
Yes, I do understand that.
Subsequently, you were asked to provide an updated CV in April 2025?
Yes, I was.
Did you do that?
I did.
And can we have Exhibit 184?
The degree that they talk about here, I didn't read whether it said Bachelor of General Sciences. If it did, that doesn't exist because it's a Bachelor of General Studies. Let's see what the next one says. The BGS part can be accurate.
Did you
What
further
BGS
appreciate
stands
this
for
would be
was
provided
not.
to both the court and the defense?
Yes, I did.
Did you represent to the defense that your education included earning a bachelor degree?
No, I did not.
What's the new one say?
You've testified in, you can take that down, please. You've testified in many other cases
I have. Yes.
in courts around the country.
Yes, I have.
And when you've testified in other courts around the country, do you know whether there are transcripts of your actual testimony?
Yes, I believe there are.
Have you ever represented in any court that you achieved your bachelor's degree?
No, I have not.
Have you ever inflated your qualifications in a court?
No, I have not.
When I asked you about some of your background, you told us that you had certificates in Celebrite and Axiom. I didn't go through all of the qualifications and all of the accomplishments you had, did I?
No, you did not.
Do you have professional certifications, GIAC, Advanced Smartphone Forensic Analysis?
Yes, I do.
Do you have professional certification from CCME, Celebrite Certified Mobile Examiner?
Sustained.
Do you have professional
It's leading.
certifications as
It's
a
leading.
Magnet Certified Forensic Examiner?
It's
Sustained
leading.
for the same-
Ask him what degree.
sorry?
Ask him.
Sustained for
It's
the same reason.
leading.
Do you have a number of certificates that I did not ask you about?
Yes, you did.
Can you share some of those with us?
Name them.
Sure. So one of those is going to be GIAC, Advanced Smartphone Forensics. So that's going to be Global Information Assurance certification. And that is basically a 40-hour class or 48-hour class with a test at the end to get that certification. There's also a Celebrite Certified Mobile Examiner certification that is specific.
Do they talk about pocket states? Just curious.
To kind of demonstrate your knowledge of the Celebrite software, as well as Magnet Forensics certifications, again for their software specifically.
Any certifications regarding computer hacking?
What was that last part? Sorry.
Any certifications regarding computer hacking?
No, not currently.
Okay. Did you also take any classes regarding crash data or Bosch?
Yes, I have.
What do you have for certificates in that arena?
So those certifications would be Crash Data Retrieval Technician and Crash Data Retrieval Analyst. So those courses would be around acquiring and analyzing crash data from airbag control modules.
You mentioned that you had over 700 hours
Yes, I do.
of classes and certification.
Yes, that's of classes and classes and seminars or conferences, specifically in digital forensics or vehicle forensics.
Do you need a bachelor's degree to be competent and achieve in
I
this
thought
area?
he would ask
No, I do
this.
not.
Is a bachelor's degree a prerequisite of success in a particular field?
No, it is not.
You ever hear of Bill Gates,
Oh, good
Yes.
Lord.
Stephen Jobs,
Yes.
Oprah Winfrey?
The degree is not the point. The degree has never been a point. The point. The degree is not the point. The representation is the point. The cake is a lie, Brennan. And you know the cake is a lie.
Bachelor's degree to be competent and achieve in this area?
No, I do not.
I had to hear the
Is
whole
a
list.
bachelor's degree a prerequisite of success in a particular field?
No, it is not.
You ever hear of Bill Gates,
Yes.
Stephen Jobs,
Yes.
Oprah Winfrey?
Sustained.
Also, who calls Steve Jobs Steven?
You had become engaged in this case in October 2024?
Correct.
And when you first became engaged, you had a chance to look at photographs and some data?
Yes, I did.
At that point, you hadn't had a chance. Had you had a chance to actually inspect any of the
I
physical
know he went to
property?
Oprah. I don't
No,
know.
I had not.
Did you have an understanding that somebody else did?
Yes, I did.
Who?
Miss Gaffney and a number of other people with the MSP.
Attended some type of procedure?
Correct.
And do you know who led the actual procedure?
As far as I'm aware, it would have been Miss Gaffney.
The defense expert?
Correct.
You filed a protocol. What was the purpose in October when you first got involved in filing a protocol?
Sure. So the first purpose of the protocol was just to address the fact that we were missing data that we expected and address a potential solution to gather more data.
I want the defense to
Without
ask me
having
about
looked
like
at the physical property,
Elizabeth
the actual
Holmes.
boards, how did you conclude simply on data and photographs that
Girardi.
there was missing data?
Sure. So that would be reviewing the initial data that was provided and not seeing user data like I would expect. And that's because there's a number of different chips that are on a circuit board for an infotainment or a telematics or any other module. And there's a number of different data-bearing chips. The purpose of those chips will vary. Some chips' main purpose is to store user data. Some chips' main purpose is to store software or firmware. So if you're gathering, acquiring data from chips that only have software and firmware, then you would not expect or you would not see user data within those chips.
When you made that analysis and concluded that there was missing data, had there been any report provided by Ms. Gaffney suggesting there was missing data?
No, there was not.
Had there been any analysis or opinion alerting that there was missing data?
No, there was not.
Was there anything to indicate that the person who did this test missed data at that point?
No, not at that point.
When you decided to write a protocol so you could actually look at the boards and do an analysis, did you put that protocol in writing?
Yes, I did.
And do you remember if that was around October 10, 2024?
That sounds familiar. Yes.
Would it refresh your recollection
Now,
to review your report?
when you were cross-examined, the attorney asked you if you knew what the word mendacity meant. Do you remember that?
Yes, I do.
And you didn't know. Do you now know that means to lie or be untruthful?
Sustained.
Hey,
He didn't ask you a question. He just asked you if you knew what the word was. Do you remember that?
Yes, I do.
Do you remember he also, on cross-examination, suggested that when you had your mistake about megabytes, megabits, it was the defense expert that alerted you to that mistake? Do you remember that suggestion by the defense?
Yes, I do.
Did they ever show you the documents so you could see the chronology?
No, they did not.
Okay. You wrote a report on October 10, 2024. Did you then write another report, a supplemental protocol?
Yes, so I did write that initial protocol and then a supplemental protocol.
Was that on October 17, 2024?
That sounds about right.
When you wrote that a week later, at that point, had you realized your mistake?
Sustained.
Why did you?
the leading, Your Honor, the leading. The defense said you didn't correct this until you saw the defense report. And he said, I would have to check. Can I review my report? And the defense said, I'm sure Mr. Brennan will ask. Mr. Brennan's asking.
Okay.
So they're going to approach on the leading. We're going to zoom past that. It's a long... And they are coming back from the sidebar.
Error, what did you do?
All right, wait. I stepped on the beginning of that question.
When you realized your error, what did you do?
So I intended to correct it with a supplemental protocol.
When you corrected it with the supplemental protocol, do you remember what date that was?
Not specifically, I do not.
Okay. If I showed you your report, would that help your memory?
Yes, it would.
May I approach?
Yes.
Please don't read this, just look at it. And if it refreshes your memory, let me know, and then I'll ask you a question.
Yes, it does.
Yep, Brennan is used to being able to lead. He is a defense attorney by trade.
When
He's
did
a
you
special
correct your
prosecutor
error with the
here.
supplemental protocol?
That was on October 17th, 2024.
It's easier when you can lead, but you can't because it's redirect. It's in the title. I stepped on the date because I was yelling about Brennan leading. October 17th. Okay, perfect. Defense attorneys are allowed to lead when it is the Commonwealth's
And
witness.
do you remember the
When the other side calls the witness, then you're allowed to lead. In most criminal trials, the majority of the witnesses called are called by the prosecution. So for most criminal trials, the defense spends most of their time cross-examining witnesses. They might call a witness, they might not. It depends on the criminal trial, but the bulk of the witnesses is called by the prosecution. So if you are a defense attorney doing trials over and over and over again, 90% of your time on average is going to be spent doing cross-examination and then recross. So Brennan defaults into cross-examination mode because, well, that is his normal pattern of questioning. He is acting as a special prosecutor here. He can't act as a defense attorney until the defense calls their witnesses, and then you can cross. So he keeps asking leading questions on just about every redirect.
The date that you first received any information from Mr. DiSorga?
No, I do not specifically.
Remember the date when Mr. DiSorga's information was first filed?
No, I do not.
And do you know if it was, whether it was after your October 17th supplementary report?
Not specifically, but I believe it was after.
Okay. And so when it was suggested that you had to be schooled or advised by Mr. DiSorga, was that accurate?
Schooled?
Objection, Your Honor.
Word it differently. Word it differently.
It's leading.
The claim
I was on the cusp,
that was made
it's leading.
that you weren't aware until someone advised you of your error. Was that true?
No, that was untrue.
When you realized there was an error and put it in a report, were you ever dissuaded from publicly alerting all the parties of your mistake?
No.
Do you leave stuff in or out of a report if you find it helpful or hurtful to one side?
No, I do not.
Have you, in this effort that you've made in this case, have you always been encouraged to provide all information, regardless of what it is?
Objection, Your Honor.
I'm going to allow that.
Yes, I have.
And who's encouraged you to always provide all information, regardless of what it says?
No one. So my job is to assist the jury. So the jury, assisting the jury means presenting all the information.
Have you ever been discouraged by me?
No, I have not.
When you looked at the photographs and you looked at the boards without actually touching them, how long did it take you to figure out that there was some other vehicle for data?
Sure. So it took a few times to look at the photographs before I identified the micro SD card slot.
You were asked whether it's important to be accurate and reliable. Is it in this field?
Yes,
Yeah.
it is.
And
Yeah.
if data is not found on the chips, is it a standard practice to look elsewhere?
Yes, that would be a standard practice.
Was that done in this case before you became involved?
No, it was not.
Who was the first person to identify where the missing information was?
Myself.
I thought there was no missing
What
information.
happens
Now I'm
if
confused.
you miss information because you don't see it?
So if you miss information, that's
incomplete.
information that won't help in the analysis.
In this case, the information on the SD card that you found, how important was that to this entire analysis?
It was important to timestamp certain events.
Without that information in the SD card, would you have been able to so accurately timestamp certain events?
No, not so accurately.
Before you were involved, was that information, that very important information for timestamps, was that available for either side?
No, it was not.
Is it now?
It is.
You were asked about
it was available if somebody
Burla.
grabbed the chip? I'm so confused.
When Burla did not have updated software to simply plug into a car and download the information, what process would have to be used?
Sure. So best practice for vehicle forensics is if the module or a vehicle is not supported by a forensic tool, would be to remove that module, or let me start over, manually document the screens on that infotainment module if it's available and it can be powered up. but then also going through disassembling the module, identifying any type of chips or SD cards that may hold data, and acquiring that data.
Is that called a chip-off process?
It is called a chip-off process.
Does it describe the process well, chip-off?
Yes, it does.
Since
My toes got cold.
Ms. Gaffney did the original analysis and did that chip-off, has the software updated?
What?
Yes.
Is that the Burla software?
He was like,
No, I'm sorry. So she has not done a updated analysis with the Burla software.
But has the Burla software itself updated?
So the Burla software itself has updated, but it is limited to, again, plugging in a USB into the infotainment module while it's in the car running.
Does the updates in Burla software have anything to do with the SD card?
No, it does not.
Why not?
Because, again, they're going a different route to acquire data, and they are acquiring a limited amount of data through what's called diagnostic logs. So if you think of diagnostic logs, your radio unit is keeping logs of any time things happen on the radio for manufacturer purposes. So Burla is taking those logs, and they can interpret some of those logs. They are not
celebrate for cars.
acquiring all the data that is on the SD card itself.
You have drafted a number of reports in this case.
I have, yes.
Regarding the chip-off process, did Ms. Gaffney ever write a report?
No, not that I'm aware of.
When you wrote reports in this case, do you expect for them to be shared?
Yes, I do.
When other experts, like, for example, Mr. DiSorga writes a report, do you expect to have a copy and review it?
Yes.
Sustained.
What is the standard practice when there are reports from different experts regarding the same subject matter?
Objection, Your Honor.
Sustained.
Is there a standard practice
Sure.
regarding reviewing reports from similar experts in similar subject matter?
Sure. So anytime a report is written by an expert, that report would be provided and shared with opposing experts.
Reports,
That's common.
do they always come at the same time in a case?
No, they do not.
When you wrote your reports, how would you provide them so they could be disseminated?
Sure. So that I would typically provide them to the client or the attorney that hired me, and then that would be disseminated from there.
Did you have an opportunity to receive Mr. DiSorga's March 5th, 2025 PowerPoint?
Yes, I did.
Were you provided that by me, the Commonwealth?
Yes, I was.
And were you asked or given any direction on what you could or should do?
No, I was not.
Were you ever asked to reach any particular result?
No, I was not.
Were you ever asked to avoid anything?
No, I was not.
What did you see your role as when you receive a report from another expert like Mr. DiSorga?
Sure. So when I receive a report, I would typically review it and then make a decision if it's better to address any issues in that report through testimony or address those with a supplemental report.
And in that analysis, do you follow your own discretion or do you follow directions of the client?
No, I would follow my own discretion.
Did you ever receive any direction on what you should and shouldn't do regarding considering Mr. DiSorga's report?
No, I did not.
That froze. It's not you.
When you looked at Mr. DiSorga's report, did you have concerns about his report?
I did, yes.
I want
not a
to
great
talk about his
phrase.
report in detail before we get there. Share with us what your general concerns were about Mr. DiSorga's report
video
when
is
you
just
reviewed
frozen.
the whole report.
Sure. So what Mr. DiSorga does is take a couple different adjustment methods to attempt to adjust the clock from the Lexus with the iPhone.
Nope, just frozen.
But what he does is takes a lot of methods or data points that are not applicable to the time that we're interested in.
What do you mean? Can you explain with a little more specificity what he does?
Sure. So if you think about it, your clock is constantly, changing as far as it syncs up with other GPS satellites or network time servers, and it's updating constantly. So a clock
Constantly?
variance between two devices may be different at, say, 12 o'clock in the day versus 1 o'clock in the day. So best practice is to choose an event that is nearest to your time in question, so you have the most appropriate adjustment for that clock variance.
Mr. DiSorga's analysis, did he choose the event most closely tied to the backing up event?
Objection, Your Honor.
Sustained.
Leading.
The backing up event. Are you familiar with that time frame?
Yes, I am.
Okay. Was Mr. Sorga's analysis based on information most closely related to that event?
Objection, Your Honor.
Sustained.
Ask it
What
differently.
information did Mr. DiSorga choose to use for that analysis relative to the backing up event?
Sure. So he chose a couple things. That's going to be call logs that happened on both devices or that was recorded on both devices, as well as a GPS data point, which was incorrectly identified as being near that or encompassing that 3-point turn. So what we did is did a more thorough analysis of that 3-point turn event when it occurred within the iPhone data, and then compared that and adjusted with the Lexus.
Explain to us your concern about using call logs.
Sure. So there's a number of call logs that you saw earlier that were recorded by the phone and the Lexus. The one thing you'll notice, and it's hard to kind of go back to it without the graph, but the calls that happened between 1 and 5 o'clock that morning actually happened when the car was powered off. We know that based on the power on and power off events. So those timestamps that are recorded with that 2-second and 1-second offset is actually from Mrs. Reed's iPhone as she gets back in the vehicle and her phone connects up and syncs back up.
Oh, that actually makes sense.
So the 8-second and the 16 or 21-second offset are the only offsets that we have to compare to calls.
Was that a concern?
It was a concern.
That makes sense that the iPhones would be closer in time, but the report should reflect that clearly.
Why?
Because if you're using the 1 and 2-second offsets, that could be misleading because it's not actually comparing the Lexus clock with the iPhone clock from Mr. O'Keefe.
What's it doing?
It's comparing the Mr. O'Keefe's iPhone clock with
didn't that come
Mrs.
up in
Reed's
direct?
iPhone clock.
What other concerns?
Sure. So the other concern was a GPS point known as GPS 154, which, if you remember yesterday, we talked about it a little bit. So that was misidentified as being the end or towards the end of that 3-point turn. But when we look closer at all the location data, we can see that that actually occurs between 12:23:59 and I believe it was 12:24:07.
Let me ask you some questions about what compelled you to look at the 3-point turn and synchronize the clocks. Were you aware of Mr. Whiffin's report where he offered that the last user interaction on Mr. Whiffin's phone was 12:32:09?
Objection, Your Honor.
No. You were asked, did you consider Mr. Whiffin's report where there was a last user interaction of 12:32:09 by the user?
Objection, Your Honor.
I'm going to allow that.
That's not
You were
leading.
asked if you
That's pointing
considered
him
that.
in time.
Did you know that information?
I did know that information was available and existed, but I did not use that in my analysis for the clock synchronization.
Did that have any part of your motivation to do the clock synchronization?
No, it did not.
Were you attempting to match the synchronization with any of this other information
That's
that
the
exists
question.
in data?
No, I was not.
You were also asked if you were aware of Mr. O'Keefe's phone that at 12:32:16 it ended its movement.
Yes, I was aware of that, yes.
Did that in any way affect your interest or your decision to synchronize the clocks?
No, it did not. So my primary focus and to adjust the clocks was because I thought the PowerPoint slides by Mr. DiSogra were misleading.
When you were shown Exhibit 190, can we have 190, please?
He has said misleading about the defense expert quite a few times.
You were shown this chart. Was this the entirety of Mr. DiSorga's report?
No, it was not.
Was there text information offered by Mr. DiSorga to give his position or explanation of this?
Yes, there was.
Is that included in this exhibit?
No, it's not.
Did you get a chance to read Mr. DiSorga's report, including the actual text explaining his analysis and process leading to this chart?
Yes, I was.
Did you look at Mr. DiSorga's entire report?
Yes, I did.
I move to introduce Mr. DiSorga's report.
No objection, Your Honor.
Okay, so this was
All right.
triple D for
So they're
identification.
asking to introduce the entirety of the defense expert report into evidence. The defense, of course, has no objection, because generally that wouldn't come in. Now it's coming in.
191.
Remember, the reports are not evidence. The testimony is what's evidence.
You said as a result of Mr. DiSorga's report, you were concerned, so that compelled you to do your analysis that resulted in your May 8th report?
Correct.
I want you to take us through Mr. DiSorga's report and explain to the jury what concerned you about his analysis.
So he's
With the
now
court's
addressing
permission, I'd like to put this
the
page one of
defense
this
report preemptively, which is a good use of redirect. It just is going to depend on how much this jury is listening to this witness at this point. Because there are things he has
Is this the front
explained.
cover of Mr. DiSorga's March 5th, 2025 report?
Yes, it is.
Turn to page 2, please.
But that only matters if they listen.
What do
And
you
they only listen if
recognize
they trust.
this slide or photograph coming from?
Sure. So this slide is coming from Dr. Welcher's overall PowerPoint slides.
When
And
you
then
first saw
DiSorga
this slide,
highlighted it.
where did you first see, what source did you first see this through?
Through Mr. DiSogra's PowerPoint.
Well, Dr. Welcher works at Aperture, doesn't he?
He does, yes.
Did you know he was working on this case?
Yes, I did.
Was he providing you his PowerPoint or slides before this point?
No, he was
Those
not.
PowerPoint slides look blurry to me too, Chad. It's not you.
When you first saw this slide, did you see information about the timing of the text stream event, which was the backing maneuver?
Yes, I did.
And what time did that show?
Can we blow it up just so I don't get the time
Please.
wrong?
Can I see it? The blue's hard to see. This is trigger event 1162-2.
Up, please. I'm sorry. Up. There we go. Thank you, Ms. Gilman.
Trigger 1162-2 occurred
Sure. So
at
that's got
approximately
the text stream
12:31:38
event ending at 12:31:43.
and ending at 12:31:43.
These text stream events that are captured, do you know how long of the event is captured? How many seconds?
Yes. So approximately 5 seconds before the trigger threshold is met and 5 seconds after.
When this information that you reviewed in Mr. DiSorga's report, do you know what clock is used to identify the 12:31:38 to 12:31:43?
Yes, I do.
And what clock is that?
So that's a combination of the Lexus clock that's coming from the infotainment center, as well as the running timer that we discussed yesterday that's coming from the airbag module itself.
Is the source of that time important?
Yes, it is.
If you compare time from a different clock with time from a different clock and don't synchronize the two, does that lead you to an accurate result?
No, it does not.
When you were answering questions, you repeatedly were saying, according to the Lexus clock. Why were you offering that qualification repeatedly? One moment, please.
Sure.
Why were you offering that qualification repeatedly?
Sure. So to make sure that the jury understood that that timestamp was coming from the Lexus itself and was not an adjusted timestamp to Mr. O'Keefe's iPhone.
Could you scroll down, please, Ms. Gilman? Up a little bit, please. Thank you. The 3209, what did you understand that information to be?
Sure. So that is information I understood to be the last device lock recorded on Mr. O'Keefe's iPhone.
And what clock did you understand that time came from?
That would come from
John
Mr.
O'Keefe's
O'Keefe's iPhone clock.
phone.
If you reconciled his iPhone clock information, or if you compared it without reconciling, to what's the danger in doing that?
Wait, what?
Objection, Your Honor.
That's compound.
Is there any danger in doing that?
Objection, Your Honor.
I'm going to allow that.
Is there any danger in comparing two times if you don't consider the clocks that they came from?
Yes, there is. So you could essentially be, in inaccurate time for when that event actually occurred.
If you could just scroll down to the bottom so we could see the rest of that. You mentioned the word variance yesterday during your direct examination. I'm going to ask you to look at that box that has the green around it. Is that an example of variance?
Yes, that is an example of variance between, no. So I take that back. That is not an example of variance itself. That is an example of, comparing the end of the text stream event to the device lock event.
Is that attempting to compare two different devices?
So that's attempting to, that's not attempting to compare anything. It's just stating that the time between the device event lock and the end of the text stream event, unadjusted, is approximately 26 seconds.
Is that accounting for synchronization or not accounting for synchronization?
That is not accounting, that is not with synchronization.
Can we turn to the next page, please? Did you review the next page of Mr. DiSorga's report?
Yes, I did.
Crochet
And
Gnomes
did
in
it
the
lead
chat
you
asked
to
a
any
great
concerns?
question. Crochet Gnome said, why are they assuming the iPhone is the correct time? They're not assuming one of them is correct. They are trying to correlate the difference between the two. So if an event happened on the iPhone, do we know what the car was doing at that time? And if the two of those are at slightly different times, how do we adjust for it? And so they used the iPhone time as the anchor, not the car time, and then adjusted the car time, showed what the range was between the car time and the iPhone time. But they could have done it the other way where they say, okay, well, then on the iPhone, it would be at this time. They anchored it to the iPhone. So neither of them are really what's correct for the purpose of telling time. It's what's happening in the timeline, and are these things happening at the same time before or after?
This page specifically, yes and
helps.
no. So this page again is just showing the time difference between the end of the text stream event and Mr. O'Keefe's last device lock event.
Is this another way of showing the information that was in that green box?
It is. It's another way of showing the information in that green box, but it is not a clock variance or an adjustment.
Could you turn the page, please? When you read this page, is this a opinion or conclusion?
No, it does not.
What is it?
So this is just pointing out that when the 26-second window, which they'll refer as John's interaction window, when that number is positive, then the phone interaction occurs after the end of the text stream event. When that number is negative, the phone interaction occurs before the end of the text stream event ends.
Did you have any issue with that slide?
No, not that slide in particular.
Okay, then if we turn the next page.
The
Did you
phone
have
and
an
vehicle are
opportunity to review
two
the
separate
next
clocks.
page?
They may not be aligned.
Yes, I did.
And did you come, were you in agreement with this page?
That was in agreement with this page, yes.
And what does this tell us?
So this page points out that two clocks are not always in sync. So again, to synchronize those clocks, you would have to have a shared event that occurred on both devices.
If we could have the next page, please. Any chance to make that a tiny bit bigger, Ms. Gilman?
There is always interaction with John O'Keefe's phone after the end of the vehicle, regardless of what adjustments are made
Were you in
to
agreement
correct
with this
clock
page?
variance.
No, I was not.
Tell us what concerns you about this page.
Sure. So this page
read what
is
it
potentially
said.
misleading to the jury again by using,
Objection, Your Honor, move to strike.
I'll strike that.
Just tell me what your concerns were.
Sure. So my concerns with this, that it was potentially misleading to the jury.
Objection, Your Honor. Move to strike.
No, I'm going to allow that. That's his concern.
Sure. So that this slide was potentially misleading to the jury because it uses incorrect adjustments to try and adjust the times.
That
How does it
slide
use
doesn't
incorrect
use
adjustments?
adjustments.
Explain that to us so it's very basic, please.
Sure. So
slide doesn't
as we
use
kind of go
adjustments.
through the next
It
few
just
slides,
makes
you'll
a
see.
statement.
But essentially what they're doing is, or what is being done, is they're comparing call logs, timestamps from call logs from when the phone was off, suggesting that, again, that the lock event occurs after the end of the text stream event, as well as incorrectly identifying the GPS point when the 3-point turn ends.
Will you better be able to explain that to us with the further slides that come next?
Yes, I believe so.
So they are
Would you
going
turn
through
to
the
the next page,
defense. They are going through the defense expert report, and he's talking about where he disagrees with it.
Is this just a label of what's to come?
We
It is.
haven't gotten through
Until
to
we turn
his
to the next
report
page,
and the
please.
date, and the defense expert will do this with his report.
If we could start, Ms. Gilman, with the top left-hand box, if you could enlarge that for us. Did you review this information in this box?
Yes, I did.
Okay. And before we get to your opinions, what does this information tell you?
Sure. So this is a snapshot from my initial report where I point out that the ignition on happens approximately 3 seconds before the infotainment power on event. So you can see that. I think we're up a little too high on the page.
Like,
Yeah. So highlighted in the red. That's based on our testing where we identified that the ignition on, or your finger on the ignition pressing it, and the engine coming on and the vehicle coming on happens 3 seconds before the infotainment system powers on.
you were asked on cross-examination about that 3 seconds between the pressing the button and the infotainment system going on, but you weren't allowed to answer the question whether you considered it or why that was important. So I'm going to give you that opportunity now.
Objection, Your Honor.
Sustained. Ask the question.
It has to be asked differently.
Is there significance to that 3 seconds, and did you consider it in your report, in your findings?
Yes, I did.
Share with us.
Sure.
No lazy
so when
questioning
we
for
make our
Brennan.
adjustments based on the
Unless he is not going
event,
to allow
so in this case the 3-point turn, what we're looking at is the approximate time frame when that 3-point turn occurred via Mr. O'Keefe's iPhone. And then we're adjusting that for the approximate time that the text stream event and that 3-point turn ends. So as we sync those clocks, we're adjusting not only for the difference in the clocks, but we're also adjusting for this 3-second delay.
Did you accommodate that 3-second delay in your analysis and your conclusions?
Yes, that was included in my analysis.
Now back to the
Where did
screen.
you
The
show that it
information
was
there,
included
is
then?
that text taken from your actual report?
Yes, it is.
Could we shrink the screen, please? And then the photograph in the bottom left, if we could enlarge that, is that as well from your report?
Yes, that is also from my report.
Did we look at that yesterday on your direct examination?
Yes, I believe so.
And briefly tell us what that depicts?
Sure. So that's during our exemplar testing,
I wanna
where
see.
again we've got it rigged with cameras that are recording video and timestamps of interactions we're having with the vehicle, which include powering it on and powering it off.
If you could shrink the screen, and we'll go to the right, Ms. Gilman.
Okay. I just want to see the screen at this point.
What was the import of this screen to you in its entirety?
Sure. So this is not actually a valid way to adjust or synchronize clocks because, again, we're not adjusting based on a shared event. So the ignition on event occurs. It is not recorded by Mr. O'Keefe's iPhone. But again, we are adjusting and including this in our timestamp adjustment.
If we turn to the next page, please. You were asked about the process of synchronization through phone calls or through the 3-point turn data.
Yes, that's correct.
Why did you choose to use the 3-point turn data instead of phone calls?
I mean, he used
Sure.
phone calls
So
first.
I chose to use the 3-point turn data because it was closer in time to the event that was of interest, as well as it was based not only on the infotainment clock, but it was
did you
also
know
based on that running timer.
it was the
so
event of
once we
interest?
adjust that first event to Mr. O'Keefe's phone, the second event is also based on that running timer, so it would also be adjusted.
What is did you have any concerns about using phone calls specifically?
Yes, I did.
He
And
already,
what were they and why?
he already
Sure.
said
So
that.
those concerns were related to the phone calls that we could actually compare, and again, some of the phone calls that happened earlier or closer to the event of interest were not actually recorded by the infotainment system itself.
Why is it important to take an event closest to the time of
He
the
already
event
said
you're
that.
studying?
That's
Sure.
asked and
So
answered.
like I kind of said before, clock variance will change between devices as they are constantly syncing back up with reference systems. So a clock difference that you see at 1 o'clock in the day is not going to be the same as you would see at 2 o'clock in the day.
When you chose the 3-point turn, how close to the backing up event was that in time?
I believe it was within 10 minutes or so.
Was that closer in time or further away in time than the phone calls as a method?
That was closer in time than the phone calls. If you think back to the phone calls that we could have compared, those occurred at 5 o'clock in the morning.
We turn to the next page, please. Did you have a chance to review this slide of the PowerPoint?
Yes, I did.
Okay. Now you see on the left is a box. Where's that box taken from?
Sure. So that box on the left is taken from my report. That's going to be my initial report.
This is the defense.
January 30th, 2025?
That's
this is
correct.
the defense expert
And
report.
share with us what you were trying to
Using
express
his
in
report?
this box.
Sure. So again, this box is a
I'm sorry to interrupt you. I apologize. Ms. Gilman, is there any chance we could enlarge the box on the left? My apologies. Okay, please proceed.
Sure. So this is a comparison of the calls. So the infotainment call timestamps are on the furthest left column. So again, your infotainment
BRB.
system, when you plug your phone in, is recording and synchronizing your calls. It's not great about recording and synchronizing every call. So there's a lot of calls here that we don't have that we know exist based on Mr. O'Keefe's iPhone. So the calls that we do have that were recorded in the infotainment system, we can compare to the timestamps that those are recorded on Mr. O'Keefe's iPhone. So when we do that, there's a couple things we notice is during that 1 o'clock and 4 o'clock and 4:45 time frame, when we look back at the power on and off event, we know the vehicle was not powered on at that time. So the vehicle's off. So those timestamps are not coming from the vehicle. They're coming from Mrs. Reed's iPhone or the defendant's iPhone. And then the times after 5:21, we know the vehicle has been powered up at that point. So those timestamps are coming from the infotainment system itself. So that's why we can actually do a comparison of those timestamps and determine the exact.
The thing is, that makes sense to me, but it wasn't discussed at all during direct examination. So when we don't discuss it until now, I don't know if it has the impact. It might. It makes sense to me. Hey, those are coming from the iPhone. Those aren't coming from Karen Reed's vehicle. We're trying to adjust the vehicle and John's iPhone. Okay, but it doesn't come up during direct.
Or the approximate clock variance.
But if you don't have the
When
raw
you look at
data,
the-
isn't it just an assumption that that's where it's coming from? Because he hasn't explained to me how you know that.
Call timestamps of 1:14:13, 4:38:16, at 4:42:06, and 4:45:12. Was the power on or off with the car during those four first calls?
Yeah, so with those first 5 calls, the car was powered off. And again, we see that, we know that based
the
on
call
the power
wasn't
on and off
powered on
event.
till like 5:07.
We also know that just by looking at the offset, it's a consistent 1 or 2 seconds. And that's what we typically expect and see between two iPhones. That's because iPhones are generally pinging back to Apple servers or GPS towers that are the same. So those times are pretty consistent and pretty accurate.
Was the power on by 5:04:28?
No, not at 5:04:28. It was still powered off.
So those first five events, were they reliable for you to use in synchronization?
No, they were not.
You gave us a number of reasons. One, the time distance between the event, and because they were phone to phone. Any other reasons why they weren't?
Objection, Your Honor.
I'll strike the first part, ask the question.
Besides the reasons you already gave us, are there any other reasons why this would not be a reliable way to synchronize two separate devices?
Not besides the points I've made already.
Okay. And if we could zoom back on this. The box on the right, is that from your report? Is that Mr. DiSorga?
That's Mr. DiSogra.
Was there anything about that analysis that concerned you?
Sure. So that analysis is misleading because, again, it's not comparing Mr. O'Keefe's iPhone to the infotainment system. It's actually comparing the defendant's iPhone to Mr. O'Keefe's iPhone.
Is there
That makes
any
sense.
acknowledgement anywhere
I
in
just
Mr.
wanna
DiSorga's
see
report that he appreciated that this was iPhone to iPhone rather than iPhone to infotainment?
No, there's not.
Did you ever receive any report from Mr. DiSorga that would alert that he appreciated that this was iPhone to iPhone and not iPhone to infotainment?
Objection, Your Honor.
Sustained.
That's asked and answered.
If we could go to the next slide, please. Is this a similar or different slide?
Sure. So this is a different slide.
Okay. If we can zoom in on the left box, please. Where does that box come from?
Sure. So again, that's coming from the same page of my report, just highlighting the 5:30 phone call, and this is comparing the iPhone.
Where does it explain on this, though, that the first 5 are iPhone to iPhone and the other ones are from the Lexus clock? Where does it explain that? Because it says forensic analysis identified a clock skew between O'Keefe's iPhone timestamps and Reed's infotainment timestamps with discrepancies ranging between 8 seconds and 16 to 21 seconds during the period from 5:21 to 5:30. So it just doesn't address anything from 1:14 to 5:04. Where does it say that, though? He's explaining it on the stand, but where would you get that information in this report?
From Mr. O'Keefe with the infotainment clock.
At that point, is the power on of the Lexus?
Yes. So at this point, the power is on. So this is a comparison of the infotainment clock with the iPhone clock at that time.
Could you zoom out? That final box that shows the comparison between the defendant's Lexus and Mr. O'Keefe's iPhone, do you have any concerns about the accuracy of that information for that time?
No, so I think those times are accurate, but again, that's at 5 o'clock in the morning when we're trying to adjust the clock variance, and it's too far away from the time in question. So if we zoom back in to the box, we can actually see in the data what I'm talking about as far as clock variance will change, with time. So the phone call at 5:21, we see an offset of around 8 seconds between the two devices, between the infotainment system and the iPhone. And then at 5:30, which is only 9 minutes later, we can see that offset has actually increased between 16 and 21.
In capturing this data,
That's wild.
were there phone calls between the infotainment system and Mr. O'Keefe's phone?
Yes, those last 2 phone calls were between the infotainment system, or were recorded by the infotainment system with Mr. O'Keefe's iPhone.
How does that happen?
Sure. So that's, when the device is connected up to the vehicle and you make a phone call, the call is recorded within the infotainment system and it's recorded with the infotainment system's timestamp.
Could you focus on the right-hand box, please? Did you review the right-hand box?
Yes, I did.
Was that from your report, or is that Mr. DiSorga's opinion?
That's Mr. DiSogra's.
Did you have any agreement with that?
Yes, so I do agree with that calculation, but again, that's 5 o'clock in the morning versus when we're really interested in around 12:30.
Can we have the next slide, please?
12:30 on which day?
Could we enlarge this? Do you know where this photograph came from?
Yes, so this screenshot came from Dr. Welcher's presentation.
When's the first time you saw this?
We haven't
screen?
seen that yet, but we will.
When I saw this presentation.
In Mr. DiSorga's report?
Correct, yes.
Had you seen this before that?
I had not seen this before that.
If we could focus in a little more, especially the bottom left hand. When you reviewed this, did you feel any need to do further testing?
Yes, I did.
Why?
So what we're looking at, if we zoom back out, so what that is the 12:23:38 is the approximate time that the text stream event occurred. Now, what we want to do is we want to be able to compare that to the 3-point turn from Mr. O'Keefe's iPhone. What you'll notice, though, is right here we've got a circled GPS point. So if we can zoom in there. So this circle here is actually circled GPS point 155, which is after this point, but we'll kind of ignore that. But GPS 154, and it's hard to see the time.
There was some confusion. A couple things. Pitbull Crew asked, John's phone wasn't connected to her car. Yes, that is precisely the point, because John O'Keefe's phone was on Waze. So they are pulling the difference between John O'Keefe's iPhone and Waze data and Karen Reed's car. And then the questions about if that's Welcher's PowerPoint, not DiSorga's. This is DiSorga's PowerPoint that is highlighting DiSorga's disagreement with Welcher's PowerPoint. So the witness on the stand is reviewing the slides from Welcher in DiSorga's PowerPoint because DiSorga is talking about Welcher's slides and Welcher did not talk about the time. So that's where we're at with the different data. So I'm going to back up to get to that question. Hopefully that makes sense.
GPS point. So if we can zoom in there. So this circle here is actually circled GPS point 155, which is after this point, but we'll kind of ignore that.
This is the 3-point turn, and they're talking about highlighting the different GPS points on the green circles are from DiSorga. The PowerPoint slides are from Welcher. And he's just like, well, just ignore that that's circled there.
But GPS 154, and it's hard to see, the time is 12:23:58. When we look at that, what we see is that actually that GPS position is recorded before the 3-point turn even starts.
You mentioned 154 begins recording before the 3-point
That's a fair point.
turn starts.
His point on that, which again might be lost if people are already tuned out on this witness, that point might get lost. It's fair. But the point he made was on the 3-point turn, there are GPS points going into the turn and then GPS points coming out of the turn. He's saying that the GPS point that they highlighted is going into the turn, not coming out of the turn. So it can't be the last point because it's the first point. Hopefully that makes sense.
Correct.
Is the end time of the 3-point turn a time before or after that 12:23:58?
Sure. So the end of the 3-point turn logically would be after this point.
At the time you saw the slide, had you broken down point 154?
No, not at the time that I saw this slide.
CC
Could you
Streetlights
zoom
or
back
C
out a little
Streetlights in the chat asked,
Please.
was John's phone Bluetooth to
The
infotainment
information
while
in
on
the right
Waze?
box, is that from you or from
No
Mr.
one has said that it
DiSorga?
was.
That is not from me.
And when you read that, did that compel you to want to do anything?
Yes, it did. So again, my initial thought was to address this during testimony. With further review and further thought,
Josh H said, so how does John's phone time sync up with Waze's clock? That was all during Whiffin's testimony. So Whiffin addressed that pretty early on, 4 weeks ago. But yes, that was addressed on Waze data vis-a-vis the other systems in the iPhone.
I decided it was best to offer a supplemental report. What this is, basically the math I agree with. The point I don't agree with is that GPS 154 is the time towards the end of the 3-point turn. And now reviewing further data, we know that's not true.
The 12/23/58
So they are
event
disagreeing
on the phone, is that
They are
related?
disagreeing with the data point. The witness is saying the defense expert has pinned that location data point as the end of the 3-point turn, not the beginning of the 3-point turn, which then shifts the timeline on the defense end. If you say this is John being done with the 3-point turn, it would shrink the window of variance because it shows the car being done and the phone being done closer in time, because in fact, the car's done with the 3-point turn, but the phone is just starting the 3-point turn. So it shortens the time versus expanding the time. So it is a battle of the experts between which data points are accurate for that phone variance. And it's going to come down to who the jury believes. And if the jury's already out on this witness, then they're out. If the jury thinks the defense is being hypercritical of who cares what's on LinkedIn, then the jury might not be out. Or maybe they're out with the typos, or maybe they're out with the bits and the bytes, or maybe they're not. But those are the data point issues that they're fighting.
Related to the first event, the 3-point turn, or the second event, the backing maneuver?
So that's going to be related.
Was there any
That was
other
the feed, not
data
you.
that was closer in time to the to the backing event that you had access to?
No, not that we had access to.
We can turn to the next slide, please. You've seen this part of the report before?
Yes, I have.
Having seen the
The
earlier
microphone
part of the
just
report,
keeps getting
does it help you
abused.
explain and understand this diagram?
Yes, it does.
Is this your diagram or Mr. DiSorga's?
This is Mr. DiSogra's.
Do you agree with this diagram?
No, I do not.
Okay, could you explain to us what this, from your perspective, from your experience, what this chart is trying to suggest?
Sure. So this chart is trying to suggest that the lock event always occurs after the end of the text stream event. And again, that's using inaccurate adjustments to make that conclusion.
I want you to use the pointer, and I want you to take us line by line why you believe that this is inaccurate in trying to conclude the time of those locking adjustments.
Sure. So it's kind of hard to tell. So what we've got is we've actually got two different sections. So we've got the top section,
The
which
feed
is
froze.
1, 2, 3, 4, 6 events.
Which is real frustrating.
So that's going to be the GPS event, and those. Let's see, no, that's going to be this.
Come
it's
on,
hard to
feed.
say. That's
Come on, feed.
going to be the phone calls
Bring it back,
and the
bring it
GPS
back, bring
event
it back.
that are calculated in this, and it's also done with the 3-second
wait.
delay as well, adjusted. But what we see is, so this obviously +1 is one of the phone calls that was from
There it is.
the defendant's iPhone time.
Woohoo! This is going through the defense exhibit, which the defense asked about on cross, so it's coming up on redirect, and talking about the key on and then the vehicle events, and then John's phone. And there's a lot of different variances in that from 45 seconds down to 5.
So not from the infotainment system. So that's a inaccurate comparison. Same thing for the +2, the +1, the +2 again, the +8, the +16, and the +20 are going to be those last two calls. If you'll notice, the very last call, we can't really tell which phone call is the correct one to compare, so we're using both within that same time frame. And that's why we get the 16 or the 21-second variance. But again, that's 5 o'clock in the morning, so that's not appropriate for the time that we were interested in. And then the 20-second variance is coming from that inaccurate GPS position comparison.
Could we enlarge that a little bit, Ms. Gilman? On the 2021, is that plus or minus 21?
So
Right.
that is -21.
Right.
The 20 and 21, is that based on different information than the 1, 2, and 8?
Yes, it is.
And explain again for us, where's the different source of the information?
Sure. So the -20 is coming from that GPS point 154, which we know is not the end of the three-point turn. It's, right before the three-point turn begins. And the -21 is coming from the last phone call that happens around 5:20, I believe, or 5:30. And again, that's 5 hours after the time of interest.
The -20 and -21, is that suggesting that time should be taken off or put onto Mr. O'Keefe's phone for synchronization?
Sure. So that's suggesting that time should be. I'd have to go back to the other slides. I believe that's either way. It's suggesting that the iPhone lock event occurs +6 or +5 seconds after the end of the text stream event.
Besides not accommodating for the timing of that timestamp at the beginning of the three-point turn, is there anything else about this that concerns you?
No, just that overall, these numbers can be misleading, again, because they're based on inaccurate adjustments, and could lead, again, the jury to believe that the lock event always happens after the end of the text stream event.
Could we go to the last page of Mr. DiSorga's report?
So we're moving to the last page.
Is
The
this
defense.
a conclusion offered by Mr. DiSorga?
Yes, it is.
Did you agree with that?
No, I did not.
Why not?
So based on those inaccurate adjustments, this slide is again kind of misleading in the fact that it states there's always interaction with Mr. O'Keefe's phone after the end of the text stream event.
You can take that down and turn that off, please, for a moment. After reviewing this report, you told us you then engaged in further study for synchronization.
Yes, I did.
Did you call me on May 7th?
Yes.
Okay. And what were you told to do about a report?
Oh boy.
On May 7th?
Yeah.
Yes.
Sure. So that was finish the report and submit it.
Did you?
I did.
And when did you submit it?
May 8th.
And do you know that it was provided to the defense by email on May 8th?
He doesn't know that.
Do you know if it was provided to the defense?
He doesn't.
Yes, I know it was provided. I don't know when.
Well, he knows it was provided because they were questioning about it quite a lot.
Now, if we could have
The
Mr.
timeline.
Burgess's PowerPoint. Go back to page 38, please.
I'm very interested to see what and how we get to this. Andrew D'Angelo in the chat says, speaking of brains, I had emergency brain cancer
After
surgery
you
several weeks
explain to
ago.
us-
Andrew, that's much. I am now doing radiation and chemo. This trial and your commentary, Emily, has been a pleasure while I recover. Andrew, speedy recovery and well wishes. We have had many in the law nerd community who have battled and won, and I am glad that you are among them and will continue to be, because I've seen lots of comments today of people who are hanging with us while they recover. So speedy recovery to you. And on that, Lady Picture Show, Said started chemo during the first retrial. Now during the second, I got the best news. Cancer-free. Congratulations, Lady Picture Show. Thanks for sticking with me through it all. EDB and Law Nerds. Sickness to health. You're the best. We're here. We're here. Day in, day out. We're here. The Law Nerds, even when it's painful, we're still here. And we needed a moment to just say, y'all have got this. And this witness is, well, it's really going to depend on the jury. If the jury thinks that the defense is being hypercritical or, overwrought, they might see it differently. They might say, okay, well, I don't really care about the LinkedIn stuff, but the timing stuff makes sense. This witness explained it very well, why he did the things he did. It wasn't all in his report, though. And there are errors in the report. Though, with the errors in the report, he was not evasive about it at all. He's like, yeah, no, that was an error. That was my error. It's going to depend on how the jury reads it. And I think having Alessi do those crosses is a solid strategy. So let's continue on the timing of the clock variance.
Objection, Your Honor. Can we close this on scope?
We are deep in the weeds on clock variance. Emily, you should have done that while they approached. Yep, sure should have. Keep reading, Emily. Keep reading. Because you never know what the jury is thinking. They will read things differently often than we will. Most of us have more information than they do, especially after the first trial, which is hard. Yeah, that is... Do they come back on the record and excuse the jury? They might. Because it looks like they are still at... Okay. I think they go to lunch. I heard the audio go back on for a second. I think they go to lunch. I'm pretty sure they go to lunch. Hold on. They go to sidebar and then it's like, lunch is here. Yep, that has to be lunch. All right. That has to be lunch. It's lunch. It's log. It's log. No, Emily, it's lunch. It's lunch. It's lunch. So they're not back yet. We are on real time. The jury is still out. I need lunch. Do y'all need lunch? I need lunch. Good Lord, this morning. Oh boy. Oh boy. Oh boy. Today was spicy, Law Nerds. It was an interesting lunch. I'm glad we had time to add some more things to the soundboard. I'm exhausted. How about you? But then again, I well overslept, so I don't even think I'm awake yet. I don't know what's happening today. It's a very Monday, Tuesday. We're at lunch. The Commonwealth's expert is still on the stand on redirect. There was a lot more cross to go. I think Alessi was incredibly productive on his cross-examination of this witness. And we learned again that when it came to the trigger information or the infotainment information or the text stream information, which are all synonymous, that this expert didn't have the raw data. He pulled the text stream information from Dr. Welcher's report. We still don't have a full explanation then of how they attributed the log events 1162.1 and 1162.2 to the different on-off of the car. We haven't heard how those have been attributed yet. Welcher might do that, but the reason this witness is testifying first is because this witness is the one who Welcher bases all the tech timing off of. So in redirect, as we thought he might, Brennan started with, you don't really need a degree to do the work that you do. You have certificates, and you've never said to anyone in court that you have a degree that you don't have. And this is what it says on your CV that you provided to the court, which said in progress. Different than what the company website and stuff says. And Brennan asked, when did you write your LinkedIn? The guy's like, well, like 10 years ago. Okay, well, when did you write the CV for court? No, he didn't ask that. He asked, did you write the website for your company? No. Did you have any input on that? No. Do you know how many people are at your company on the website? And he said maybe 100 with 15 different offices for Aperture. Seems like a lot. But he said he didn't do any of the stuff that is on Aperture's website, and that his LinkedIn was done over 10 years ago and he hadn't updated it. And in all of his time testifying, this has never come up. In the 10 years he's worked for Aperture, this has never come up. I would imagine most expert witnesses would beg to differ that their LinkedIn and the way they hold out their professional credentials doesn't come up, but he says it's never come up. How the jury will take that information depends. If they think that the defense is being hypercritical about it, they might be like, well, the one he gave the court is accurate, and he didn't tell us that he had that degree. And he says he doesn't need the degree for his opinions. So they might disregard it. They might not. I think I'm going to be more critical of it just because this is the field that I work in. And so I have a baseline that's different than an average juror. My baseline comes from being a lawyer and being in court quite a lot and watching more cases than that. It's wild to me. But jurors who might have never served on a jury before and don't really watch this might be like, I mean, okay. The one he submitted to the court's accurate. So I don't see it as a big deal. They might not. For me, if it was just the resume, I might be less critical. The resume is wild. But then you get to the issues with the bits and bytes, and then we get to the raw data not being evaluated. And there's a lot of questions. But on redirect, Brennan is bringing up, okay, well, why do you disagree with the way that the defense experts interpreting this data and where they're interpreting the data? And I think that testimony has been pretty clear. Whether the jury agrees with it or not is different. But I think the testimony with the redirect has come in clearly in a way that makes sense. He said, look, the defense expert is trying to align the clocks or correlate the clocks after 5:30 in the morning, and the information taken from the SUV's infotainment system when the car was off is just importing data from Karen Reed's iPhone. So that variance is going to be 1 to 2 seconds from John O'Keefe's iPhone. Okay. But his report just has it on a chart. The chart that we've seen, and maybe it's elsewhere in his report, the chart that we've seen doesn't note that that's what the differential is. So it's confusing information on its face. And yes, he's trying to explain it, but it's not there. It's just a bunch of data, and it's titled as infotainment system. And where we haven't gotten to in redirect that came up quite a lot in the rest of cross this morning was that this witness with all confidence said that the timeline that he presented in court was accurate to the second. And the timeline shows from January 29th in the evening through overnight midnight to January 30th. And that is not the correct timeline. And he said, no, this happened January 30th. Well, January 30th, the SUV would have been sitting in Canton PD and John O'Keefe's phone wouldn't be doing anything. So we haven't even addressed that yet. But on all of the slides that were shown yesterday, and if you go back and watch yesterday, you will see that they show the timeline on the bottom of those slides a little bit, and then the Commonwealth zooms in to the videos that are correlated with that slide. The videos, it's all in evidence that those videos that are being shown came from January 29th, not January 30th. But when you are asking a jury to trust an expert, when it comes down to seconds, when is it too many errors for a jury to rely on that? When? And not having the date right seems like we are not paying close attention to the details. And Alessi did I think, a good job of pointing out how much the details matter when you are dealing with seconds. And again, why does this testimony matter? Well, for the Commonwealth, it's the basis of when they say Karen Read hit John O'Keefe with her car. And for the defense, it's the basis of where they say John O'Keefe's phone was still moving after the text stream data shows a backing up event. Therefore, at that time, John O'Keefe was not hit by a car because he was still interacting with his phone. And the injuries that he had would not allow him to be interacting with his phone. So if the injuries came from the vehicle, then how is he still on his phone? Because the time is different. So it is up to the Commonwealth to narrow in that timeline in a way that the jury finds reliable. The defense can say, how can you rely on this? And if they can't show you when the timeline is accurate, or if there are two reasonable explanations, could be this, then the jury's told they have to pick the reasonable explanation that points towards not guilty, because the reasonableness goes to the heart of beyond a reasonable doubt. If there are no other explanations than this happened the way the Commonwealth said, then reasonable doubt loop has been closed. But if there are multiple reasonable explanations, then that reasonable doubt loop hasn't been closed. And the defense has been much more, I think, laser focused this trial on reasonable doubt versus the last trial. And the Commonwealth is trying to narrow in this case and the contradictions. There's a lot the jury does not know. There's a lot of witnesses that were called first trial that aren't called yet. And though we know it, if we've watched the trial before, the jury doesn't know it. So the jury, I'm sure, is sitting there still trying to piece together a timeline because they now have some vague idea that this 1162 is a backup event that may have been when this happened. And the jury, I'm sure, is sitting there still trying to piece it together because the puzzle's not clear to them yet. But on day 19 of trial, shouldn't the puzzle be more clear? So when are we going to get to Welcher's testimony? Because we've heard a lot about it today. And the Commonwealth seemed to indicate Welcher's testimony might be next week. So we got a long way to go. So who's the witness they call after this? Because it sounds like it's not going to be Welcher. Is it going to be the medical experts? It might be. It might be. The rest of today is going to be very interesting. But remember, the way we see things with the information that we have and the way the jury may see things can differ. And there's a long way left to go in this trial. But this witness has said, I never said on the stand I had a degree. I never represented that in any court. And this is how I parse the data. I find the explanation about the data more clear than I did last trial, but that's going to come down to how reliable this witness is viewed. And it's going to be interesting to see how the defense expert that's going to talk about the same issue, DiSorga, I think, because it's been pronounced like 17 different ways in court, how those two things go together. Because the tech timeline is between this witness that's testifying today and the defense witness DiSorga. The accident reconstruction is going to be between Welcher from Aperture and Wolf and Rentschler from ARCA. I can't believe we are 19 days in and we've got a long way to go. But also the Commonwealth's getting towards the end of their case. And it seems more and more like they are not going to call any more civilian witnesses, which means they might not call the Aruba witnesses either. They might not call anyone else that was at 34 Fairview. They might not call, and it seems more and more likely that they won't call Proctor or Tully or Higgins or anyone that lives at 34 Fairview. And I think that leaves a huge door open for the defense to argue, what hasn't the Commonwealth shown you? And why? Because they've heard these names over and over and over again. And is that enough for them to argue doubt to the jury? What is the Commonwealth not telling you? And why? We're going to have to see how it plays out, law nerds. We're going to have to see. We're going to have to see. But for now, what happened? I was trying to gavel. Where'd my gavels go? There they are. It's time for lunch. It's time for lunch. The law nerds need lunch. Emily needs lunch. I need lunch. Lunch is needed. Court is just coming back. So we're going to be, I'm going to try to be 5 minutes to go grab some food and bring it back. While I go grab some food, y'all can stay here. Y'all can get the Law Nerd app so you know when I'm back live. I'm going to be as quickly as I can. I'm going to put, Miguelina, will you put it up for 10 minutes? I'm going to try to do it in 5. But I need to go check in with T because T has been dying to tell me something. And I need to let him tell me what he wants to tell me. And then check my weather coming in. We will go through questions as best we can as we get back into the afternoon. This might be the last witness today. It might not. I think it's probably likely it might be the last witness today. So let's see. We are at 105 Central. I will be back by 1:15 at the latest. I might be back sooner. Don't worry. You'll hear this when I'm coming back. So if you're listening in the background, this will let you know. If you have the Law Nerd app, we'll also send an app notification. I've got to grab some more food and see you back here in just a moment. In just a moment, because, well, I want to see how the rest of this goes, but I also want a little zoom room. Just a little, because they're going to keep approaching. We're going to need that zoom room, I promise. So, law nerds, hydrate, move your laundry. Answer that email you've been putting off. You've got 10 minutes. Set a timer. Everybody ready to go. I'll see you in a few. It's time to go. Let's boogie.
Hey Law Nerd, court is still on break, but don't forget to download the Law Nerd app so you know exactly when we're back from break, and you can get a notification from us when witnesses take the stand that you've been waiting for, when something unexpected happens in court, and during verdict watch. The Law Nerd app has all of your live court notifications to keep you in the loop. LawNerdApp.com, free for iOS and Android. And while we're on break, don't forget to hydrate, get up and stretch, and take care of yourself. Trial days are long days. trying to stay in the loop with this trial? I know sometimes it's hard if you miss a day. That's why I've got daily case briefs dropping over on the Emily Show YouTube channel and the Emily Show audio feed on your favorite podcast app, so you can stay in the loop even when things get busy. Are we ready, chat? I'm ready. Are you ready? I think we're ready to go back to court. We're ready for a weather day. I'm like, did you throw your hair up in your hat? Yeah, it'll probably be down again in a minute. But it's just, I got to get the in-ears in. And there's like hair and hat and glasses and ears and head, shoulders, knees, and toes. Are we ready to go back to court? Yes. T says hi. We were talking about packing. Why? Because we get on a plane for him to leave for the entirety of the summer in just a few days, and we had lots to discuss. So it's busy. It's busy around household baker for the next few weeks. This week, particular and more than most. So let's get back to court, shall we? Let's get back to court. I'm interested to see if we're done with this witness today. I'm interested to see if we ever address that timeline on the bottom there. So let's see if we do or if we don't. Because, well, the jury had some food, and they're back into timelines and variance. Variance. Ray of Sunset, are you prepared for him to be gone? No. But I'm really excited for him. So, I'll get to see him a couple times throughout the time that he's gone, so it'll be fine. It's just, it's all the things. I'm excited for him, but I'm also just like, but also I'm excited for him. So, all the things. It's an adventure at every stage, parenting. Just adventures. But I love band, so I'm ready. Let's go back to court, shall we? Shall we? Yes, we should. Yes, we should.
Sir, when I asked you about your first report regarding the protocol, you told us October 10th, followed by your supplement on the 17th. You did not remember the day that you first received any information offered by Mr. DiSorga. Is there a document that may refresh your memory?
Yes, there is.
Sounds like there's fans in the courtroom. It is just, the sound is just coming in hot after lunch.
Approach.
Yes.
Thank you, Mr.
I don't want you to read this. I just want you to look at it. You can look at any part of it.
This is getting into
And
when that report
look
was
up when
turned
you're done,
over.
then I'll ask you a question.
Okay.
So we are still on redirect with the prosecution after lunch. And that's where we're at.
Does that refresh your memory the first time that you saw any information provided by Mr. DiSorga?
Yes, it does.
And when was that?
November 7th of 2024.
Before or after you recognized the megabyte oversight?
That would be after.
I want to go back to where we were at before we went to lunch.
The timing
You
on
had
that
described
seems accurate.
two text stream events. I want to focus
Okay.
on the first text stream event, and that is the text stream event relative to the three-point
Does it change the error? No, but
Okay.
does it change that he
You had
caught the error on his
described that
own?
there was a timestamp 154. Just to reacquaint us, can you very briefly tell us the significance of 154?
Sure. So GPS point 154 is a GPS point that occurs just before the three-point turn starts.
And why is it important to identify when that turn starts and when it ends?
Sure. So what we're specifically looking at comparing
okay.
is the end
Sound.
of the three-point turn. That's going to be the text stream event ending, which is near the end of the three-point turn, as well as the end of the three-point turn as recorded in Mr. O'Keefe's iPhone.
Was it important to identify the beginning and end of that event to come to a conclusion to a reasonable degree of scientific certainty regarding the variance between the text stream data and Mr. O'Keefe's phone?
Yes, there was. So we can't say, we can pinpoint approximately when the three-point turn ends based on the GPS data. But best practice would be to use a range of time. So the range we're using is the time that the three-point turn starts to the time that the three-point turn ends.
Could we have
Approximately?
from Mr. Burgess's PowerPoint number 41,
He
please?
keeps saying approximately and exactly as if they're synonymous, and they're really well not fucking synonymous.
Is this part of your presentation helpful in explaining the beginning and end point of that three-point turn?
It does. It does. So if you look at, and if you recall yesterday, the heading change, first heading change from a general north heading is depicted by that green shading circle.
Could you use your pointer, please?
Sure, yes.
Ms. Gilman, can you enlarge just a little bit?
So again, this green circle is going to be the center of this circle is going to be the GPS point itself. That's going to be centered on the horizontal radius, which is the accuracy. So the green circle represents the 16-foot accuracy zone. The black arrow coming off in a northwestern direction is
the way the
going
phone's
to be
pointing?
the heading for that point.
Okay.
And then again, the yellow is going to be the approximately 8 seconds later when the heading changes again in a southerly direction, and then the GPS points after that also continue south with increasing speed.
What part of the three-point turn event does the green circle signify?
Sure, so that's going to be the approximate beginning of the three-point turn.
And that time?
That's going to be 12:23:59.
The yellow circle, what part of the three-point turn does that indicate?
Sure, so that's going to be approximately the end of the three-point turn, and that time is going to be 12:24:07.
Is there any correlation between the times in the green, the time difference between the green and yellow circle, and the range you ultimately arrive at as far as the synchronization variance?
Yes, so that is what determines that range of 21 to 29 seconds.
This
That's not
illustration
clear.
or diagram where you've put the green circle, is that based on actual data?
Yes, that is based on actual data recorded by Mr. O'Keefe's iPhone.
That data, is it
Actual data.
accurately
What?
reflected in this diagram?
Yes, it is. So again, the GPS point that is recorded within the iPhone, every point has a horizontal accuracy. And again, that horizontal accuracy is depicted by the green circle.
Is that level of precision used when you create this diagram?
Yes, it is.
The yellow circle, is that specifically reflected in the data, or is that an estimate?
Sure. So that's specifically reflected in the data. So that is another GPS position that has been recorded by the iPhone. Again, with a horizontal accuracy, a timestamp, and a speed and heading.
How about the orange circles?
So the orange circles are are portions of the GPS positions leading up to this event. So if
They look
we
red to me, but orange red.
went back one
Sure.
slide, you would see, it would zoom out obviously, so a little bit harder to see. But essentially, what we've done is I've removed the other orange circles representing GPS points heading north, and the GPS points heading south after the 3-point turn. And I've just removed those for clarity to kind of clean up the map so it's easier to read.
On the left, text stream 11621. Remind us again where that information comes from?
Sure. So that's the text stream. That's the end of the text stream event for the 3-point turn. And that is based on the infotainment clock as well as that running timer from the airbag control module.
Does this diagram reflect the data that you reviewed to a reasonable degree of scientific certainty?
Yes, it
Going
does.
over his opinion again, or one of them. There were numerous.
In breaking down this timestamp 154 and getting into the minute detail of when it started and ended, one of your charts, does it also show it numerically?
Yes, it does.
Can we have number 40, please? Before we discuss this again, where did you get the information to put in this chart?
Sure. So this is coming from Mr. O'Keefe's iPhone. Specifically, it's coming from a SQLite database that is recording locations.
We've heard lots about the
as he's
SQLite
using the Waze
databases,
app
haven't
to
we?
navigate.
Is the information in this chalk or diagram directly from the data?
It is directly from the data.
Is this accurate to a reasonable degree of scientific certainty?
Yes, it is.
If we could zoom in just a little, we'll have to go left to right, Ms. Gilman. We start with the left. Timestamp 154. At what point in that 3-point turn does 154 represent on the left?
Yeah. So timestamp 12:23:58 or GPS point 154 is approximately 1 second before we see the heading change. If we could zoom out just a little
And
bit.
we've seen this before.
A little bit more. Yep. So we see the heading change represented in green. That's a heading change to 284. Before that, we've got a pretty consistent heading of 348 to 339. So that first heading change, as well as the drop in speeds, is indicative of a 3-point turn maneuver.
The latitude and longitude, did that assist you in making the diagram with the circles on it?
Yes, it did.
How so?
So the latitude and longitude are the center points for each GPS point, or the center point for each circle.
Well, at least the colors match.
There's a green highlighted row and an orange highlighted row. What's the difference between the two?
Sure. So the green highlighted row is, again, the beginning, the approximate beginning of the 3-point turn. And the orange or the yellow is the approximate end of the 3-point turn.
Okay.
And the time between the green and the orange lines?
Approximately 8 seconds.
Is that consistent with the range that you've shown for synchronization?
Yes, it is.
Point 21 or plus 21 and plus 29?
Yes, it is.
The inevitable variance that you found between the text stream data
Inevitable's
and
argumentative.
between Mr. O'Keefe's cell phone, could you share with us to a reasonable degree of scientific certainty what that variance is?
Objection, Your Honor.
Sustained.
Do you have an opinion about the time range and the synchronization between Mr. O'Keefe's cell phone data and the Lexus clock that shows the text stream data to a reasonable degree of scientific certainty?
Objection, Your Honor, and appreciate an approach at the appropriate time.
Okay, so answer that question, yes or no.
Sure. So yes, I can.
So I'll see you inside, by the way, Mr. Wilson.
Thank you, Your Honor.
And they approach. I appreciate the Alessi reads the room with this judge and says, I would like to approach when it's an appropriate time. He knows, oh boy, let's zoom past the all of the things, because, well, we're at all of the things. That is a long sidebar. All right.
We go back to.
I'm trying not to zoom beyond the sidebar, but that was a long sidebar. All right. I think we're going to get back to all the paper
Go back
kerfuffling.
to slide 40, please. In reaching your conclusion about the variance between the defendant's Lexus as contained in the text stream, as it relates to Mr. O'Keefe's
Text stream doesn't have a clock.
iPhone, was stamp 154, timestamp 154, part of your analysis?
Yes, it was part of my analysis.
Was the running clock on the text stream data part of your analysis?
Yes, it was part of my analysis.
What else was part of your analysis?
Sure. So in addition to the location data, including the GPS 154, that would be the running clock for the text stream data, as well as the infotainment clock from the Lexus.
How does the running clock correlate with the text stream data and with the time on Mr. O'Keefe's iPhone?
I'm looking
Sure.
for something
So
on my desk. I
they
can't
correlate.
find.
So the running clock and the infotainment clock are used to create that timestamp for the text stream events 1 and 2. And then comparing those to the iPhone, we can adjust and get a clock variance for those.
Did you come to a conclusion to a reasonable degree of scientific certainty about the variance range between the defendant's Lexus and its clock system and Mr. O'Keefe's
He
phone?
said he did.
Yes, I did.
And to a reasonable degree of scientific certainty, what is that variance that is needed to identify for synchronization?
Oh,
That is 21 to 29 seconds.
And we've heard that opinion
Now have
before.
number 43.
And we're doing it all again. Just all of it. Okay.
Did you create this diagram?
I did, yes.
When comparing the text stream event, the backing maneuver, to Mr. O'Keefe's clock on his phone, do you recognize the different timestamps on each device?
Yes, I do.
When you are trying to synchronize them, what do you do? What is the base? Do you start with the text stream event and you add, or do you start with Mr. O'Keefe's phone and subtract?
Sure. So we could do it either way. Because we're wanting to compare this against other events that happened or occurred on Mr. O'Keefe's phone, we're going to adjust the text stream clock or the Lexus clock to Mr. O'Keefe's clock. But you could do it either way.
The window that is depicted on this diagram, this is not the three-point turn?
No, this is not the three-point turn.
Which event is this?
This is going to be the backing maneuver.
The green, what does that green depict?
Sure. So the green depicts the range of time that this text stream event ended. So based on our range of 21 to 29 seconds, and applying that, adding that to the Lexus.
Did you just put it right over the date? It is so hard to read.
Clock, we get a adjusted time of 12:32:04 to 12:32:12, and that's going to be the approximate end time of text stream event 11:62:2.
Now again, the text stream data has a limit on the amount of time available?
Can you rephrase your question? So I
You said
understand.
a window is captured during a triggering event.
Sure, yes. So there is a window that's captured during the triggering event.
And what is that window? How much time?
Sure, so from the text stream trigger, there's 5 seconds before and 5 seconds after.
Can an event be longer than that 10-second window?
Yes, it can.
And in this case, do you know at the end of this reconciled event at 12:32:12, do you know from your study what direction the defendant's car was traveling at 12:32:12?
It would have been traveling in reverse.
And at 12:32:12, do you know how fast
How do you know?
the defendant's Lexus was traveling at 12:32:12?
I do not recall.
Mr. O'Keefe's last user
How do you know?
interaction with his phone at 12:32:09. Where does that fall within the 10-second window that was captured by the text stream data?
Sure, so that falls within that 8-second window. So again, the text stream event ends somewhere between 12:32:04 and 12:32:12. But that does not represent that the backing maneuver has ended. Just the recorded data has ended.
And in your review, do you have, around this time, any other movement of Mr. O'Keefe's phone after 12:32:16?
I did not look at that specifically. It was my understanding that Mr. Whiffin looked at that.
To a reasonable degree of scientific certainty, did both these events, the last user interaction and the window captured on the reconciled data for the text stream, happen around the same time?
Yes, they did.
I have no further questions.
Okay. That's the end of redirect.
Or I can approach later or now.
So we can approach again for me.
Didn't ask about the date at all. Didn't ask about it once. Didn't ask about the date on the bottom. Overlooked it like, ugh, whatever. Didn't even address it. All right, let me make a note. And then let's zoom. Okay. I have to imagine that Brennan, sitting in court, was looking at the jury and decided that it wasn't relevant to ask for him, which is possible. We're going to zoom past this sidebar if we can. If we run out of space, then we do, because this is a longer sidebar before this witness is off the stand. There's been a couple of longer sidebars today. There we go. All right. Oh, we're not done.
Your Honor,
One more question, it seems.
I move into evidence the following pages from Mr. Burgess's PowerPoint presentation. Move into evidence page 41. I move into evidence page 40. And I move into evidence page 43.
Okay, allowed.
All right. So those pages are being moved into evidence
Thank you.
of Burgess's report. Those are going to get marked.
Once we get these marked, I'll be.
Those are getting marked. I'm going to let those get marked. They can't put anything on the record while the court reporter is marking these.
Thank you, Your Honor.
So those are getting marked. And we should be getting to recross. There we go.
Mr. Burgess, between the time you left the witness stand yesterday until this
Sir, what else has been going on?
moment, have you talked to anyone about this case?
No, sir, I have not.
Has a filing ever been made in any court in which your educational background has been misrepresented?
No, not that I'm aware of.
Pardon me?
Not that I'm aware of.
Color me
Did
curious.
I understand that you're based out of the Aperture office in Texas?
Yes, I am.
And are you aware of a case in the United States District Court, Eastern District of Texas, Marshall Division, titled Jeffrey Glover and Teresa Glover versus Graphic Packaging International, LLC? Are you familiar with that case?
Yes, I am.
And is it correct that in that case, well, tell me how you are participating in that case, sir?
So I'm no longer participating in that case. So if I believe correctly, that would have been a accident reconstruction case from, I don't recall, a year or two ago.
And so it was a case that you did participate in, correct?
Yes, I did.
And what was your role in that case?
Sure. So my role in that case was an accident reconstructionist.
What?
And
What? Wait, what? You've said specifically you're not an accident reconstructionist. What?
did you provide any testimony, deposition, or otherwise in that case?
No, I did not.
Did you,
A report?
in that particular case, there were, like all cases, filings made, correct?
I'm sure there were, yes.
Isn't that outside your scope? Something is going to be shown to Brennan before it comes up with this witness. Emily, we're not zooming. No. No, I'm very curious how this is all going to play out.
May I approach, Your Honor?
Yes.
I would like to have a document marked as the next exhibit for identification,
Okay.
please.
Exhibit EEE for ID.
Exhibit
May I present to the witness, Your Honor?
Yes.
Thank you.
for identification.
Mr. Burgess, I am showing you a document which has been marked as Exhibit EEE for identification, and I'd ask that you take a look at it, sir. Your Honor, may I remain here?
Sure. As
Thank
long
you.
as you stand back a little bit.
Exactly.
As
yes.
long as the
Thank
jury
you.
can see the witness.
Farther.
Yes, and after EEE, we go to FFF. Uh-huh. You were correct, chat. When we get from E to F, we'll see.
Yes.
All right, what is it?
Mr. Burgess,
This one piece of hair does not want to cooperate. Get out. Go that way.
with regard to Exhibit EEE, do you recognize the second page, and do you recognize any stamping at the top of each of those pages?
Yes, I do.
And can you describe what that stamping is?
Sure. So that is stamping for a file date of 8/7/2023.
And is that a stamping of a federal court?
I don't know if he would know that.
That I'm not sure.
Yeah, I don't know if he would know that.
If I were to show you a document, might a document refresh your recollection as to whether
Sure.
That looks like an exhibit.
Exhibit EEE is a filing in a federal court.
That's an exhibit to a filing.
May I, Your Honor?
Sure.
I am showing you,
Did you show those to Mr. Brennan?
thank you, Your Honor.
I mean, Brennan has
I
access
believe
to
I did, but I want to make
And
sure.
just let me know if we need to move.
We will, Your Honor.
It's going to be FFF.
Can I mark each of
Yes.
these for identification? They're,
Yep.
let me just give one first.
All right, they're marking 2 for identification.
For that.
I'm going to just zoom as they're marking because I can't. Why? Because I have no chill.
Exhibit FFF right here.
Thank you.
Can I reach over you, sir?
Yes.
Exhibit F,
Thank you.
F.
Sir, I am showing you what has been marked as Exhibit FFF
FFF.
for identification and ask whether or not this document can refresh your recollection as to whether the court filing that you reviewed in Exhibit EEE is indeed a federal court.
Yes, it is.
So that document refreshes your recollection that what has been filed as represented in EEE is a filing in a federal court, correct, sir?
Correct.
Now, what I'd like to do is to draw your attention
We got to move the closed
to
captions.
the,
I want to see the judge's face. I feel like so does the cameraman. Like, I feel like everybody just wants to see what's going to happen. Let's see. These are filings.
second page of this exhibit. Is that a curriculum vitae of you and a picture of you?
Yes, it is.
And sir, under education,
Objection.
I would,
The objection's stayed.
right. Do you,
Do you want to bring it over? We can take
I
it
will,
there.
Your Honor. I will.
Jurors, feel free to stand up and stretch.
Jurors, feel free to stretch. Lawnards, feel free to stretch. Let's see if we can zoom past this sidebar. It looks like where we are getting to is a CV filed as an exhibit in federal court in 2023 that is a CV. I guess we will see what the CV in federal court says. Emily, do you also have access to Pacer? Yeah, I do. But I'm waiting for them to tell me in court what is happening.
I'm going to have to get a little closer in proximity. Bear with me, please. What I would like to do, sir, is
It was asked if he had ever misrepresented his education in court. So, is this a CV filed in federal court? The question will then naturally be for me, did he provide that CV to an attorney or did an attorney grab it off of a website? And what does the CV say?
to put before you again Exhibit FF for identification and Exhibit EE for identification. And what I would like to do is to ask you some questions, sir, with regard to the process in the case.
Okay.
Are you aware, or do you recall in this litigation that, as typical in litigation, including federal courts, that as part of the litigation process, the parties have to designate their expert witnesses? Are you aware generally of that process?
Generally, yes.
Yes. And have you participated in the documents that need to be prepared for an attorney or a party to prepare documents and submit them to a court to establish the designation of expert witnesses?
No, I have not.
And so you have never participated or never been aware of a process
He's
like
probably
this?
just
No, I'm
asked.
aware of a process, and that process goes through other staff members
Okay, so it goes through other staff members where?
at Aperture.
Correct.
Correct.
Are you aware that that process is occurring, even though it may be done by other staff at Aperture?
Yes, I am.
And in this instance, you were aware in this litigation that staff at Aperture needed to submit documents in support of an expert witness designation, correct? Even though you may not have done it yourself, you were aware that some person or persons at Aperture were performing that process, correct?
Correct.
And they were performing that process so that
he
you
doesn't send
could
the
be
paperwork.
designated as an expert witness in that case, correct?
Correct.
And so you were aware of the process, you were aware they had to submit documents that would establish your qualifications as an expert in the case so that you could be designated as an expert witness, correct?
Correct.
And now specifically with regard to Exhibit EEE for identification with these court filings, etc. Even though you may not have done it yourself, were you aware that this document, which is EEE, was submitted as part of the expert designation process we were talking about?
Not this specific document, no.
Were you aware that a CV was needed to be submitted on your behalf as part of the designation process?
Yes.
So you were aware a CV had to be submitted, but you're saying you don't recall this specific one being submitted?
Correct.
Does the timestamp up at the top of each page of Exhibit EEE, including this page that is your CV, match the timestamp, or is it different from the timestamp at the top of Exhibit FFF?
No, that is the same.
So it's exactly
Is
the
his
same.
brain just
Yes.
going
And have
FFF
you
right
been
now?
involved in processes in courts where your qualifications, including your CV, have had to be submitted to courts to establish a designation as an expert witness?
Yes.
And can you conclude from these documents, including the timestamps, that the submission that was made to the court to establish your status and as an expert witness consisted of exhibits FFF and EEE?
Objection.
I'm going to allow that. Were you aware of that?
Yes.
Your Honor, at this point, I move EEE and FFF into evidence.
Yeah.
You need one more step, Mr.
And, sir,
He's laying foundation for
Do-
whether this witness knew.
EEE.
Somebody at this witness's firm submitted this as the expert designation. This witness is saying, I'm aware that this is happening. I'm aware that this is happening. But did this witness know what was on his CV that was being submitted to the federal court? Because we can imagine what's on this CV, right? Right? We can guess at where this is going at this point. So they are laying foundation for whether or not this witness knew that this was being submitted regarding him.
And FFF fairly and accurately represent the submission of documents in support of a designation of expert witness in this case.
Yes, as far as I can tell.
Your Honor, I offer these
Now
two
this.
into evidence.
I'm going to allow it over here.
May I have briefer?
Yes, no. Bring those, please, Mr. Welcher.
Yes, Your Honor.
She's like, I'm allowing it over the prosecution's objection. And he said, I think, may I have reasoning? So, so of course, Brennan wants to be heard at sidebar. There's a difference, though, between whether this witness said it in court or whether it was submitted. Does it contradict what he said on the stand here? We'll see. I'm waiting to see what it says. But the court's going to allow it in. I would be very surprised if the court changed her mind after sidebar. But she's like, the foundation is laid. And this witness, to his credit, this witness knew what was coming, saw what was presented to him, and said, yes, I was aware of this happening. Instead of saying, no, I wasn't aware of this happening. No, my company does this and I have no idea what they're doing. I'm not even told. The witness said, yes, I'm aware. Let's approach.
I'm going to have to stand here again, Mr.
Sure.
Burgess.
And let's see what it
So
says.
what I would like to do, Your Honor, at this time is to offer into evidence
Yep, those are getting marked.
Exhibit EEE and Exhibit FFF for identification
As one exhibit?
as one exhibit.
All right, we'll do that. And the court reporter.
Those are going to get marked. I don't even know if we have the scantest amount of zoom room, but I am zooming. We're going to be caught up to real time here.
Mr. Burgess, I am handing you, it is now in evidence as Exhibit 193. I would like to draw your attention.
Tell me everything.
To the fourth page, which is your CV. And further, if I could, sir, draw your attention to the category of education, where it says BGS is it correct that there you state Bachelor of General Science in Mathematics and Business Administration, University of Alabama - Birmingham, Alabama, comma, 2024. Did I read that correctly?
You did read that correctly. And this was filed in 2023.
Understood. So now what I'd like to do, Your Honor, is to
mention it all.
Ma'am,
Mention it
keep
all.
this for a moment, Your Honor. Give it to the witness as needed. Thank you. With Your Honor.
So that one says 2024, and it was filed in 2023. It hasn't happened yet. It's expected in 2024. Well, we're now in 2025, and it hasn't happened yet. So does this seem like a... Chat, let me know. Does this seem to you like a, I didn't update my LinkedIn? Or does this seem like it is willfully playing with the, I'm imminently going to get my degree? Because the one on the website yesterday said 2022. And the one in federal court in 2023 said 2024. And the one on LinkedIn says 2016 to 2018. And the one in court, in this case, says in progress. And he said it's been in progress as long as literally my teen has been in progress. It's been in progress for 17 years. Someone asked this man, how many credits did you take last semester or quarter or whatever? When's the last time you were enrolled? Are you even enrolled? When were you enrolled? Because if you weren't enrolled in 2023, isn't it dishonest to say you expect to receive your degree in 2024? When were you enrolled? So is it a typo? Is it a failure to update? Or is it something more than that? This was filed in 2023 and that says 2024. Okay. And now in 2025, do you have that degree? No. But you said in 2015 when you made your LinkedIn, 2016 to 2018. And you said yesterday on the stand, you started this in 2008. So, yeah.
Your Honor's permission, I would like to publish a document that is already in evidence.
Okay.
Actually, there may be two, 183 and 184. Let's start with 183. Let's expand it. And then, Mr. Wolf, do we have
When
what
are
has
they
just
not a
been
mistake?
to publish as well?
Like when
So what
does
I'd like to do is to
mistake
publish
run out?
first, with the court's permission, Exhibit 193 that we were just talking
Alessi,
about.
I swear, if you don't
so
ask
the
him
jury
about
can
his
see
enrollment, I'm gonna
what
lose
has
my
been
mind.
the subject of discussion. And sir, if you,
And again-
Mr. Wolk, if you could just
again-
enlarge, all we need is
For what he's testifying to, you don't need a degree. You don't.
the education section. Now,
Oh, we also learned that the Bachelor of General Science is also a lie like the cake because it is actually a Bachelor of General Studies. Bachelor of General Science is not a degree that exists.
Mr. Burgess, as I heard it correctly in questions from Mr. Brennan, you answered the question that whether you had ever filed a document that
That's not what he asked.
misstated your educational background in a court. Do you recall that question
I thought
asked
he
of
asked
you?
if you.
Yes, I did.
And your answer
Oh.
was no, correct, sir?
Correct.
So let's look at this document, which we
I thought Brennan asked, and this witness was like, yes, he did ask if I'd ever filed a court. I remembered him saying, did you ever testify in court? Did you ever file a document? Is this a document that was filed? Because this was filed. And he's going to say that indicates, this is what he's going to say. That indicates that in 2023, it was in progress. That's what he's going to say. Because it's future dated. See, back to it being a fucking vision board.
we've just gone through was filed in federal court in the United States District Court, Eastern District of Texas, Marshall Division, which is a federal court. And attached to it is
The law clerks were
your
busy.
CV, and in the line of education, it lists under BGS, Bachelor of General Science in Mathematics and Business Administration, University of Alabama, Birmingham, Alabama, 2024. You see that, sir?
I do, yes.
Now, you stated, and now what I'd like to do is do a, is there any qualification whatsoever in that line, that reference to BGS, qualifications at all, explanation, sir? Is there anything?
I don't know what you mean.
It's just a statement, right? There's words there, there's nothing after it that explains what's intended, correct?
Correct.
Now what I'd like to do, Your Honor, is to go to what was filed in this case, which is in evidence, and we'll go to 183 and then 184.
Duty Ron, good to see you in the chat. I mean, pain for this witness. But, dude,
Now,
what is
in
he
what has been
doing?
filed in this case, there is a currently pursuing at the end after University of Alabama
Like, what does that even
Birmingham,
mean?
Alabama, correct?
Yes, that's correct.
Let's go back, please, to Exhibit 193.
Oh,
There is no
boy.
currently pursuing there, is there, sir?
There is not, but that was filed in 2023, so that would be an expected graduation date of 2024.
Why do you
Okay,
keep expecting
so-
to graduate? Like, why do you keep expecting to graduate and then not? How many units do you have left? Credits, whatever.
This document was filed in 2023. However, there's nothing in this document that in any way leads the reader to believe anything other than the degree is obtained on 2024, correct?
Correct.
So the only way somebody in the court system or a judge or a jury would know anything about this is to have to know about court filing dates, correct?
I mean, the date's on the top
I'll
of the
ask it
paper.
another way,
The
Mr.
filing date's on the
Burgess.
top of the paper.
You know how to write. Let's go back to 183 and 184.
Why didn't they all? How many units do you have left? How many units have you taken? Is it even a reasonable expectation that he expects to graduate and then that date gets updated every year? Is that even a reasonable expectation?
You know how to write currently pursuing on your CV, correct?
Correct.
And writing currently pursuing lets the reader know that you don't have that degree, correct?
Objection.
In that form, it's sustained.
Calls for
You
speculation.
intend by writing currently pursuing, don't you, sir, that anybody reads this to know that you do not have a bachelor degree, correct?
Correct.
Now let's go back to what you filed in federal, what was filed in federal court in that case. And it does not have the words currently pursuing, correct?
It does not.
So the reader, it doesn't have that verbiage, correct?
Correct.
So isn't it the correct answer that you did file a document, your CV, in this federal court case that misstates the status of a Bachelor of Science in Mathematics and Business Administration?
Objection.
Sustained.
Excuse me, Your Honor.
He didn't file it. His company filed it. His company filed it.
You stated again, sir, that you have not filed a document that misstates your educational background, correct?
Correct.
And the last time I'll
He's
cover
gonna
it,
say that doesn't
you know
misstate
how
it.
to put currently pursuing on anything to do with a Bachelor of Science, correct?
Correct.
A Bachelor of General Science in Mathematics and Business Administration does not exist as an offered degree at the University of Alabama, Birmingham, does it?
Sure. So that is an error. Clearly, BGS stands for Bachelors of General Studies, and that should have a with minor in Mathematics and Business Administration.
What is clear from that document that BGS stands for a Bachelor of General Studies? What is clear in that document about the definition of that acronym?
That is a known acronym.
Obviously not known to
Let's
the
go
person
back
writing your
to-
CV.
Bachelor of General Science in Mathematics and Business Administration. That degree does not exist. It is not offered at the University of Alabama, Birmingham, correct?
No, that is not.
So therefore, an incorrect statement about your educational background was filed in a federal court in Texas, correct?
Yes, it was.
That's it, Mr. Lessie?
That's it.
Okay. Is there anything?
There is.
Okay.
Miss Alessi on the recross didn't ask him anything about the data, anything about the interpretation of the data, anything else at all, and just went back through, okay, well, in 2023, you filed, or your company or the attorneys that hired your company filed this in federal court. Is that misleading or not? I just want to know how many units are left. Like, is he even enrolled? Because if you're not enrolled and still saying currently pursuing, is that accurate? And back to redirect.
The document that the attorney just showed you, did you submit that to the federal court?
No, I did not.
Did you ever see that document before it was filed?
No, I did not.
The document says 2024 for a degree. Is there a presumption whether you had it or expected it if that document was filed in 2023?
Yes, there is.
He expected it.
And what is the presumption if it was filed in 2023?
Objection, Your Honor, respect.
So presumption,
Well,
we'll strike that.
okay.
Ask what his expectation
He
was.
asked if there was any designation to make it clear. If it says 2020, if it was filed in 2023, and it says 2024, what was your expectation at that time as far as your degree?
That I would complete my degree in 2024.
When you didn't complete your degree in 2024 as you expected, did you then change your CV
Yes, I did.
to accurately reflect the change in your status?
Yes, I did.
And what did you change it to?
Currently pursuing.
But what
Why
about the one on
didn't you
your
finish your
company
degree in
website?
2024?
Sure. So,
Your Honor, still.
No, I'm going to allow.
Nope, that door's been opened.
as most people can probably relate, work, family, and life many times get in the way. So as a personal objective, I would like to finish my bachelor's, but again, work and life gets in the way.
Did you ever represent
17 years though. Are you enrolled? Are you enrolled?
to a court that you had a degree that you didn't earn?
No, I have not.
He asked you a number of questions about this 2023 filing, but didn't ask you any questions about the data. Does your opinion regarding the data change in any way in light of his questions about a 2023 filing that you didn't file and someone filed on your behalf?
Objection, Your Honor.
The objection is sustained. I'm going to strike that question.
It's argumentative.
No further questions.
Brennan just gave up. You could have asked it a different way, but Brennan just gave
Thank
up.
you.
I'm shocked we're done with this witness. This witness is just like, well, I want to finish my degree. And I think what we've learned here today is apparently it is a fucking vision board.
Well, I would like to. Life gets busy and I haven't finished my degree. I understand that. But we're not talking about a semester or two. I want to know if he's even enrolled. I really do. I want to know if he's even enrolled. Because if you're not enrolled, you don't have an expectation that it'll be completed that semester or that year. I'm surprised we're done with witnesses, honestly, with this witness. I'm very surprised. What's next, Brennan? Because you're the one standing up. Lord.
Mr. Brennan?
I'd like to play a number of clips.
Oh,
I'd like
clips.
to begin with clip 23.
So we're getting to clips of Karen Reed from the various media interviews she's given. Interesting.
So we approach from the north, we actually missed the turn. And John says to me, it's Fairview, we just passed it, it's back there, it's on my left. I said, all right, so I pull nose into a driveway and back out onto the street, which I now own was Cedar Crest, and then come from the north onto Fairview.
I'd like to next play clip 25.
So that's the 3-point turn they've been talking about in Karen's own words. This is from Discovery ID on the 15th of 2024, June 15th.
At 12:41, I leave a voicemail to John where you can clearly, and this will probably be played on Monday, you can clearly hear me pull into John's garage. You can hear my car sensors beeping as I come close.
I wondered that. I wondered if it was the car sensors. Look at that. And we talked about whether those sensors, whether the beeps were like a keypad on the garage or the sensors of the car. But Karen Reed has just put the time that she pulls into John's driveway at the same time that voicemail is played at 12:41, which is going to go along with the Commonwealth's theory that the Wi-Fi connection can happen while she's down the street. Because the Commonwealth is going to say the Wi-Fi connection happened down the street and she was pulling in at 12:41. Very, very interesting. So the Wi-Fi connection is going to shift because Karen is saying, and even if anyone argues about the Wi-Fi connection, I imagine most jurors are going to say, oh, she says that 12:41 is when she's pulling in, so 12:41 is when she's pulling in. The jurors are going to believe this time. Because she's saying, you can hear me pulling in. And on the voicemail, it sounded like car sensors pulling in. I'm going to back that up because I yelled in the middle. That's the time that the jury's going to pick, is 12:41. That time.
At 12:41, I leave a voicemail to John where you can clearly, and this will probably be played on Monday, you can clearly hear me pull into John's garage. You can hear my car sensors beeping as I come close to the sides of the garage truck. And then you hear the car go off, and then you hear the sled ding, ding, ding as I open the door, shut the door. I had high heels on that night. You hear me walk in, go into the stairs up into the kitchen, shut the door. You hear me walk in the kitchen.
You do. You hear all of that.
That's at 12:41.
You hear all of that. Play the voicemail again.
And finally, clip 24.
That is the time that she gets to John O'Keefe's driveway at 12:41.
I do. I mean, I'll tell you, John and I argued the morning of the 28th, Friday morning. So we think he died right around 12:25, 12:30 on the earlier.
When was this interview given? I had to back up. All right. This is Discovery ID from April 13th, 2024. And this is giving when she thinks John died.
I do. I mean, I'll tell you, John and I argued the morning of the 28th, Friday morning. So we think he died right around 12:25, 12:30 on the earlier morning of January 29th.
Thank you. I have these for
Okay.
evidence, right?
194.
The next witness, Mr. Allen?
Yes, sir. I'm calling Miss
Very-
Christina Hanley to the stand.
Interesting. The Commonwealth is calling Christina Hanley as their next witness. Those interviews are going to be persuasive. Because when there is a conflict in time, listening to you can hear her pulling into the garage at 12:41. She's pulling into the garage at 12:41. Now, is the defense going to argue that, okay, so she was in the driveway for a minute before she pulled into the garage? Maybe. They might. But it also clears up that at 12:41, she's pulling into the house. So we'll see. But the defense is arguing that John O'Keefe died later. And she's in her interview saying, we think he died at 12:25, 12:30. Those interviews are not helpful because they contradict what the defense is trying to argue. And a jury is going to put a lot of weight on the words they hear from the defendant. A lot of weight. And I don't think I can express to you how much weight juries put on the words of the defendant, even if those words contradict things. They will put a lot of weight onto the words of Karen Reed. A lot of them. And a jury sitting in a criminal courtroom is not going to have the, oh, well, she could have meant this and she could have meant that. They're going to be like, 12:41. Okay, it's 12:41.
Step up, face the clerk, and raise your right hand.
All right, Christina Hanley is the next witness for the Commonwealth.
Good afternoon.
What is this? Witness number 36.
All right, Mr. Lally, whenever you're ready.
Thank you, Your Honor. Good afternoon, ma'am.
Good afternoon.
Could you please introduce yourself to the
I
jury,
remember this
spelling your
witness.
last name for the court?
Sure. I'm Christina Hanley. Hanley is Hanley.
And Miss Hanley, what do you do for work?
I am a forensic scientist 3 at the Massachusetts State Police Crime
I remember
Laboratory
her.
in the Trace Arson and Explosives Unit.
And chat, you guys can disagree with me. I'm telling you how I see it and how I think a jury will see it. You are welcome to disagree with me. But I'm just trying to give you an overview of how I see it and how a jury is likely to see it. Because they're going to see it differently than those who have been following this case for quite a long time. They are. And those clips do not help. They don't. And I know you might disagree with me on that. And that's okay. I don't think those clips help the defense at all. Do I think there's plenty of things they can work around? Yes. But the prosecution is bolstering their case with Karen Reed's own words. Does that change some of the testimony we'll hear later? No. But the jury puts a lot of weight on what the defendant says. So if there's a quibble in the timeline, they're going to put the emphasis on what Karen Reed has said. If there's a quibble about when John O'Keefe died, they're going to put the emphasis on what Karen Reed said. And when it comes to count 2, which is not volitional, when it comes to count 2, quite a lot of the jurors last time, the majority of them were leaning towards guilt on count 2. So the defense has to also address those, because the jury can look at things and go, well, she was the last person there. She says she got home at 12:41. That's enough time. And we've heard in her own interviews that she thinks he dies around 12:30. And the cell phone data we just saw all shows around 12:30. There are still many medical experts to come, but the jury is trying to piece this together as the witnesses are going and as the information is talking, as they are listening to the information, they are piecing it along. The jury doesn't know how many more medical witnesses are to come. They have no idea. They don't know what's to come. So they're trying to make it make sense that we're sitting here, because they haven't seen the whole case yet. And they still don't have context. So they are trying to piece together, why are we here in trial? All right, let's continue with Hanley. And they haven't gotten to the accident reconstructionist yet.
And where
sorry,
did you go to
Lily.
school?
Why are you yelling?
I went to, I had received my Bachelor of Science in Chemistry with a concentration in forensics from Merrimack College.
I agree.
And do you have any other degrees?
I do not.
Now, following your education, where did you first go to work?
I began working at the State Police Crime Lab in...
I wanted to answer this question. Jay Cash said, I don't understand why EDB said that the Wi-Fi connected when she was down the street. At what point was that proven? Whiffin talked about it in his testimony, that you don't have to be precisely at the location for the Wi-Fi to connect. Whiffin talked about it in his testimony. So he talked about there is a range for the Wi-Fi to connect.
2008 in the drug identification unit. And in 2009, I transferred into the trace unit. And in 2017, I was promoted from a forensic scientist 2 to a forensic scientist 3 in the trace, arson, and explosives unit.
Could I ask you please to speak up, please?
Ms. Hanley, if it helps, that microphone is adjustable, so if you could get it as close to you as possible, that would be great. Thank you.
Just pull it right up, right up into the mouth.
Massachusetts State Police Crime Laboratory, where you work, is that accredited?
Yes, it is.
Oh, boy.
And by whom?
We are accredited by ANAB.
And what does ANAB stand for?
ANAB stands for ANSI National Accreditation Board.
And what does ANSI stand for?
Sorry, I can't remember exactly what ANSI stands for. I apologize.
That's okay. As part of that accreditation process, do you undergo any sort of proficiency testing?
Yes, I do.
And can you explain to the jury what that proficiency testing process consists of?
Sure. So proficiency tests are a quality assurance measure that's used to monitor performance. And I'm required to complete at least one external proficiency test per year, where I'm authorized to do casework in multiple subdisciplines. In my unit, I typically complete more than one proficiency test per year.
And what areas do you specifically undergo proficiency testing in?
Sure. So I'm authorized to do casework in multiple subdisciplines in trace. So I complete proficiency tests in the subdisciplines of hairs, paint, fibers, glass, tape, and serial number restorations and physical match examinations.
And generally speaking, what is entailed in those proficiency testing that you're given multiple times a year?
It's provided by an external company that provides the proficiency test, and I'm required to successfully complete one of those proficiency tests per year.
Now, have you successfully completed each of those proficiency tests that you've taken?
Yes, I have.
Now, what type of training or continuing education have you undergone at the State Police Crime Laboratory?
Sure. So I had internal training as well as external training.
So training within the lab and training not in the lab?
Consisted of, I had to complete required readings. I was required to complete some laboratory exercises, learn how to utilize the instrumentation in the lab. I observed other analysts in the unit working on casework. I was also required to complete a written exam as well as a competency test, and in addition to that, a mock trial.
Now, you mentioned earlier in your testimony you're a forensic scientist 3 currently, is that correct?
That's correct.
And what is the difference, or can you explain the difference to the jury between a forensic scientist 2 versus a forensic scientist 3?
Sure. So a forensic scientist 2 is essentially just like a bench chemist who their primary role or responsibility is casework. A forensic scientist 3 does casework, but in addition is also a unit supervisor.
Now, what does the trace unit do or examine within the Massachusetts State Police Crime Lab?
Sure. So I'm responsible for examining and comparing trace items that, for example, such as paint, glass, fibers, hairs, tape, miscellaneous items. I also perform serial number restorations on firearms and physical match examinations.
And what are your general duties and responsibilities within the trace unit within the lab?
So I am responsible for the general operation of the unit. I train other forensic scientists within the unit. I also complete technical and administrative reviews of casework. And I also complete my own casework in the trace disciplines that I previously mentioned.
Now, Ms. Hanley, you as a supervisor, you review other analysts' work within...
I can 1.25 to a point, but we don't have much room because we are almost at real time. Yes, they are going to go through background training and experience, and then we will get to what she did and what she tested.
The trace unit, correct?
Yes,
She's the supervisor for the physical match and tried some of that stuff. We can try at 1.25, but we don't have a lot of room for it.
And who reviews your work for any sort of trace analysis that you do?
Caught up soon.
So depending on what the subdiscipline,
she's
some of
from the state crime lab.
Casework that I'm authorized to do work in, it needs to be technically reviewed by an external technical reviewer because I'm the only one within my unit that can do certain types of casework currently. So we have to utilize an external technical reviewer at this time.
She's like, I'm actually the only one that can do my job, so we have to send it out.
With reference to physical match analysis, can you explain to the jury first, just in general terms, how is that analysis performed?
Sure. So when I receive an item, I take that item into my custody, and I document it with photographs, and I make observations and take notes, and then I'll examine the items microscopically, and I will do any comparison work to determine if there is or is not a physical match between items.
Now, that physical match analysis within the trace unit at the state lab, is that general work supported by any sort of scientific principle or methodology that you're aware of?
Yes.
Let me ask you this. Are you familiar with something called the Lockhart exchange principle?
Oh my goodness.
Yes. So the
What is he
Lockhart
asking?
exchange principle.
Do you do your
it's
work? Yes.
Kind of the foundation or basis of trace analysis. It is a principle that states that when two objects or two items come into contact with each other, there is an exchange of material.
Now, with reference to your workspace, what is it that you do to your bench between your examination of separately packaged items?
Sure. So the
I'm
bench
curious
top
as
as
to what the
well
trace
as
results are.
the tools that I'm going to use are all cleaned with a bleach solution. And once that's done, there's a clean piece of butcher paper that's put down on the bench, and that's done in between looking at different items.
And why
So
is
they
it
don't
that you do that in between
cross-contaminate.
looking at different items?
That's done to prevent any cross-contamination.
Now, you've alluded a little bit earlier in your testimony, but on what types of evidence can you perform a physical match analysis?
Sure. So physical match examination can be conducted with many different types of material.
Oh, that's right.
For
She dealt
example,
with the glass.
Plastics, glass, tape, etc.
Now, when evidence is submitted to your lab, how is it kept track of throughout its stay at the lab?
Sure. So
Well, we
when
check it
evidence
in
is
to make sure it's
submitted
comfy.
to the laboratory, the case information is put into our LIMS system, which stands for Laboratory Information Management System.
And once it's assigned that number, how is it sort of tracked as it progresses through the different units within the lab?
Sure. So the unique case number that's assigned to the case is tracked within the system. It's referred to as the chain of custody. So items of
Tracking
evidence will get
with
scanned,
numbers.
depending on where their location is, and the LIMS system keeps track of all of that, so we know exactly where an item is.
So when you take an item or you receive an item to be tested, can you explain to the jury what you do to begin your analysis?
Sure. So when an item gets scanned into my custody, after I've prepped my area to examine the item, I scan that item into my custody, and I is broken. And
We are back on real time. So we were at 1.25. I'm just backing up a little for the consistent or the cohesion of her answer because it jumped back to real time because we are caught up.
so class characteristic is that it can be associated with a group of items that share.
All right. One more. There we go.
Class characteristic versus an individual characteristic.
So class characteristic is that it can be associated with a group of items that share characteristics versus the individual characteristic. It's more individualizing. It can be related to a single source, just in the case of like a physical match.
And what is a physical match?
So a physical match is if an item is broken and those pieces are compared to each other and they're broken irregular edges fit back together and they have a jigsaw fit, that would be considered a physical match.
Now, can you please explain to the jury the steps and the process that you undertook in your comparative analysis of items, specifically of glass in this case?
Sure. So I first did a comparison.
What items were
of
they?
all of the glass pieces and the glass cup that were recovered from the road. So those were items 3-2, 7-12, and 7-14. So I examined all of those to determine if there was a physical match between any of those items first. And
all right, we got to, it's going to, when I pause and back up, it's going to keep trying to go back to 1.25, and then we're going to keep ending up with the same glitch. So I'm speeding it back down, but taking the glass and then the glass pieces to try to fit them together.
There were, I believe, 6 pieces of glass from item 7-12 that fit mechanically to the cup that was also recovered from the road, item 3-2. After I completed...
I wish they would just show them on the screen.
That examination, I then did a comparison to see if there was a physical match to some of the 2 of the glass pieces from the bumper. And there were 5 total from the bumper. 2 of them I used for physical match comparison. And there was no physical match comparison between those 2 pieces from the bumper, item 3-3, compared to the glass pieces and the cup that were recovered from the road. And then I sampled, as I had mentioned earlier, one of the pieces from the bumper to do further microscopic and analytical analysis on, and did a comparison with one of the pieces from the road.
Can I see counsel at sidebar for just a minute, please?
All right. They are going to sidebar. I don't know why the court has sua sponte asked them to go to sidebar, as we are getting into the physical match of items 3-2, the cup, and then the pieces of glass, and physically match them together. Let's see. Do we have any Zoom room? None at all. Do we have the only fan? Yes, we do. So yes, we do. For those of you asking what is 3-2, 3-2 is one of the first items recovered. It is the bottom of the broken glass. Excuse me. It's the bottom of the broken glass. So let's answer some questions while we're waiting for court to come back, because we're waiting for court to come back. Jake B asked, when does the Commonwealth say Karen Read hit John O'Keefe? They have not yet. They are getting there. Where have they gotten to so far? Well, during that last text stream event that ended at, I wrote down the exact seconds, that ended at 12:31:43. They are saying that text stream event that ended at 12:31:43 is a backing event. We haven't gotten into all of it yet because the how is for their Reconstructionist, who hasn't been called yet, and that John O'Keefe's device locked at 12:32:09. So they are saying the device locked at 12:32:09, and that text stream ended at 12:31:43. And then the last expert was to show that 12:31:43 on the Lexus correlates to a broader window that encompasses up to 12:32:16, because the time on the iPhone and the time on the Lexus are not exactly synced. They're not the same. There is a difference in time between the clock on the Lexus and the clock on the phone. So that's what the Commonwealth will be arguing based on what they've said in opening and based on what we've already seen from their expert. Keela asked in the chat, what is the real time of death for John O'Keefe? If you mean determined by the hospital, it is after he was taken to the hospital after 9 o'clock in the morning. I don't know if they put the time that he was called at the hospital into evidence. So I don't know if that's into evidence because they had to take him to the hospital. Then they had to get his body back up to 98 degrees before they could call it and give a time of death. So that would have been after 9 a.m. on the 29th. I don't think they've put in the exact time. Vicky said, Emily, do you think the defense will call anyone? Lots and lots of witnesses. I think the defense will have 2.5 weeks, give or take, of witnesses. Reality Check said, EDB participating in a mock trial tomorrow. Good luck. I'm sure it will be amazing, and just have fun. Let's see. Let us continue on with questions, because we've got questions. Didn't the defense know the Commonwealth was going to show these clips? Yep, they knew. I mean, they didn't utilize them in the first trial. I don't know if they assumed that they wouldn't. I have to wonder if when the defense did the Discovery ID series, it was their belief that this case would be resolved by the jury and that there wouldn't be a retrial and that there would be a verdict. So I have to imagine.
It's been a long day.
Oh, they're done.
We're going to stop for the day. Ms. Hanley, I'm going to ask you to come back tomorrow, but a little bit later in the day.
That witness must be pissed.
The victim of this person can tell you the time. All right, so
something is going on.
Today, Please do not discuss this case with anyone. Don't do any independent research or investigation into the case. If you happen to see, hear, or read anything about the case, please disregard it and let us know, and watch your social media use. Thank you.
But yes, the defense would have known. The defense would have known.
The court, please.
I wonder if they're going to go back on the record. We're going to see if they go back on the record.
Goodbye.
Misty Two Misses said, respectfully disagree. Perfectly fair. Everyone's going to have their... Look, I say it all the time. This is why jurors deliberate. 12 people are going to see things differently and can interpret things differently. And they have to talk about them with an open mind to come to a consensus, which is what we do here. We talk about things with an open mind. And what I appreciate about the law nerds is there's times you're like, I can't have an open mind on this. That's fair too. You don't have to. You're not the jury.
All right. You don't need me for anything, right? We're all set?
We're all set. Thank you.
Oh, I guess we're done. We're done. And Missy said you have to wait for it to open first. Fair. When you pull into the driveway, you have to wait for the garage to open. And the beeps were the sensors of the garage walls. Fair. She connected to the Wi-Fi in the driveway. Fair. How long was she in the driveway? Will be a question. The Commonwealth is going to argue that she was down the street when that connected. The defense might argue she was sitting in the driveway for a few minutes before that voicemail. The audio is still open in court. That's what we're hearing now. So
We can leave those.
apparently we're just like leaving it open. All right, and there goes the audio. Let's see. Give me 1 second to answer something. I need to answer a question real quick, you guys. I'm sorry. And then we will get to summary and then to questions. All right. Well, how pissed is that witness to have to come to court today to get into 5 questions and then be told to leave and come back tomorrow? And they've still got 20 minutes of the court day left. So we're going to answer some questions and then we're going to be done for the day too. Why? Because we have a long week ahead of us this week, even though it's a short week in court. Why do trials take so long? Well, there's other stuff that has to get done. There's other stuff. What that other stuff is, I don't know, because they asked that witness to come in a bit later tomorrow. So what time is court going to start tomorrow? I don't know. Are they going to need to put things on the record tomorrow before court? Maybe. Did they need to put anything on the record this afternoon? No. But the court told this witness, the witness coordinator will let you know when. I will have you come back in a little later tomorrow. So what's going to happen in the morning? I guess we'll find out. And if I see it later, I'll let you know in the Law Nerd app what time we're expecting. So let's see. We're going to summarize and then we're going to answer some questions. And then I guess we're done for the day. This is just... I don't even know. I don't even know today. It's... Ladies and gentlemen, this has been a long day. So, Tess asked, do you think there's more to this early stop? It's odd to stop that witness 15 minutes early to me, but you never know. I mean, the clerk could have to leave early to pick up a kid. The court reporter could have something that's going on. I can't attribute it to anything because it could be so many things, but it's a pretty neutral witness, just like, this is what I did, this is what I tested, this is what I saw. And they're probably going to have, well, something going on in the morning because the witness is coming in a little later, so we'll see what that is. But it's about 15 minutes early on the day. Is it horribly early? No, but it's a pretty simple testimony to go through. But it could also be that jurors had somewhere to be and they can let the court know that through the bailiff. So you never know. So I don't attribute anything nefarious. It could be a ton of things, especially this time of year. It's running into Memorial Day. It is running into the ends of school. It is a busy time of year. And a number of you in the chat said, and it's Taco Tuesday. Yeah. And it's Taco Tuesday. And it's Taco Tuesday. Let's try to summarize. Let's answer some questions. And then I'm going to go help my kiddo work on packing.
So I should ask, because I don't think I've asked the entire trial to go ahead and like the stream. I keep forgetting to ask. Also, we are just a few law nerds away from 100,000 law nerds in the app. And it is a number that Team Baker has been looking at throughout trial going, we're almost at 100,000 law nerds in the app, 100,000 law nerds that we can just tell what's going on at the push of a button. So if you have not downloaded the Law Nerd app yet, and you would like to make Team Baker's and my heart full, it is a hugely appreciated thing if you want to engage and stay in the loop that way, and I appreciate it. Free on iOS and Android if you haven't downloaded it yet. As the days of court get squirrely with early endings, late starts, it's the best way to keep us all in the loop on what's going on and when I'm covering things. So thank you so much for downloading the Law Nerd app. I appreciate you. We are also working on new merch. That is what I had to answer. We are working on new merch. We are doing all the things. We are navigating all kinds of things that we never thought we would be navigating. Why? Because we have a whole merch store that we have to do things with. And, started with okay, we can do a t-shirt till we're here. And we are working on tank tops. We're working on them. I promise. But, the streaming is dynamic and so are running businesses. So Lyndon said it accurately. Get the app, make Octo happy. All 8 arms will be thrilled. Let's summarize the rest of today. So at the end of day 19, the court stopped, I thought, kind of abruptly at maybe 15 plus minutes early, as we had just gotten into a scientific witness. We had just gotten into the trace witness from the lab who did the mechanical match on the glass. And we had gone through background training and experience and another explanation of what mechanical match is. And then the court called everyone to sidebar and excused the jury about 15 minutes early for the day and told the witness they'd need to come back tomorrow and told the witness they'd need to come back just a little later. I don't know if court is starting later tomorrow or if there are things the lawyers need to address with the court before court starts. I guess we'll see tomorrow. And if I find out more, I'll let you know in the Law Nerd app. But at the end of the day, we did in fact finish with witness Burgess. Did the redirect help? Well, it's really going to depend on how you see this witness. If you see this witness as someone who you kind of lost faith in the carefulness of their analysis, then no, the redirect's not going to help at all. It's just not. It's whatever, I'm out. If you're looking at this witness going, okay, I don't think the CV thing's that big of a deal, which jurors might. I don't see it as that big of a deal. Then did the redirect help focus on the data? Yes. Because there were a lot of parts of Alessi's cross-examination that did not focus on the data the witness was bringing forward. There were definitely parts that did, but there was a lot of it that focused on whether the witness was credible. And if the jury finds the witness credible, there are points of the data that are consistent with what the defense says too, and points that aren't, because it all comes down to the window of time that Karen Reed's car has a backup event and John O'Keefe's phone clicks closed and then does not open again. So it really depends on how this witness is seen. But the fact remains that the time when John O'Keefe's phone click button closes is the last time from all the experts we've seen that there is user interaction with the phone. Other data is written onto the phone after that, but that user interaction data time seems pretty firm to me. Maybe it will shift as we get into other witnesses, but at this point, that time, Emily, back to the Post-it notes. That time of 12:32:09 when the device locked seems like a pretty firm time. So the question remains, when was Karen Reed's car backing up? And was it covering that time? Or was that backing event done before that period in time? And when the medical experts come in, I think that this will become
much more apparent as to why it's necessary. And we heard some of those questions in cross-examination with the defense asking the coroner, is that the type of injury you would expect someone not to have volitional movement or the ability to manipulate a phone or et cetera? So we know the direction that's going in from the defense. And then at the end of that testimony, the Commonwealth played 3 clips of Karen Reed in her own words. One of the clips talked about the 12:41 a.m. voicemail that we talked about where there's beeping. And Karen Reed explains everything that happens on that voicemail. The beeping at first in the voicemail is the beeping of the car going into the garage with like the walls. And so it's beeping from the sensors on the side. And then you hear the slower beeping, she said, when you open the door, the open door sound. And then you can hear, she explains, her going into the kitchen with her high heels and walking into the kitchen on that voicemail. Do I think that that explains everything that's happening on that voicemail? It does. It's really consistent. So then if the defense is trying to push the time forward to show that she connects to the Wi-Fi sooner, what do we do with that 12:41 period of time? I imagine you will hear the defense argue that she connected to the Wi-Fi and was waiting for the garage door to open and was in the driveway before she pulled all the way in. And I imagine you'll hear the Commonwealth say the Wi-Fi could have connected down the street and she was still driving back to One Meadows at John O'Keefe's house. And that the time it takes to get from John O'Keefe's house to 34 Fairview isn't enough time with the way that the Commonwealth has looked at that time. So that's where we're getting to on the timeline. And then we have another clip of Karen Reed talking about the fact that we, and I assume we to mean her and her legal team, we think John died around 12:25, 12:30. While the defense might quibble with that time in their presentation of the evidence, I think listening to Karen Reed say this is the timeline will be impactful on the jury. And we will see how that continues to be illuminated as we get into all the expert witnesses. And the defense will probably argue, well, with stress and hindsight and this and this and this and that, 12:20 to 12:30 or 12:25 to 12:30 doesn't make sense with what the digital evidence says. And people get things wrong. And I wonder if the defense will point out the things the Commonwealth witnesses have gotten wrong. Because when we got to the recross of the tech expert from Aperture, the defense was like, hey, so, oh, Emily, you have not a single docket sitting on your desk today. I cleaned my desk. Hey, so this filing in federal court in Texas from 2023 shows that on your CV, you said that you had a BGS Bachelor of General Science, and the date there was 2024. So did you submit to a court a resume that said that you were anticipating your degree in 2024? And it was, well, my company submitted it and somebody else handles that. But yes, I anticipated that I would receive the degree in 2024 and nobody asked. And I suppose it's because the lawyers don't know the answer and you don't ask questions you don't know the answer to. If this witness was enrolled in 2023, how many credits they have? Why did they think they were going to get their degree in 2018, and 2022, and 2024? And why does it keep shifting? And why does it now say in progress? And when it was asked on redirect, redirect, it was asked, so you anticipated finishing your degree? And the witness said, yes, I hope to finish my degree, but work and life and family get in the way. But then why is the degree still listed in multiple places? And is it a typo on an old LinkedIn account? Or is it 2016 to 2018 and then 2022 and then 2024 and then in progress? So it's been updated
Is it intentionally misleading? Or is it just human error because he still intends to complete the degree? It's going to be up to the jury. But the more the dates keep changing, the more it looks like he's well aware that the degree is not complete and that it's on the resume, in the education section of the resume. So why put it there if it's not done? What's the purpose? The jury's going to get to decide the credibility of witnesses, but I've never seen an expert get called out on a resume like that. Ever. I've seen people quibble with if this article was peer reviewed, if that article wasn't peer reviewed, are you board certified or not? I've seen those quibblings over the education of experts. One expects that type of quibbling with the education of experts. But I have never seen, I expect to get my degree next year. For the past 17 years. That I've never seen. But the way the expert explained the timing made sense to me. How much weight the jury will put into it, it's on them. They get to decide. But the way he explained the timing made sense. I'm curious to see how the defense expert explains the timing variances. And at some point, if the defense just says, you know what, we're not worried about the timing variances because none of the other information shows that John O'Keefe was hit by a car, because that is what they said in their opening. Sure, you can say it's this time, you can say it's this time. None of it changes the fact that the Commonwealth hasn't shown you that John O'Keefe has been hit by a car. And the witness that the Commonwealth is expecting to do that is also from Aperture. And it seems that we'll maybe see that witness next week. Wow. What a lot we learned today. And I guess we'll summarize the last witness tomorrow because court ended for the day and that's where we're at. So let's answer some more questions. And then I guess we're fully in, that's enough work for this day. Oh, and I've got spicy weather, so it's probably better. It's probably better to spicy weather it in a little bit because that's where the spicy weather came in. Let me answer where we're at. Oh, we're getting very close to 100,000. Thank you, Team Baker, for giving me that update. Thank you, everyone who downloaded the Lawnerd app. Let us get to the questions. Oh, Lord. The FBI! Today. Lawnerds, if you're watching weather today, that's fantastic. If you're not, that's fantastic. But we're done with court, so you can keep an eye on your own spicy weather, and then we'll all see how tired we are tomorrow morning. Coral said, Emily, can you even believe it's simple errors when the date changes, but the name of the degree doesn't yet, it never existed? Right? The degree is listed repeatedly as a BGS, Bachelor of General Science. And he's like, well, clearly that's a typo. Okay, but that typo hasn't been clarified. Ever. So is it intentionally misleading? It's up to you. Do you find it intentionally misleading to list a Bachelor of General Studies as a Bachelor of General Science? Is it trying to bolster the credibility of an expert witness? Because one of the things that expert witnesses battle over is their qualifications, their education, their experience. It's actually a massive component of a battle of the experts. A massive component. Oh boy, I've never seen anything like that. So it is just wild. The virtual juror said can connect to work Wi-Fi less than a quarter of a mile. I've never even looked at how long my Wi-Fi stays connected from the house down the road. It does for a little bit. But it's wild to me.
All right. Let's see. Poppet said, thanks for keeping me occupied while I'm home with a cold. I mean, we're here for it. Whatever is going on, we're here. Let's see. I hope the defense calls Proctor. I watched his prior testimony and your streams of it, and I forgot how bad it was. I don't think the defense would pass on the opportunity to call Proctor because there's no cost benefit for them. Like, if you're the defense, what's the cost benefit of Proctor? I see all benefit and not a lot of cost. I mean, you lose some time. So you lose a day of testimony or more, but you get into stuff the jury doesn't know yet. The jury doesn't know all of Proctor's texts. There's a lot that the jury does not have before them at this point. So when you're looking at an expert going, well, is that a typo? Is that a misunderstanding? Is that an intentional error? Does the way Proctor ran the investigation change the analysis of garbage in, garbage out? If you're looking at an investigation that from the beginning was always going to try to fit what Proctor wanted, that's the defense argument. And does that add context to the expert saying, no, we adjusted it later? Does it change the way that evidence is viewed if you call Proctor? And I think it does. And it lends to the argument of, well, what if the Commonwealth didn't call Proctor? Then the defense can argue, why didn't they want to call Proctor? What are they not telling you? And I think it can make the Commonwealth look bad. But would I be very interested in what Hank Brennan cross-examining Proctor looks like? Yeah, I do. So I don't think there's a downside. I saw the comment, you and lawyer, disagree. I don't think so, Miss RCM. He thinks the defense should call Proctor. I said there's no downside for the defense. So I just stated it in the opposite way, same intention. I don't think there's a downside for the defense. What do they lose? What does the defense lose if they call Proctor? Time? The defense has a lot to lose. Or the prosecution has a lot to lose if they call Proctor. For the defense, I see it as a win-win for the defense. I don't see how Proctor has a downside for the defense. Proctor has a lot of downsides for the prosecution, but not calling Proctor, I think, has more downsides for the prosecution. The defense, I think it's just a win-win, So someone's going to call Proctor. It's just a matter of who and when, I think. A lot of you asked, can Proctor plead the Fifth? He didn't last trial. It doesn't mean he won't. It would have to go question by question. And he's already been disciplined at work. And the text messages and things that are really bad, he's been disciplined at work. Those aren't criminal. So he would have to be at risk for a criminal prosecution. So we would have to wait and see. But he didn't plead the Fifth last time. And so at minimum, they could ask him everything that they asked last time. If there's other stuff that might put him at risk for a criminal prosecution, then there's a question there. But everything he testified to last time, he did not plead the Fifth. The virtual juror said he is responsible for telling his employer his education. I'm very curious about what his employer knows, because his employer is also responsible for providing those CVs. So John Stamos, I don't know if the real John Stamos, not the real John Stamos, because, well, verification on YouTube. But thank you for the super chat saying my sister Alana and I are now hooked. Can't stop watching. You're getting us through with intelligence and humor. Big thanks from both of us, John Stamos. Well, real John Stamos or even not real John Stamos, we're a fan over here. So it's also John Stamos, if John Stamos, don't be offended. But the law nerds took us a while to realize it was the real Sir Mix-a-Lot in the chat. It's the same with Bailey Sarian and like iJustine. We're all just like, wait, what? We're just hanging out over here. We're just hanging out over here. Shane said, I'm a medical doctor. Well, I've been working on it since 1995. Same. Shane, exactly. And your employer should pay you according to your doctorate degree. So let us continue. Susie's Me says, thanks to you and your channel, I've been accepted into college at the age of 61 for criminal justice. Sue, that's amazing. Get it. I imagine college not at like 18, 19, 20, 21 would be a lot of fun because it's like, oh, I'm just curious and I want to learn things. I just want to learn things. Let me just learn things. Like, it's not stressful. You're not like, how am I going to pay for this shit? And what am I going to do with the rest of my life? And why doesn't that guy call? Like, it's so much less stressful. It would be so much fun to just be like, I want to learn things. Like, isn't it weird? What about this? It'd be so much fun. I try to help my kids have that attitude with going through school. Like, can we just explore? Can we just explore? And I hope that they're able to take that through school, because when you put a lot of pressure on creativity or education, it gets difficult. So let's get dangerous. Beldy said, I know the soundboard requests probably aren't your thing, but a finish him Mortal Kombat fatality bite seems appropriate. I don't know. I'll take it under advisement. I've been leaning heavily into our pop culture clips. That's my opinion! We might need to name him, though. Do it. We might need to name him because, like...
Mention it all. Mention it all.
Name him. We might need to name him. I don't know if we'll get to finish him, but I also... I want witnesses to provide good testimony and reliable testimony. It's wild to see an expert get roasted like that. I don't want to see experts like that in trial, honestly. I want to see good experts who do their job. And then I want to see if we can get to the middle of the information. Like, can we get to the truth of the matter? And when an expert gets so roasted on something that is so avoidable, it's not what should be going on in trial. Like, and who even vetted everybody? Like, what is happening? So I want to see lawyers doing their work excellently. I want to see witnesses doing their work excellently. And I want to see what civilian experts remember. And then shit goes off the rails. And it is confounding. It's just confounding. And it at times incredibly frustrating, but that's because I know that none of this should be this dramatic. Thank you for the gift of memberships. Like, it shouldn't be dramatic. And it is. It's so dramatic. Let's see. Said, my husband works as a first assistant in surgery for 41 years, says surgeries are consistent with the beating and not being hit. The arm is 1,000,000%. I think the experts have to come in and testify to it. But again, we have lots of experts. Though I have seen, well, we will let the experts come in and say what they think. I have not seen a vehicle collision with a significant injury like the head injury without a point of impact. So we will have to see what that looks like when they get to it, because how do they describe a point of impact and how do they describe the broken taillight? How did it get broken? And if you can't explain those things, I think it's hard. I think it is a hard case to prove, though I have seen people prove homicide cases where they do not and have never located the victim. But there was a lot of evidence to do that. Sheila said, does sequestration preclude his boss from watching? As to Burgess, one of his bosses, I don't know how many bosses he has, but Welcher is a witness and Welcher is sequestered from watching his testimony. But I don't know if there is amendments to the sequestration to allow the experts to watch the testimony of the experts they're rebutting, because they had asked for some modifications as to that. Heather said, why are the defense and state allowed to hire experts from the same company? They didn't in this case. It seems like a clear conflict of interest. But the confusion might come from the fact that the ARCA experts and the Aperture experts are way close, but they are from different companies. So let's see. Bone said, can you review the times of the 3-point turn? He's disgusting. I'm confused. Is this the turn to get onto Fairview? Yes. It is the turn to get onto Fairview, not the backing up where they're alleging she hit him. So the 3-point turn is them getting onto Fairview, as Karen Reed explained in the clip we saw of Karen Reed talking about the 3-point turn and John saying, oh, you just missed it, and her turning around. I think that clarified it. Should they have played that clip before all this testimony? Maybe. I think it would have made it a little clearer that the 3-point turn everyone agrees on. So we will see. Terry said, why does Brennan get three questions of Burgess? It's his witness. So when you call the witness, you generally get the last word. Sometimes you don't. Sometimes the court will allow like one more question on cross, but generally the party that called the witness gets the last word on that. Jojo said, Emily is someone who's dealt with translating MOUs, legal docs, scientific docs that listed people of all education work experience. I've never seen, heard, or read a CV like that. Same. I saw a lot of questions yesterday about why would Alessi have even gone looking for this information? Because the CV saying in progress is weird. And when there is something weird, attorneys or whoever's reviewing the information, law clerks, when there's something weird, they go, that's weird. And then the curiosity should propel you forward from that's weird. Law doesn't like things to be weird. Law likes to do things the same way all the time. Keep it consistent. When something seems outside of that normal pattern, it raises interest. That's weird. That's weird. And then that prompts the curiosity. And when you get an expert that looks at a lot of CVs, or an attorney that looks at a lot of expert CVs, they know it's weird. Where a younger attorney might not have seen enough CVs to know it's weird yet. So that's why you have attorneys of different experience levels doing different things at trials, and why you have law clerks to say, hey, y'all, this is weird. Let's see what we can find. Now, would Brennan have looked at that and gone, that's weird, but he was hired? Maybe. I don't know if they would have run it down or not. Does it shock me that Brennan wouldn't run down what a LinkedIn page says? No, it doesn't. Michelle said, is the time of the voicemail the time the call comes in, or the time the voicemail is received to the phone? It's a good question. I don't remember if any of the experts addressed it in this case. I don't remember if any of the experts said. They all said a voicemail at 12:41. So it indicates the way they said it, that the voicemail is from 12:41. So we will see. Let us continue on with questions. So, Miss RCM said, sorry, Emily, my listening ears have glitched and I didn't fully hear your stance on Proctor and who should call him. Oh, I don't know if I have a stance on who should call him. I think for the Commonwealth, it is a lose, 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 lose. And I was trying to apportion which loss was greater. Is it worse for the Commonwealth to call Proctor and have to deal with Proctor? Or is it worse to not call Proctor and then have to defend that you didn't call Proctor when the jury's like, the fuck? Or do you... So for the Commonwealth, I think it's a lose, lose, lose. And I don't know how they rectify that lose, 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 because I don't understand the decision, how you make that decision. Because it's one of the messiest things I've ever seen. I don't know how the Commonwealth decides to make that decision. If you don't call him, it looks like you're hiding something. If you do call him, then it's Proctor. If the defense calls him, then the Commonwealth is like, yeah, we didn't call him because we don't trust him. And then you go after him on cross-examination. And then you say, but this is the information you gave to Buchanan. But this is the information you gave to that person. And you try to say Proctor bad, information not bad, which is a little easier to do on cross. But does the jury feel like you're hiding things from them? And do you run that risk? Because it's a big, big risk. I don't think juries like it when they feel like information is kept from them. That's been my experience. It's like, and they know that the Proctor elephant in the room is an elephant in the room. So someone has to call Proctor, but who's it going to be? I think they're in some kind of a stare down with it. So we'll see. Sarah said, does accident mean car versus pedestrian? John O'Keefe might have slipped and fallen trying to avoid the car. His BAC was quite high as well. No one has put forth that theory in trial. Accident, as it comes to count 2 and count 3, very clearly mean that Karen Reed hit John O'Keefe with her vehicle. As to count 2, I think there is legal room to argue on count 2. We did not see the lawyers argue count 2 very much, but the Commonwealth has said Karen Reed clipped John O'Keefe with her car. So does clipped mean hit? Does the jury think that the evidence will sustain that? And how does their accident reconstructionist explain the rest of it? I don't know. But yes, for the way they have argued count 1 and count 3, it absolutely means that she hit him with the car in some way. And I think for count 2, they have to argue that she hit him in the car with some way, because otherwise they're saying it could be this or it could be that. And if it could be this or it could be that, then there are multiple ways to interpret it. And that doesn't get you to beyond a reasonable doubt for me. So let's see. Those are good questions about car versus pedestrian. We might do a pickle yodel tomorrow or at the end of the week, because we are definitely not clear for this week just yet. Avon DZ, we're just at dolphin noises with exhibit EEE. Her doing the interviews only seems to help count 2. I don't disagree. They know there's a terrible investigation, and ARCA and the medical examiner prove he wasn't hit. Maybe their plan is to narrow it into count 2 and then show doubt. Maybe. Because the defense has to be mindful of count 2 and its lesser includeds, which we've talked about on other days. We will not get into it today. My brain is very tired. It is not simple. Count 2 is complex. And count 2 leaves open more possibilities, and Karen Reed being a factor in those possibilities. It's more like, it's an involve, but it also has lesser includeds. Not all those lesser includeds decrease in severity. Count 2 is the least severe of the crimes penalty wise. And then those lesser includeds are also less severe. And that's where the jury was hung last time. It sounds from the interviews, if you believe the interviews, that 8 of them were leaning towards guilt on one of the parts of count 2, and it's lesser includeds. So yeah, the defense has to be thinking about it. And the Commonwealth, I think, does too. And I think all these attorneys should be arguing with the court and quibbling with the court about an hour for closing. In this case, it is too short. There needs to be more time. I think an hour is too short. I don't think they need 5 hours to close, but I think an hour is way too short. Then again, I am verbose. And so in a trial that's going to last weeks and weeks and weeks, if the judge said, Miss Baker, you have an hour, I'd be like, what? I can't even read the jury instructions in an hour. There's so many of them. And there's 3 counts. And then count 2 has like multiple subparts. And no, not an hour. Ugh, miserable. Carrie says, Memphis here, weather getting spicy. Stay safe. Thank you. We are under all the watches that we need to be under, but we have maintained power throughout the entire stream today, so yay. Good for us. SF said, question, would putting John O'Keefe's phone in a Faraday bag right away after the last logged info stop the phone from logging more steps and info? This is a great question. From my memory, 5 weeks in, the step information could still log in a bag because the phone's moving, but it would stop information coming in from applications and from the internet, but it could still move. But when you look at the phone data, there's that long break of activity until the phone is picked up in the morning. So there is a long break in the phone activity. And I just wonder if with everything else being a cluster, that the jury is really looking to that digital evidence. Potentially Criminal said an even better way to show he was still in school would be 2008 to present. Then there's no confusion. Again, I'm honest like that. Sean, yeah. It's like there's ways to establish that. But why even put it there? I still want to know how many credits the dude has. Why put it there? Why put it on the CV? And I can't believe it's never been a problem. I mean, it probably never has, but I can't believe it's never been a problem. It's wild. So it's a lot. Thank you, Judy Ron, for stopping by. It was good to see you in the chat, and Sean in the chat. I'm sure we had lots of friends of the channel in chat today. My brain has kind of started buffering at this point because I'm tired. Jane asked if the law clerks get to sleep. The law clerks are on like a 2-month rocket ship of adrenaline. And hopefully not, but likely also sugar and caffeine. Working as a law clerk was one of the most exciting things because it's like all of the interesting shit. And like at the end of the day, it's not your responsibility. Like it's all of the interesting stuff. And you were just like, holy shit, I'm doing it. But it's also at the end of the day, it's not on you. So you get to pick up the nuances and you get to be an extra set of eyes and you get to use your brain that is developing into lawyer brain and seeing the world through a different lens and thinking the way lawyers think, which is a different way of thinking. And you get to exercise all of those things. And it is high adrenaline. But yes, they should be sleeping. My advice would be do not count on adrenaline. Eventually, you will just burn out. Sleep, hydrate, rest, move, eat. And by eat, I mean you cannot run a trial diet of like Coke and Cheetos. Ask me how I know. It doesn't go well. Scott said, how many hours has he completed in the past 10 years? He will have had to repeat classes. I love being a law nerd. Scott, we all have the same questions. Like, just tell us how many credits. Can we just answer this question? Can we just answer the question? But no. Mary said, Brennan said he didn't want a voir dire of this witness, right? Yep, he objected to it and said it wasn't needed. For all of you who are offended at which experts were just like, nope, that expert's an expert and which experts weren't, I get it. I get it. I get it. Dr. Russell did multiple voir dires. And this expert's like, so I looked at this and this and it sinks. I know. Tamara said, when I served on a jury, we ignored the psychiatrist's entire testimony because of how dismissive and insulting it was to teenage girl behavior. Yeah. And a jury can be like, I don't believe that witness at all. That's BS. They get to. They're the jury and they get to talk about it. Terry said, Emily, I'm relatively new to your channel. Thank you so much for the great commentary. You're welcome and educated info. I do actually have a JD. I know. It was expensive and challenging. I really enjoy your channel. I wonder if O'Keefe's family secretly questions the cops. I don't know how frustrating it must be. I do know that mourning for families who lose someone due to crime is difficult. And mourning someone who is lost unexpectedly is difficult. And I think that is more difficult when you don't know why. We are humans. We want to know why. Humans want to know why. We want to jump to answers. Even if we don't have them, it is difficult to wait because our brains want to know why so we can move on to other things. And not having answers is difficult. And it is difficult for grieving families to not have answers. But I do know, just from what I've experienced in my life and from what I've experienced through my work life, is that even when you do have the answers, it doesn't make the grief any better. Like, knowing doesn't make it go away.
somebody being held responsible still doesn't make it go away because nothing can undo it. And that is one of the hard things and one of the pressures in the criminal justice system is everything is happening after the thing has happened. When you're dealing with crimes, dealing with victims, the thing has already happened to the victim. And nothing that happens in court undoes that. And it's hard. And it's frustrating. And it can be frustrating sitting there going, well, this doesn't come in because of evidence rules, and this doesn't come in and the defendant's rights. And victims' families often feel like, okay, but my family member, my person, or the victim themselves, but me, this happened. And I am just left with that because it happened. And so, yes, there are all these rights and there are all these processes and all these procedures in court to protect the government from taking away the liberty of the accused. And the victims are like, okay, but where was that for me? And it is a tension within the system that is a push-pull, especially when cases don't get filed because the victim's like, but this happened to me. It's like, okay, but there's not enough evidence to prove it. It's hard and it's frustrating. And that is the tension. So I feel for the O'Keefe family. And at the end of the day, and with all of the wildness in this case deserved a better investigation, much better investigation, just a thorough and conscientious investigation. And it didn't get it. And I think it's one of the reasons this case is so frustrating, because no matter how you view Karen Read, what she did, what she didn't do, what you think she did or didn't do, this investigation was not good. And that is a really frustrating thing because, yes, bad investigations can result in verdicts that people might not agree with. However, the system is set up that way. You can't have bad investigations get good results. There's rules, and a lot of them. It's frustrating. It's just frustrating. And that's one of the things that's so frustrating in this case, when there is nonsense with the experts time after time after time. Because even in hindsight, this is the expert that comes in after the first trial. Really? How? Just how? Just how? It's so frustrating. And that's why we're watching to see what happens. I want answers. You want answers. We all want answers. Sometimes we're not going to get them, and that is incredibly frustrating. But I have a lot of grace for families that are trying to find answers because it is not a path anyone wants to walk. I know. I want answers. All of us do. Stephanie asks, will Karen take the stand? She didn't last trial. I don't think at this point that's needed. I don't think at this point that's needed at all. I might change my mind on that, but at this point, no. Because the second Karen Read takes the stand, everything that has happened before kind of goes to the side and everything is focused in on Karen Read. And when there is so much that has happened with the witnesses, I don't know if the defense wants to make Karen Read the focus. Because if a juror's like, I don't like the way she said that. What about this? What about that? She didn't really have a good explanation for that. It shifts the focus. So no, not at this point. So Holly said, Emily, you said you have opinions on Burgess' testimony when it's over. Will you be sharing with us at the end of the day? I need to think about it because the swapping of the dates on the CV are odd. And there were some questions that just weren't asked. Brennan just sidestepped the whole, that's the wrong fucking day situation. Just went, nah.
So Brittany says, you and Peter always have different opinions on the clips. So that is what I find interesting. Also, context is always missing. The defense can't put the clips in. The prosecution can. They can argue for completeness. And that's what the defense can do. They can argue for completeness. And I think everybody probably has different opinions on the clips. That's okay. I tell you how I see them when I'm seeing them in real time. And then how I think a jury will see them. Because I don't think all the clips are helpful for Karen Read. Some of them I think are an overreach. But the jury will be focusing on them quite a lot. So that's how I see them. The jury's going to be really focused on them. And they can interpret them entirely differently. The jury can be annoyed. Like, it sounds like the video stops. Why are you doing that? That can be annoyed. A number of you are asked, or a number of you have asked, even after they're done with the testimony, can the video interviews come in? No. The defense can't put in clips. No, not even Samantha, not even when it's their turn. No, they can't. It's improper evidence to the defense because it's their witness. It's their client. If they want to put in Karen Read's side of the clips, Karen Read has to testify. The Commonwealth can use them because they're statements of a party opponent, Karen Read. But as to the defense, they're not statements of a party opponent. They are hearsay. They cannot come in. The defense can argue with the prosecution that the clips are not complete and argue for completeness, but they haven't done that. Now, can they play the clips that the prosecution has used? Yes, they can. They can play them, but they can't embiggen them. They can play what's been introduced by the Commonwealth. That is it. And those arguments about the entire statements came up earlier. The statements that are in, the defense can use the ones that are in, but they cannot expand them to add more words. They would have had to have fought that earlier. And they have fought that on some of the clips. So they would have to fight that before the clip comes in. Who do I think will give closing? Jackson and Brennan, unless something drastically changes. I think they'll keep it consistent. Yeah, I think they will keep it consistent. Can the defense ask question of witnesses about the clips like a tech expert or something? I don't know what they would ask. They can't elicit anything else that was said. So I don't know what they would ask a tech expert about because the clips are of her. So I don't know. But when you get down to Karen Read's side of the case, in their opening statement, they said there's no collision. So, okay, put in all the clips you want. There's no collision. And if they continue to focus on that, they're going to say, show me where that happened. Okay, Karen Read said that voicemail is from 1241. The voicemail is from 1241. Okay. Show me how it happened. And that's going to be their argument with that. Let's see. We're going to do 2 more questions and then we are going to just continue on. John O'Rourke said, thinking outside the box, the defense isn't rebutting his findings, but only his education. I'm willing to admit the defense may have missed a data point in their findings. They may have, and there might be a quibble with the data points. If the defense continues to argue a collision never happened, I don't know if it will matter, but it might very well. And the data point between when the car is making the 3-point turn makes sense to me. That explanation made sense. But we haven't gotten to the accident reconstructionist yet. And I think we'll see more fighting over the data with the accident reconstructionist. Really do. So let's see. Tracking Cat said, it took me 5 years to get my degree because of my health. I was hospitalized and never gave up. Where there's a will, there's a way. I agree. I wasn't hospitalized. It still took me 5 years to get my degree. Well, I had all the injuries. Wasn't hospitalized for very long, but yeah, injured, transferred, all the things. And in law school, had surgery before the bar. Yeah. It's hard. It's worth fighting for. I don't have any shade for anybody that takes time to go through their schooling. But you can't represent it if you're an expert in a trial. The experts opt in. You don't have to pick an expert. you don't have to choose to be an expert witness. So if the expert witness was a civilian, I would feel different about the way that they were cross-examined. But when you're an expert, this is literally what you've signed up for. So, and this was not, oh, my company did this, my company did that. It's more than that for me. So Stacy said, what do you think about the defense calling ARCA first to establish no collision right away? It might make Proctor look even worse. I don't know what they will do with ARCA. It's partly going to depend on scheduling. I think leaving ARCA at the end makes a lot of sense. I might change my mind on that depending on how the evidence comes in from the rest of the Commonwealth witnesses. So I might change my mind on that, but we'll see. Law nerds, I am looking at my weather. I am going to go. I'm going to answer Team Baker's questions about merch. And I am sorry we did not get to all the super chats. Thank you all. I've been reading them as we've been going. And at some points questioning if John Stamos is in our chat or if it's YouTube-y things. I'm going to go with yes. I'm going to go with yes. Law nerds, let me know what you think. Today was wild. A retrial should not be this wild. And it looks like tomorrow we're back into scientific testimony. Will the jury feel like information's missing? I think that they might. Law nerds, thank you for being here. Thank you for being a law nerd. Stay safe. Tune into your weather wherever you get your weather. Stay weather aware. Those of you in other states can be like, okay, I know you don't have to. I chose to live here. I know what I'm getting in for. Look, at least I have a heads up. I'm still scarred from the Northridge earthquake. I still have Northridge. It's at least I know the storm's coming and I can prepare as best I can. So that's where I'm at with that. Law nerds, thank you for downloading the app, and I will give you an update tomorrow on if we are at 100K in the app because we are so close. Thank you for being here. Thank you for being a law nerd. Take care of yourself. Trial days are long days. I'll see you back in court tomorrow. At what time? We'll see. I'm going to take a look around and I'll let you know in the app if there's a change. If not, 8:15-ish. And I'll see you tomorrow. Bye, guys. Thanks for joining me on this stream. If you don't want to miss a moment in court, you need the Law Nerd app at lawnerdapp.com. It's a free download on iOS and Android where I can keep you in the loop with everything happening in court. And, of course, when the jury has a verdict. So if you don't want to miss a moment of this trial coverage, make sure you get the Law Nerd app. Thank you for being here, and thank you for being a Law Nerd.